I don't think you all understand who I am.
Her nickname's Drunky the Bear. We know they drank from sunup to sundown.
I mean, I've always been a straight-A student. I am an outstanding mother to my son.
It's her day to pick up the kid, but
okay.
It doesn't always happen. 1 or 2 days a week, maybe she gets them.
I excel at everything.
She hasn't worked for over 2 years. I mean, she was always calling to borrow money, and but it's been like 2 years since she got a job. She keeps on telling me she's looking, and she's always finding the good opportunities and everything, but...
Welcome back in, everybody. Today is still Monday, August the 5th, and believe it or not, somebody was in the courtroom recording while Sarah Boone was in there this afternoon, and we are going to watch it here right now. Now I got it as loud as it'll go, you guys. If you have earbuds or headphones, you might want to wear them. Now that she's pro se, I wonder if they should kind of give her a little bit of leeway there with the handcuffs. I know y'all don't like her. Nobody likes her. We don't want her to have any. But, I mean, seriously. I guess because these hearings aren't that long, they just don't have time to deal with all that. But, I mean, we know in court they will. Which, by the way, I've got some updates on that. There was a hearing. The hearing for 924 has been pushed back to 926. And there's been 2 more hearings added between now and then. They're going to have one later this week, one on 8/14, before the 926 trial management conference. So it looks to me like maybe they're doing this little weekly check-in with her so they can answer any of her questions. Again, don't get mad at the judge, you guys. He's got to cross all of his T's and dot his I's on this. He is looking at... There's a lot of attorneys out there saying that this could easily be upheld with an appeal because of the way it's been handled by the judge. Before I speak, Judge, let me just say that I want you to remember that I excel at everything I do. And it was not intentional. It was not intentional. We were having a good day.
Ms. Gold, raise your right hand to be sworn, please. Please swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Ma'am, good morning. Can you please state your full name and date of birth for the record for me? I do see that we have a representative from JACS that's appearing virtually. Sir, can I get you appearance for the record as well?
Yes, Your Honor. Christian Lake with the Justice Administrative Commission.
Okay, very good. All right, we've got a couple of things that we're going to be addressing this morning. The first is the motions, Ms. Boone, that you had made reference the last time I saw you. The court has reviewed all of those motions. I've reviewed also JACS's reply, specifically their response to the motion seeking due process costs that was filed on July 30, 2024. State, have you had the opportunity to review all of Ms. Boone's motions?
Yes, Your Honor.
Okay, all right. Ma'am, I want to go through each one of them and hear from the state, from yourself, and from JACS. We're going to start first with y'all can be seated, you don't need to stand, thank you. The defendant's temporary motion for reservation of proposed costs to acquire investigator for defendant's defense and trial dated July 18, 2024, received July 29th. That request seeks to reserve any and all costs proposed to be incurred to acquire investigator. The defendant's temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense and trial dated July 18, 24, received July 29, 2024. The request is to reserve any and all costs proposed to be incurred to acquire all witnesses for trial. And then defendant's temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court dated July 18th, 2024 and received July 29, 2024. I have reviewed all of those motions. All three motions reflect to be determined or TBD with regard to the investigator, witnesses, and deponents. The total amounts are to be determined. How to calculate is unknown. As to the depositions, the date are to be determined and the amount of transcripts are unknown. Mr. Lake, I've reviewed your response. Do you have anything else to add, sir, with regard to those items, investigators, witnesses, or deponents?
Not really, Your Honor. The only thing is we can provide Ms. Boone a copy of our pro se packet that has information about, including model motions. We would be happy to send her a copy or to send your JA a copy that you could send to give to her. That might help her for purposes of future motions. But as far as these are concerned, I think our response pretty much outlines what our position was to each of those requests.
Okay, thank you, sir. If you would be so kind to send that to Ms. Barrios, we will ensure that Ms. Boone gets a copy of it. State, do you have any position with regard to those three motions that the court just identified?
No, Your Honor.
Okay. All right, ma'am. So previously, Prison Break Investigations was already appointed to be your investigator. The JAC has no objection to authorizing $5,000 in costs for Prison Break and for $500 for obtaining case-related documents and materials on your behalf. So seeing as there's no objection, even though you were asking for a reservation, I'm going to go ahead and permit that cost to be incurred. With regard to the costs for witnesses and the depositions, you are requesting, as I identified earlier, just to reserve those costs. And as I had said earlier, the motions do not identify who the witnesses are or what the deponents are. So I'm going to deny those motions with prejudice, but that means you can refile them and we can readdress them when you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your defense at trial, or for any persons that you may seek to depose. Because as of right now, I don't know who it is that you were seeking to depose based on your own motions. Do you understand the court's ruling as to those three motions? And do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
With your delegated due date of July 22nd, for all of my pretrial motions to be submitted, I have yet to receive my discovery, so I was trying to beat that deadline or at least meet it. So I don't know what I'm supposed to ask for or who I'm supposed to ask for. And again, I have yet to receive my discovery, so I don't even know who it is I need. So I understand for those. So you're telling me at a later date, once I have that information, to revise them. I'm
giving you the opportunity to refile them. Yes, ma'am.
Thank you.
With regard to the defendant's motion for reservation of proposed costs to With regard to defendant's motion for reservation of proposed costs to acquire expert witnesses for the defendant's defense and trial dated July 18th, 2024 and received July 29th, 2024. Mr. Lake, anything else to add other than what is identified in your response?
No, Your Honor, again, the issue here is, with the exception of the mental health expert that's already approved, there would need to be much more specific motions for these costs. Ms. Boone needs to include essentially what we included in our response. And again, the model motions that we will be sending to will have that information. Without specific information, neither us nor the court can make an informed decision on whether the requests are appropriate.
Okay. Ma'am, the motion fails to identify any specifics. It has to be determined for your expert witness or witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts, and it's difficult for me to identify the particular showing of need, which is what's required for the appointment of that expert. So again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts, identifying the specificity that JACS has requested in their response. So at this point in time, that motion is denied without prejudice, and you'll have the opportunity to refile it. Lastly is the defendant's motion requesting immediate relief to the defendant by appointing effective standby counsel to aid in support and preparation of a criminal case for trial dated July 18, 2024, and received July 29, 2024. The request, ma'am, that you were seeking in that motion is to provide immediate relief to defendant by appointing effective standby counsel to aid in support and preparation of her criminal case for trial. State, do you have any position with regard to Ms. Boone's request for standby counsel?
No, Your Honor, other than what's already been placed on the record in the court's order.
Okay. Mr. Lake, anything over and above what's in response?
Just briefly, Your Honor, the point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when, in the situation where a pro se defendant who is elected to represent herself decide at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is asserted to represent themselves decides at some point they do no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is consenting not to get involved until the defendant says, I no longer want to represent myself.
I know what she just heard. I can tell you what she just heard because I just heard it. She's like, oh, so when my co-counsel gets on board, then I can just pull out and go, oh, I no longer want to represent myself. But judge says,
Ma'am, the courts had the opportunity to review the case law on this issue. There is no constitutional right to standby counsel as decided by Paul versus State 152 Southern 3rd 635 at pinpoint 641 by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State 449 Southern 2nd 253 at pinpoint 258 from 1984. As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. That's Brown v. State 45 Southern 3rd 110 at pinpoint 114 through 115, Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se and with legal representation by the Florida Supreme Court in 2009 in Shepherd versus State 17 Southern 3rd 275 at 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied.
oh, sorry, Sarah.
Do you have any other questions, ma'am, as to the court's rulings this morning?
First off, I did not forfeit my right. That was your judgment. And also, I feel that I should have had some type of evidentiary hearing prior to your decision. So so I could have better explained myself and you could have had a better understanding. So by you denying my standby counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer. So I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy so you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity or if it's just something that is denied, period.
It is denied, period. With regard to an evidentiary hearing, that seems to be in the realm of a Ferretta inquiry where a criminal defendant is seeking to represent themselves. And I would inquire of that person and have an evidentiary hearing as to the rights and remedies that you were forfeiting and the pros and cons of proceeding representing yourself and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
She's been talking to somebody, you guys, an attorney. I think I know who. I think there's been some YouTube lawyers calling her, in all honesty. There's nothing wrong with YouTube lawyers. These guys are great. They know, they know a lot more than I do. But I think there's been some people calling her and helping her legally, which doesn't surprise me.
My understanding was the hearing, the Ferretta hearing, is in regards to competency as opposed to having an understanding before you take someone's rights away.
Ferretta pertains to a criminal defendant's seeking to represent themselves. Ferretta was not applicable to your situation, and that's identified in the case law citations that were provided in the 16-page order.
Yes, I understand. It was the day of that I was explaining most of all of this, and as opposed to prior, so I would know what would happen or could happen. So my understanding is one thing, and then the explanation is another. So I'm just confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So now my belief was that the evidence or the Ferretta hearing was simply competency. So the evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my rights counsel. That, in my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court to avoid any of this with me sitting in front of you present.
Ma'am, as identified in my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promised you, I've read everything in the court file. I've read every single letter, and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order.
She's like a teenager who had her cell phone taken away for acting poorly. Bad behavior, Sarah. That's why this is happening to you, honey. You've had some really bad behavior. She said, first of all, I do not forfeit my rights. And she feels she should have had more of an opportunity to explain herself. I believe that she's spoken more than most defendants have ever spoken, ever, prior to trial.
Okay. I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the attorneys. And by you reading and then also listening to the audio, you did not listen to me in any way, shape, or form form in order for me to explain myself better, so you have an exact understanding of the particulars of each letter for each attorney.
I'm not going to revisit my prior decision.
I understand. I'm just trying to make you aware that it's my opinion.
You, and like we talked about last time, ma'am, you're certainly entitled to that opinion.
I like him. I really like this judge. He's not going to put up with her BS.
My judicial assistant has been in contact with the representative from the Orange County Jail, Sergeant Donald Casey, who is on his way in order to facilitate the transfer of the USB drives from Prison Break Investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So the trial will take place on October 7th, October 14th, and the third week of October 21st. October 21st is not this division's normal trial week. However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble in order to find coverage, and that we'll be able to efficiently proceed with any evidence or testimony on that third week on October 21. Pre-trial was scheduled for September 24th at 1:30. The court typically has its regular trial case managements on that Tuesday. Due to Ms. Boone representing herself and some of the complex issues that may be involved in this case, I'm inclined to change the date of the pretrial so that we might be able to have our own pretrial separate and apart from all the other cases that may be set for that same trial period. My thought would be to move it to, rather than the Tuesday the 24th, to Tuesday the 26th at 9 a.m.
You mean the Thursday?
Yes, sir. That's Thursday.
So I wonder.
Acceptable to the state.
Ms. Boone, that would give you additional opportunity to prepare for trial as well. Are you amenable to changing that date to September 26th at 9 a.m.?
So an additional 2 days?
Correct.
You don't have anything going on, do you, Sarah?
You would still have that time to prepare regardless if we had the hearing on September 24 or September 26th. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case specifically.
Of course.
Okay, all right. So pretrial will be rescheduled till September 26th at 9 a.m. One of the issues that I wanted to address was deadlines for production of the state's exhibits and the defendant's exhibits. Now, I'm mindful, Ms. Boone, that you have not reviewed some of the documents that may have been provided. I know most recently, Ms. Cashman spent 20 hours with you alone going over questionings and reviewing some of the materials. I don't know the breadth and scope of what was reviewed you, but some of it may have been reviewed based on counsel's representations. State, I want to address with you first, because Ms. Boone hasn't reviewed the discovery yet, as to what your position is with regard to assembling or finalizing an exhibit list or your exhibits for trial.
As far as providing a list of the specific items that the state seeks entry of?
Correct. I do want it before pre-trial. So let me just kind of lay the map for what the court's thinking.
Somebody said Orlando was getting hammered with rain right now because of the hurricane. And I was just looking at why he's wearing that jacket.
The court would have the state provide a exhibit list and a witness list by X date. Ms. Boone would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided to Ms. Boone. They would be provided on a USB thumb drive that could be utilized with a laptop at the jail. And then she could view all those exhibits here in open court. And then she would be afforded the opportunity to make objections in writing to any exhibits at a later time by a certain date.
I guess one of the concerns would be that if the state identified specific items that we would seek entry of, depending on the course of the trial and the questioning, there may be other items that have already been disclosed in discovery that may necessitate being entered in, would potentially not be part of this original witness exhibit list. You know, items that were in the discovery, but if that makes sense.
That does make sense, yeah. And I understand what you're saying. And that seems to be more of a fluid situation as to what may happen at trial, right?
Sure. I don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been sent in discovery and just make a notation of every item of evidence. The idea would be to try to pare down.
That's exactly the idea. Yeah. Now, obviously, that wouldn't foreclose you if something was produced in discovery and something that would not be relevant or admissible at a certain stage of the trial, but maybe later became relevant or admissible due to something that happened or something that was said. I would not foreclose the state, nor would I foreclose Ms. Boone from attempting to move that piece of evidence into evidence for the jury to consider. But it would be almost like a civil conference where you and opposing counsel would go over what your exhibits are prior to proceeding to trial. And I think that's important to do that so that Ms. Boone has the opportunity to view those in court so that's on the record as to what she's reviewed, and then give her the opportunity to provide any objections, if any, to any of those exhibits. And again, I wouldn't foreclose you if you want to use items A, B, and C, and that's all you intend on using. I don't know what you intend on using. I don't know what evidence you have. If you only want to use and only show A, B, and C, but are saving D, E, and F for later, depending on what happens, I won't foreclose you from readdressing D, E, and F. But it's just an opportunity to address what it is you think you're going to be seeking into evidence at this time.
So essentially,
go ahead, sir.
So I think we could accommodate that if we could go around September the 1st for that, and then that would give her an opportunity to review that USB and lodge any objections, and then we could potentially address those objections and go from there.
Okay, and that would be September 1 to have the evidence viewing, for lack of a better word, or for the list to be provided?
For the list and the USB.
Yeah, we're going to make this work for an October 7th trial date, Judge. I think September 1st is probably about the right time frame to have this in-court hearing to begin lodging those objections if she has any. My next question is, are you expecting the physical evidence to be brought here into court by a CSI so that she can potentially open it? Or are we just talking about digital evidence and giving her a list of the physical items? If
there's physical evidence that's sought, I want her to have the opportunity to review it.
And we should be looking at the top of the month for September so that we can get this done.
Okay, all right. Ma'am, do you understand that what it is that I'm discussing right now so that you have the opportunity to review the evidence that the state may be seeking into evidence in your trial?
Is it my understanding that they will supply me with a USB drive and then I am to review it while in court?
No, ma'am. So it's kind of a two-step process. So anything that's digital, that's not forensics or CSI or something that's tangible, will be provided to you on a USB drive. We also will have a hearing where all of the evidence, including any digital, electronic evidence, or any tangible evidence, CSI materials, will be shown to you in court, played to you in court, so you have the opportunity to review it here as well. Anything else will also be given to you on a thumb drive for you to review at your leisure based on the hours of 8 to 4 by the laptop at the Orange County Jail. Then we will have a deadline after we have this evidence viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by the state.
So it's not a matter of any type of confidentiality. It is all done in the courtroom with everyone?
It would be in the courtroom, correct?
Are there going to be news cameras and photographers?
That's something I need to address. I do not want, because our jury pool is going to be coming from Orange County, I have concerns about the media's presence in the evidentiary viewing.
I knew he was going to say
So I may
that.
have to enter an order which would prohibit media access for the purposes of that hearing due to the nature of what is being produced and reviewed, so as to further prevent intimate details of the case being released prior to trying the case.
Makes sense.
I understand that, Judge. Ms. Boone, not to turn the page completely, but I think it's pertinent to this discussion, has indicated through some counsel that had met with her recently that she wants to talk to the state out of the jail. And I was going to discuss that at the end, but perhaps to not waste the court's time, I don't know about bringing physical evidence out to the jail, but as far as the digital evidence, which will include autopsy photographs, which will include crime scene photographs, which will include videos, perhaps a different suggestion, especially since she has an investigator from Prison Break, is that we identify those files that we intend on introducing at trial so that they can review that digital evidence on their own in the jail, and we're not publishing all the digital evidence here in open court. That should allow her the opportunity to lodge any potential objections such as duplicative or any other objections she may want to raise about autopsy photos, so on and so forth, without exposing all of the digital media to the public. As far as the physical evidence, the state doesn't have any real concerns about the media covering that. She can open those exhibits, or somebody with scissors can open those exhibits for her if there are any exhibits she wishes open in the witness box where it's concealed from the media's eyes. So those are my suggestions. And then later we can turn to her request and put on the record how we would go about going out to the jail and meeting her.
The only concern that I have with that is I don't have a record as to what it is that she reviewed.
My suggestion would be that because this is in the context of plea negotiations potentially, I would be out there, Mr. Capt would be out there, and our investigator would be out there, and we would record it, the conversation that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code. And then we can all file in writing, the state can file in writing, these are the videos that we are going to use. These are the particular photograph numbers from the crime scene and from the autopsy photographs that we're going to use. And then we can have the defendant sign off on that as well, so that it's documented as to what was told that she would be facing at trial. And either she can review it with her investigator or she can review it with us, being present, and then that way the digital evidence is now in the open.
Okay. Ms. Boone, what are your thoughts on that?
I'm a little lost. So it's an option of reviewing what the state has with my investigator and then be able to come with the objections and everything.
That is correct.
I'm unclear on having all of my evidence being in sealed bags and for me to be able to inspect them to be here in the courtroom. I don't know how the attorneys have done any of this prior, but I don't believe that it was in the courtroom. So I'm just trying to protect myself against the media. I'm not sure at this point what is even suppressible that is available on the internet. But at the same time, though, it is my understanding that I should have some right to privacy in reviewing my the evidence. So I didn't know if my investigator and I are able to collaborate prior and view and then come to court with a
I'm certainly going to give you an opportunity to meet with your investigator to address it. The question is just the method of how to do it. The state's proposal is digital. They would meet with you, identify specifically digital, what videos, what photographs they intend on utilizing, and anything that may be physical, CSI, et cetera, would be addressed here in open court.
Just so the court and the defendant understands how physical evidence viewing would operate normally, the defense attorney and or her or his investigator would come out either to the sheriff's office or OPD's evidence center, whichever agency, and they come and view it, but it's done in the presence of the state, it's done in presence of law enforcement, it's done in presence of the CSI for the chain of custody. So attorneys don't get privacy when they're reviewing the physical evidence either. So that wouldn't really be any different than if she's doing it in the witness stand or wherever we deem suitable in the courtroom.
I think that's the most appropriate way to have the opportunity, ma'am, to review the evidence. I can't release that evidence to Mr. Lane to bring to the jail for your review because of the chain of custody issues concerning some of the physical evidence. So CSI would have to be here just like an evidence viewing at the sheriff's office or elsewhere where counsel just identified. And I cannot bring you anywhere else other than here, and I can't release you to anywhere else. So I think the only solution that we have is to have the evidence viewing here with regard to any of the physical evidence.
Why is it that it cannot be transported anywhere other than here?
Because I cannot make a record anywhere else of what you saw or what was reviewed. The only opportunity for me to make that record is here in court.
What did prior attorneys do?
That was already identified by the state.
I know I'm trying to keep up with everything. What was the answer, please?
So an attorney who's doing an evidence view would come out to the law enforcement agency's evidence warehouse, for lack of a better term. And then in the presence of the state attorney, the CSI, and the lead detective, they look at the package, and if they deem any particular package worthy of opening and examining, they can do that. We can have the CSI bring a butcher paper here so that any particular item can be opened, put on fresh butcher paper, and then changed out between exhibits so that there's no contamination. And then you can examine it. If Mr. Lane or any other representative from his organization is here, he will have the opportunity to photograph those exhibits once taken out of the packages. And that's essentially how an evidence viewing is conducted.
Thank you.
You're welcome.
And again, please, would the media be involved in that?
That's a conversation that I need to see if I can exclude them from participation or viewing that proceeding. There are rights where the media has to view proceedings in court, but due to the sensitive nature of what may be being discussed or viewed, I need to see if I can prevent media access. So without doing a little bit more further dive of research in that, I don't know if I can make that call at this time.
Yes, I have not heard of a case where the evidentiary hearing has been televised. So, if you could please look into that, because I disagree with the media being involved in that.
I understand your position, and again, for the reasons that I stated earlier, I'm trying to prohibit as much as I can from dissemination to the public, especially some of the exhibits that the state may be seeking to utilize. We are going to go ahead and set the evidence hearing. The first is Sunday. September the 1st is a Sunday, and that is Labor Day. The court would be setting a hearing for Tuesday, the 3rd at 9 a.m. to have the physical examination here in court. At that time, in the USB drive or the after our viewing here in court, state is at your position to then have that meeting with Ms. Boone and her investigator and your investigator under the plea negotiations or settlement discussions auspices to review all of the digital and identify what it is specifically?
We are happy to defer to the defendant's wishes on that. And I wanted to have that discussion. It seems like we're turning that discussion. So I'll leave it in Ms. Boone's court. My indication from one of the attorneys that she had discussed things with said that she wanted to have a conversation with us. And so I'm offering that up. In the past, with female defendants at the Orange County Jail, there are classrooms, or at least one classroom there, where we could arrange to meet. It would be a big enough room for 4 or 5 of us that would need to be there. And then we can discuss that, whatever it is she wants to discuss, and it would be recorded. And again, those portions of the conversation that are about plea negotiations and the evidence and whatnot in the trial, I believe under the evidence code would not be admissible to be used against her. And I can leave it to her when she wants that to happen. We can make arrangements to try and accommodate that. It should not take us very long at this point, given the age of this case, to select and identify which digital evidence exhibits we're going to use. It's simply a matter of getting rid of duplicative and irrelevant photographs from the scene and the autopsy. And I believe the videos won't be too hard to decide which ones to use. I don't know that there's a whole lot of other digital evidence.
Okay. All right, ma'am, do you have a thought on when you would like this viewing to take place at one of the classrooms at the Orange County Jail under the concept as identified by the state?
So this meeting is separate. This is prior, before everything else.
What I would envision, to not waste anybody's time, is we can go out there and have this discussion. If there is a discussion to be had about plea offers, one of the other topics was other matters, so that's kind of ambiguous. I'm not sure what other matters are. And then also we can let her know and probably provide the court in writing a list of the digital evidence that we seek to introduce. And then that way, if she wants us to review those digital evidence items together with her in the presence of everybody, we can do that. Or we can let her, with the list of the digital evidence that we plan on introducing, review that as many times as she wants by herself and or with Mr. Lane.
I understand. So would I be leaving with the digital evidence today, or how soon may I receive that?
So the state needs to assemble that. So my thought would be to have that meeting, ma'am, on the 3rd of September. So we would have a hearing at 9 o'clock in the morning where the physical evidence would be reviewed here in the courtroom. As soon as that evidence was finalized and reviewed, the state with their investigator, yourself with your investigator, would then meet that afternoon at the Orange County Jail to address, as the state has identified or spoken about, any settlement negotiations, plea offers, and under the other category to address what the digital exhibits are. They would provide you those on a USB drive, and they would identify for them specifically what it is that they are seeking for you to review at that point in time and have the ability to review it afterwards.
We're happy to do that beforehand, and I just want clarification. By providing her the USB with all the narrowed down exhibits out of discovery, are we providing it to Mr. Lane? How are we physically?
It would have to be provided to Mr. Lane, who would then have to provide it to a member of the staff at the jail, the names of which I have from the captain at the jail as to whom, what persons are involved in the laptop process. And then once that's done, I would require Mr. Lane to identify with a filing in the court, probably in the form of an affidavit, as to when, where, and how the USB drive was received by him, and when, where, how, and to whom it was delivered. Thank you.
Your Honor, I feel uncomfortable with you supplying my evidence to the jail. So I don't know if there's a way that, I don't know if you are aware, but my jail phone calls have been released, and there's a lot of things that have been released from the jail. So I don't know, I do not feel protected by you all handing it to the jail. I know that Mr. Lane and I previously have worked on the laptop with USB drives that he has furnished himself, bringing in from the outside. So I didn't know, and I would feel more comfortable if there was a process or a procedure. I don't know who your names are from the jail. I do know the captain, whom I spoke to the other day regarding my laptop. But I would very much.
Who was that, ma'am?
I'm sorry?
Who was that?
For which?
The captain that you spoke to, who was it?
D. Giovanni.
Okay.
There's multiple sergeants involved, and I did meet the gentleman who was supposed to be here today to pick up the USB drives. So I don't feel comfortable with providing the USB drive of my evidence with things that have been leaked or released from the jail. So if there's a possibility, please, I would like for my investigator to have that and bring in with me prior.
If I understand the jail's protocol, which I read to you at our last hearing, the jail will keep custody of the USB drives and release them with the laptop as well. So I don't know how I can bypass that process that they've created.
I love how she refers to it as her evidence. It's her evidence. It's evidence against you, you moron.
Because the USB drives in the laptop, when it's checked out by you and when it's returned by you, is all going to be logged in their IMS system.
Right. It's simply a laptop. It's a very basic laptop where anyone affiliated with my case has the type of digital evidence they bring in with them from the outside. It's simply a basic laptop that we are able to utilize at the Orange County Corrections Department. That's how we have done that prior. So I don't know what it is different, and I don't know the jail protocol because no one's included me.
You were provided a copy of it through the court filing, and I read it to you at the last hearing.
Yep.
Your understanding is different than my understanding because my contacts from the jail are telling me something different.
Who? What are their names?
There's multiple sergeants.
What are their names?
I'd rather not get them involved with fear of harassment or anything from other.
Ma'am, I'm deferring to what the Orange County Jail and the captain that you identified specifically as to her memorandum to the court, which was read to you at our last hearing, which was sent a copy to you by a notice of service, and it was provided by U.S. mail. It was sent out last week.
I have yet to receive anything such as.
Don't worry, I have a copy to give to you this morning, just in case you have not received it.
Yes, the last thing I have is your order that you provided me with the implementation of your USB drive.
Okay.
Option.
All right.
So anything that you are speaking of in the meantime, I do not know, and it was served by process,
It was served by U.S. mail.
by U.S. mail?
Mhm.
Yes. I actually have 3 motions, please, if I may submit them to you.
In a moment.
Yes, in the process of, because the address that you are, I'm guessing, sending these to is incorrect.
I received your letter addressing the address issue.
That was the 2-page item that we weren't allowed to see. See, now that she's pro se, I'm thinking that anything she writes and puts up on the docket now, or they put up on the docket now, we're not going to be able to see those letters anymore. So, yeah, I was wondering what that was.
That's been remedied. So the appropriate legal mail address will be utilized. It was simply a clerical error, and that has been remedied. But regardless, I did read to you at our last hearing the protocol for the USB drive in the jail. The court is inclined to follow the Orange County Jail's protocol with regard to the USB drives. So the evidence, digital evidence that the state seeks to admit at trial will be put on a USB drive, delivered to Mr. Lane. That will be delivered to a representative from the Orange County Jail. And Mr. Lane will thereafter file a filing with the court in the form of an affidavit identifying when he received it from the state and who he gave it to, when he gave it to, and what representative of the jail he gave it to.
So it goes from the state to Mr. Lane to the jail.
For the purposes of indexing it, for the purposes of their records under the protocol, and then it will be available for your use.
So if I want to see all of my evidence digitally, I need to contact someone at the jail.
No, ma'am. The evidence that were in the 2 bankers box that Mr. Lane digitized for you is going to be provided to the jail. That's going to be provided with the laptop to you. And that's available to you from 8 a.m. to 4 p.m. every day in the protocol that I read to you at our last hearing.
Yes, and I will speak to the captain just to be aware that everyone that it is in the process, if I do not feel comfortable with any of this, and I do not feel protected either by the courts or the jail system. So for right now, I don't know if it can be postponed or if it's something that I need to write another letter to.
Oh, please don't write another letter, girl.
Everything takes longer in jail, so by me trying to get a hold of the captain nonetheless, is going to be a feat in itself. So I want you to know, if anything, that I am in the process of trying to reach out to the captain. I don't know if she'll be here today or if it'll be the contact person. So in the process, I am working on speaking to the captain because I do not feel, like I said, that I am protected in any way, shape, or form by the Orange County Corrections Department withholding money.
Again, she's always the victim, and you know the jail staff. Yeah, he's like, "Who, ma'am? Can you name them?" And she's like, "I don't want to get him in trouble." She did the same thing. She did the same thing when she was talking about the neighbor in her interview with the detective. She goes, "Well, you know, he's an illegal. I don't want to get him in trouble, but I think he's here illegally." She will throw anybody under the bus, and again, she's the victim.
Evidence in any way, shape, or form.
Okay. The court's going to follow the procedure as I outlined at the last hearing. So here's what we will do. We will, on Thursday, September the 3rd at 9 a.m., we'll have a hearing to review the physical evidence. At that time, the state will provide its exhibit list, which will be filed with the court at that time, and a copy will be given to Ms. Boone of the physical and the digital evidence they are seeking to admit. After we have the in-court examination of the physical evidence, that afternoon, there will be a meeting at the Orange County Jail between the state, its investigator, Mr. Lane, Ms. Boone, to review the digital evidence and provide a USB drive with that information.
Can caveat in that order be unless it hasn't already been done? In case we do it ahead of September.
Sure, if you want to do it before, the deadline to do it will be to September 3. But the in-court physical examination will be at September 3. So if you all want to meet in advance of that, I won't prohibit that. Just file something in the court file identifying a notice or some document so that it identifies when that meeting took place, when the evidence viewing took place. Okay, thank you very much. Ma'am, after we've had this hearing on September 3, and that being the deadline for the digital evidence and the viewing of the physical evidence, the court would then like to set a deadline for when you would provide your objections to the state's exhibits. Mindful that this will take place on September 3 and that we have pretrial set for September 26th. And if we need to have a hearing with regard to those objections, my thoughts would be to give you 2 weeks until the 17th to lodge your objections. And those would need to be provided in writing by the 17th. So that if there are objections and if we need to have a hearing on them, that hearing can be held when we have our pretrial on the 26th. That would give the state ample opportunity to prepare for any of the objections that you have.
Forgive me, and thank you for your patience, everyone. So on September 3rd, I will be viewing the digital and physical evidence here in the courtroom.
Correct.
And then later that afternoon, I would be meeting with the state and my investigator.
If they don't meet with you prior to that date. The deadline for the state's investigator, your investigator, and yourself to meet to review the digital evidence would be no later than the close of business on September 3. I've outlined for when I would like it done, but if the state wants to meet you in advance of that date, they can do so.
Yes, please. If I may ask, please, what is your name, sir?
William J.
Could you spell your last name, please?
J-A-Y. Don't get fast.
And what is your affiliation with the state?
I don't get asked that a lot.
Could you spell your last name, please?
J-A-Y. Don't get fast.
And what is your affiliation with the state?
I'm a homicide unit chief.
Yes, please. And I am okay if you would like to meet prior, so less time is consumed on the day of our meeting, supposedly on the 3rd.
I assume you have availability. Should I meet with Mr. Lane to discuss his availability so we can get out there this month?
Yes.
Then you can do that. And like I said, Mr. J, if you could follow that notice, just identifying when, that would be most appreciative. So ma'am, understanding where we are with the viewing, what is September 17th for the deadline for your objections acceptable to you?
Yes, and if I may please raise the point that I have a motion here in regards to going in the process of working on it for the laptop. I do not have my discovery as of yet, and I do not have the laptop as of yet. I do not know what hiccups may be involved. There's a lot of hiccups with the jail already. So I'm trying to figure out when and where I'll be able to view anything. So there's a great restriction also that is being put on the laptop usage from 8 to 4. I'm unable to utilize my time to the full extent. Also, I have a motion here to receive my hard copy evidence because when the laptops are in quotes, the laptop is in quotes, closed for the day at 4 p.m., I can therefore pick up using the hard copy evidence.
I haven't had the opportunity to review the motions that you're speaking of, neither has the state. We'll address them today. I don't have a problem doing that. I'm just not going to do it right this second because I haven't had the opportunity to review them yet.
Yes, and I'm just explaining myself in the meantime, please, so you're aware of what I have already thought of and am trying to ease the pain of everyone with me trying to figure out how to do everything and when and do it appropriately. But I just wanted you to know that by bringing that topic up, I have that to also be looked over.
She said, I'm explaining for the millionth time for everyone because she's trying to ease the pain for all of us, for the court. That's what she said. She won't.
9/17, if that has to be changed, am I okay to do that?
I'm trying to set deadlines now, ma'am. And that would give you 2 weeks to review the physical evidence. You'll be provided the digital evidence, it seems, in advance of that September 3rd deadline. And that may give you more than 2 weeks to review and lodge any objections.
This is just for the evidence?
Correct. This is only addressing any objections to the evidence that the state seeks to admit.
The digital discovery, is any of that included in that?
Yes.
Okay.
She's going to complain because
I'm very weary to make these type of deadlines.
Well, we're setting them today.
I understand. So the 3rd is a what day? Thursday?
Tuesday.
she's going to complain because Lane's
So the
not
17th
there.
would be 2 weeks later.
Where's
Tuesday
my
the 17th.
investigator?
And that is me coming with my objection.
That would be you filing your objections in writing with the court. And to the extent we would need to have a hearing on those objections, we would have them when the pretrial or trial case management conference is set at 9 a.m. the following Thursday, the 26th of September.
I'm sorry, what is on the 26th?
That's when we're having our pretrial or trial case management to address any last minute issues regarding trial.
Keep up, Sarah. Come on.
Forgive me. So today being August 5th, I'm supposed to expeditiously complete my case that in every way, shape, and form by September 26th in order to go to trial for October 7th.
The dates are what the dates are. September 26th is the trial case management date, and October 7th is the trial date.
So by me not even seeing my discovery yet 2 days, and only being restricted to a laptop from 8 to 4 and not having my hard copy evidence.
You have 62 days to prepare for trial,
Ooh,
not including today.
he is
And you're
not
getting your discovery today.
not going to budge.
Wow. So in over 4 years, it comes down to me representing myself in 62 days.
I'm not going to answer that question.
Am I supposed to?
What now we're addressing, ma'am, is September 17th,
Right.
the deadline, which is 2 weeks after having the physical view of any of the physical evidence. It sounds like Mr. J is going to try to meet with you pretty promptly regarding the digital evidence. So you'll have plenty of time to review that in 2 weeks at a minimum, or 2 weeks at most, rather, to lodge any objections to the physical evidence.
I understand. I just don't understand how to file objections.
I cannot answer that for you. That would be me providing you legal advice, which I'm prohibited from doing. All I can tell you is that if you have objections to any of the exhibits that the state may seek to move into evidence, you will have to lodge those objections by the close of business on September 17th. Those objections will have to be in writing. If we have to have a hearing on those objections, that hearing will be held on September 26th.
Okay, and if I may ask, are these being delegated or I'm being incorporated in this in order for me to be able to say yay or nay?
I don't know what that means. What do you mean delegated?
Are you delegating to me as you delegated everything else in regards to taking my counsel and all of your orders?
You are representing yourself for the reasons that the court identified in its 16-page order.
Did you guys hear that? She just accused him of delegating everything off to her. Let me rewind a little bit.
And then in order for me to be able to say yay or nay?
I don't know what that means. I mean delegated.
Are you delegating to me as you delegated everything else in regards to taking my counsel and all of your orders?
You are representing yourself for the reasons that the court identified in its 16-page order. It is your responsibility, as you are representing yourself and proceeding pro se, to comply with the court's orders and deadlines. So if you have objections to any of the exhibits that the state may be seeking to offer into evidence, be it digital or physical, based on your review of those, the deadline to submit those in writing would be on September 17th.
Okay, so you're making statements, so I don't have any say in it.
I've asked you what your thoughts would be as to when. You've never provided me in a disagreement with regard to that date as of yet. You've asked questions about your motions that I haven't seen yet. Your desire to have hard copies, which we addressed at the last hearing, but I'll be glad to address it again today. You have yet to tell me that that date's unacceptable for you, and if so, why?
I wouldn't necessarily say unacceptable. I'm just uncomfortable with agreeing to a date when I am pro se and have never been pro se before and do not know what I'm doing. So I just want to make sure that I do it correctly and have an understanding also if you are proposing that I go to trial within 62 days, that I know what I'm going into and what I may expect. So I didn't know if this would just be easier on everyone else, if they just delegated the date and gave me a printed copy with your order and whatever information you have. I don't know. I don't know either if you all are just proposing that because I'm incarcerated, just the dates are what you tell me. I don't know what I'm doing. I do not know what I'm doing. So I'm trying to learn as I go, which is why I'm grateful for everyone's patience. But at the same time, though, for me to accept this date and not be able to meet it, what happens when that happens, if it should happen?
I can't answer that question. Again, that would be me providing you legal advice as to what to do if something happens. I simply cannot answer that question. I'm not allowed to.
Ooh, he's tough. I like him.
Well, I'm with the court, so whatever it is that you all are trying to do in order to expedite this even more than what it's being expedited, I'm guessing I agree with September 17th.
Okay. All right. Now, ma'am, I believe that takes care of all of the deadlines with regard to the state's exhibits. Now I want to address the deadlines for any exhibits or witnesses that you may be seeking. I am mindful that you will be receiving the discovery today and that you have not had the opportunity to review some of the items that may be in the discovery. So how much time would you like to provide to the court the list of exhibits that you may be seeking to enter and the list of witnesses that you may be seeking to have testified in a defense should you choose to put one on?
Please understand that I do not have access to a normal phone. I don't have access to communicate with them on a payphone only telephone call that I do not have regular access to, and that are limited to only 15 minutes that I have to share with 62 other inmates. That is a hurdle, please, that I need you to please take into consideration in order for me to be able to try to determine my witnesses, to determine any expert witnesses. May I ask, please, does the laptop have internet access?
I'm unaware. I'm unaware if it does.
To view any documents?
I'm unaware. I can't answer the question that I don't have an answer to. I'm unaware if it has internet access.
Who is it that I need to speak to in order for this?
We may be able to inquire of the jail representative who is appearing for the hearing this morning, and if not, the captain may be able to provide that information, but I do not know if it has internet access.
May I ask your contact names from the jail?
Give us 1 second.
Please, and also, because of the court's error of sending my information that you're referencing to the incorrect address, could you please provide me a copy of that also?
What is it that you're asked? Which, the protocol, ma'am? That was what was most recently sent.
I don't know. Whatever it is, the last thing that I received from you in the court was the hand delivery of the order regarding USB.
I have a copy that Madam Clerk's already printed out of the protocol. We will have the deputy hand deliver that to you right after. What did I do? No. Oh, I sent it to Anita. That's why. Give me a second. I'll have Madam Clerk print that out for you right now, ma'am.
Thank you.
So, understanding that as of right now, you do not have hard copies. You'll be provided digital copies. And to review all this evidence, ma'am, when in time do you feel comfortable in providing the court and the state the list of your witnesses and your exhibits that you may be seeking to introduce?
So he asked her 5 minutes ago, what kind of deadline do you think you're looking at for getting us your witness list? And instead of answering the question, she says she doesn't have access to a regular phone and she has to share it with like 54 other inmates. And she thinks she should take all these hurdles into account. Now, let's see if she really gives an answer this time.
I'm going to go with to be determined because I just explained also, please, that I do not have access to a regular phone. I need to locate anyone. I need to do research. I don't know if I have internet access to anyone. I don't have a phone book. There's no way that I know how to do any of this without essentials and fundamental equipment in order for me to be able to provide you with those answers. I can't promise anything because I do not know how I will be able to do any of that at this moment. I would like please to propose your understanding of a meeting that I would like to have with the captain so I can see if I can have access to a regular phone, if I can have access to an internet. Right now I have a tablet that is used for text messaging and movies and the law library that I utilize. I don't have access to the phone. I don't have access to the internet.
You can certainly have those conversations with the jail representatives. But ma'am, we were on notice today to address those deadlines, and I cannot set a to be determined deadline at this time. I understand that there's been some delays.
She said, I think that'll be TBD. Because, well, and I mean, I understand she hasn't seen all this stuff. And I guess she's saying that they're not giving her. It sounds like she's complaining that the jail staff has not done what they were supposed to be doing. But then again, we're talking about Sarah here. So we don't really know if this isn't any of this is true. But she has said she wants to meet with the jail captain. Mm-hmm.
With regard to discovery, as I told you at the last hearing, we're moving as expeditiously as possible to get you that. And it took some time for that process to be created. That process is going to start today. Mr. Lane's here. Representative from the Orange County Jail will be here. That handoff will take place. You'll have access to that laptop with all the information today.
Oh, he is there. Okay. Lane's there, the investigator.
If the defendant's not going to make a suggestion, may state.
Sure.
My suggestion would be to give her 14 days after the point that the specific evidence identified by the state to be used at trial is provided to her. So For example, the physical evidence, which we plan on giving her the list of those physical items well in advance of September 3rd. That will just be the date that she can actually see them. But my suggestion for those physical evidence items would be September 17th, and then 14 or 15 days after whichever day we get the specific list of digital evidence items to her, would be our suggestion.
Okay. Ma'am, are you amenable to that? That would 14 days after you've had the opportunity to review the digital evidence and 14 days after you've reviewed the physical evidence to provide your exhibit lists.
That's fair.
I don't feel comfortable with any of this. I don't have the same opportunities as the state or any attorneys prior. So I feel that you all are pressuring me and forcing me into these dates which I may not be able to meet or exceed.
Can I add that obviously either side, if there's good cause for why a deadline wasn't met, if something comes up, then we're not prohibited either side from complying with the rules of discovery afterwards. But there would just need to be a cause shown at that point.
Do you understand that, ma'am?
I do.
That I'm setting these dates for now, and if either party can establish good cause why these dates should be moved.
Yes, and that is why I'm trying to make everyone aware prior to all of this to understand my circumstances by being incarcerated and not having access to a phone, not having access to the internet, and not having access to any more other, like I said, basics, fundamental basics, which is why I'm making you all aware now, so you are aware that when the time comes, should it, why for good cause, I'm stating my good causes now, if not, there are additional at that time.
Ma'am, as of right now, the court is inclined to agree with the state's suggestion that 14 days after viewing the digital evidence, which will take place no later than September 3rd, sounds like it'll take place way in advance of that, you are to provide in writing your list of exhibits that you want to attempt to move into evidence. 14 days after viewing the physical evidence on September 3rd, you are to provide in writing the list of any exhibits that may be physical that you intend to enter into evidence. Those dates can be extended for good cause that may be shown. State, would you like the opportunity to review those exhibits similar to an evidence viewing that we're having with Ms. Boone reviewing the state's exhibits? Would you like a similar opportunity to review any of her exhibits?
If the defense has any physical evidence to place in evidence, I can make those arrangements with Mr.
Okay, all right. I will set a deadline for the review of September 26th.
So everything's going to the 26th. But so what's going on between the August?
That is correct.
They still have.
I also propose a similar date of September 17th for any of the witness lists for the defense. And Mr. J, would you be in a position by the 1st of September to provide any witness lists for the state?
She should have the witness list in the discovery that's being provided. As far as the order and the list of witnesses that we're going to call at trial, we will get in that ahead of 9/3.
Okay, all right. So the deadline for the state's production of the witness list will be September 3, no later than, and September 17th for Ms. Boone. Ma'am, similar to the objections to any discovery, that'll have to be in writing as to who it is that you may be calling as a defense witness. You'll have to provide that to the court in writing by September 17th.
Yes, and if I may ask, please, what you're typing, is that for an order or for today's proceedings?
It is for an order, which you will be given a copy of. It may not be able to be hand delivered to you, ma'am, because I'm gonna have to move some stuff around based on my scratch notes here, but at a minimum, it would be mailed to the your proper address. Due to that clerical error, that will not be an issue.
Wonderful, thank you.
Okay, I think that addresses all the issues with regard to production and hearings on any objections. Anything else from the state that you believe we need to address from a scheduling concept?
We're good with the scheduling concepts. Thank you, Judge.
Thank you. Ma'am, do you have any questions with regard to the scheduling concepts or deadlines that we've addressed this morning?
Other than what I have made known to the court, I do not.
Okay. Bruce, can you see if Mr. Sergeant Casey's here? He is here.
Your Honor.
All right, very good. Sir, could you come on up, please? Madam Clerk's going to go ahead and swear you in.
Oh, I wonder if they're going to talk about her access to the laptop right here in open court so that we have it on the record. There's no issues with her getting into this laptop and getting the discovery evidence. So she can't come back and say anything later.
You can stay to the podium, sir. No, just the podium, Sergeant.
Oh, sorry.
If you could raise your right hand, Madam Clerk, and go ahead and swear you in. All right, sir, good morning. Could you state your name for the record?
Sergeant Donald Casey.
And what's your position at the Orange County Jail?
Sergeant.
And what are your duties and responsibilities, sir?
I'm over transportation, downtown port holding, BRC ports, medical security, and the juvenile assessment center.
Okay. Are you aware of the protocol that Captain DiGiovanni created with regard to Ms. Boone's use of the laptop?
I am.
Okay, all right. Have you had the opportunity to review that protocol?
I am.
Okay. Mr. Lane, can you come on up here, please, sir?
Oh, she's not have a pot to piss in. He is, y'all. He's not going to let her come back in with a bunch of whining. It's not going to be possible. Not after he's putting all this out there. Oh, poor Mr. Lane. Give that man a medal.
Sir, good morning. Could you raise your right hand? Madam Clerk's going to swear you in.
I do.
All right, sir, good morning. Could you state your name for the record for me?
Willie Lane.
And what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator.
All right, sir, last time I saw you, I had tasked you with digitizing 2 banker's boxes of information. And you said that you would endeavor to accomplish that task by today, understanding that you were out of town for your son's wedding. I hope you had a great time. Were you able to fulfill that task, sir?
Yes, sir.
Okay. How many jump drives or drives do you have?
Of the digitized information, there's one of those. This drive here is a copy of all digital discovery that I have in my possession from Ms. Boone for the court's needs if they wish to facilitate that through the, figure it'd be easier to facilitate it now through the jail than me trying to bring it in myself.
That's exactly my thought. So you've shown to me, sir, a small thumb-sized USB jump drive. That USB jump drive is the information that was contained in the 2 bankers boxes, correct? And the other jump drive that was the larger of the 2, that jump drive is any digital information that you've had previously by virtue of being the investigator.
Yes, sir.
Okay,
No.
all right. The record's going to reflect that information is going to be hand-delivered by Mr. Lane to Sergeant Casey. So Sergeant Casey, if you could please take custody of those 2 thumb drives. And I'm going to ask you, sir, to comply with the terms of the protocol, to have those added to the laptop and be available for Ms. Boone's use today once she's returned to the Orange County Jail. Do you have any questions for Mr. Casey?
No, Your Honor.
Okay, sir, thank you very much. If you can proceed with that task, I appreciate you.
Okay, and just so you guys know, this hearing, this today, even though we didn't get it till later in the day, it occurred, I want to say it was before 1 o'clock or right around that time, because it could have been its regular time, 8:30, 9 o'clock. I don't know, but there wasn't anything up on the docket until about 1 o'clock this afternoon.
Thank you. Mr. Lane, you took custody with you, sir, as well. Well, before you leave, Sergeant Casey, state, do you have any questions for him?
No, Your Honor.
All right, ma'am, do you have any questions for Sergeant Casey regarding his compliance with the protocols provided to be by the captain of the jail?
Mr. Casey, could you please make note to Captain DiGiovanni that if she has time at some point, as soon as possible, to please sit down with me for about a half an hour to go over quite a few things that I need to have resolved.
I'll look for her.
Please, in regards to the laptop.
Okay.
Thank you.
Thank you very much, sir. Mr. Lane, when we were last here, you also had 2 bankers boxes. Did you bring those back with you, sir? Okay, could you bring those back up?
Oh my God, she is something else, y'all. Could you please let him know that, let Dio Giovanni, whatever the name is, know that I would like to speak to them about internet access and the Shut up, Sarah. You're this. Now she's barking orders
I
at
do see
everybody.
it looks like the original exhibit tags are still on the top of those. Mr. Lane, did you complete and copy everything that was in both of those boxes? Okay, I'm going to have Madam Clerk take possession of what was pre-marked as A and B for the purposes of the June 28th hearing, and we'll hold those into evidence. Do you have any questions, Mr. J, for the investigator with regard to his task? All right, ma'am, do you have any questions with regard to your investigator regarding his completion of the digitization process?
And my only question is, Mr. Lane, do you know when you would be coming to meet with me at the jail?
It's going to be my intent to try to get out there at the end of the week or beginning of next week.
End of the week. Oh, what happened? What happened? It cut off. Hang on.
I don't feel comfortable signing your invoice. I think Ms. Boone would have to sign it. Okay.
Is it okay if I?
Hand it to the deputy. Deputy will have her sign it, and then you can take it. Mr. Lake, is that acceptable, sir? Counselor, you're muted.
You guys, she's going to use up that $5,000 for that investigator in no time at all, and they're going to have to come back and ask for more money. Make sure, please, Mr. Lane, please make sure you take note of every moment you spend with this wretched woman.
Yes, that would be acceptable. Yeah, if Mr. Lane, and Your Honor, in light of this, maybe it might be more appropriate for the court to go up to $10,000 for the investigator, because it sounds like he's already done a lot of work. So it might make more sense instead of having to come back later.
Will that change the original, the 5,500, or just we would increasing 5,000 to 10,000?
5,000 to 10,000, I think would make sense, Your Honor, just because it sounds like that we may, based on what's already been done, and Mr. Lane may have more to say about that, but based on what he's already done, I suspect he's probably used a large chunk of that 5,000 just doing this one task.
Are you serious?
Your Honor.
Yes, sir.
In lieu of having to come back and file another motion, is if JAC would agree to travel expenses since I'm out of county. If not, I can get that in some type of form of a writing and get it to you or to the JAC. That's
Mr. Lake?
Your Honor, we'd have no problem with the court authorizing, saying that $1,000 for travel expenses as well.
All right, fine. So we'll increase it from 5,000 to 10,000 for investigative costs, and for travel-related expenses, 500 to 1,000. Mr. Lake, are you going to need an order for the court file with regard to those?
We would, Your Honor.
Okay, could you submit that?
Yes, Your Honor.
I know what y'all are thinking. Oh, it must be nice to just have all that money thrown out. But you guys got to remember, he has to work with Sarah Boone. He has to deal with Sarah. I just don't think 11,000. Let's see, we got 10K for him, another 1,000 for his travel expenses, plus another 500 for discovery. 11K is not going to be 11.5K. It's not going to be enough for the torment that this man is going to be put through.
We will prepare the order in a minute.
All right, very good. Just send it to Ms. Barrios, who I believe you have her contact information.
Yes, Your Honor.
All right, very good. Thank you, sir. Mr. Lane, thank you so much, sir. All right. Yes, ma'am.
What is his name, please?
That's Christian Lake. He is an attorney associated with the JAC, the Judicial Administrative Commission, regarding costs for indigent defendants.
Oh, she'll be reaching out to him too.
All right, state from a scheduling perspective or the protocol, which I know I filed a notice of filing of, I'm sure you've had the opportunity to review it. Anything else we need to address from that?
We're good on scheduling, Your Honor.
Okay, thank you. Ma'am, anything else we need to address regarding scheduling or the protocol other than what you've already addressed this morning?
Will my investigator be present at anything for and with me?
I can't speak to for or anything, but based on what we discussed today, your investigator will be there for the digital review, which will take place no later than September 3rd.
Okay, yes, I would like to have some type of witness.
He will be there. He will be there. Mr. J is going to be recording the conversation as he identified previously. Now, ma'am, you made reference to some motions that you may have brought with you this morning. All right, if you could hand those to the deputy.
So they haven't had an informal meeting yet, her and Investigator Lane.
Not already done so. I printed out a copy of the July 24th, 2024 protocol regarding your use of the laptop at the jail. And I'm going to ask the courtroom deputy to please hand deliver a copy of that to you. It was mailed to you. It was read to you at the last hearing, but now you have a physical copy of it, ma'am, to the extent one was not already provided to you.
Oh, yes, I have not received this yet.
Okay.
Oh my God, look at that stack of
And then also
papers.
there was another printout that she was going to provide me with, which I believe was a memorandum for today's date.
I haven't, she being who, the captain?
No, I'm not sure her name.
Oh, Madam Clerk, no, the only thing she's printed out for you right now, ma'am, is that protocol. I'm going to be finalizing the order. And like I said, I may be able to finish it before we're done with the hearing, and I'll hand deliver it to you. If I cannot, it'll be mailed to you.
Yes, I understand. It was regards to another document, proposing the dates for today's hearing. And, I guess it was some type of notice. That's what, please, that she was going to print out to give to me, so I have that.
Okay. Mary.
I did not receive that, nor did I receive this protocol list.
That's two.
Yeah, but you were told in court last week, Sarah. I mean, come on.
It should be in the court file. All right, ma'am, let me take a moment to review your motions. Give me a moment here.
Thank you.
It was on the record. Yeah, last week they said we're going to meet August 5th. Everybody that watched it, including me, who doesn't even understand some of this legal stuff, understood it. And she's going to act like, I need a copy of it for my files. I guess you know what she's doing. She's setting up her appeal. That's exactly what she's doing. Bless his heart. She just handed him a huge stack of papers, you guys. Did y'all see how thick that was? I bet he's looking through some of this going, oh, here she goes again. Oh, I need a Diet Coke. This is getting good.
Ma'am, with regard to one of your motions, the motion for defendant's immediate address correction, as identified earlier, there was a clerical error using the general PO box as opposed to legal mail. That's been remedied. So I'm going to go ahead and grant that motion as that's already been remedied, but I don't have a problem granting your motion for the correct address for any legal mail.
So I guess what I was saying about earlier about the locked documents on the docket, now anything she sends out, since she's representing herself, is that all? We can't look at it because of the fact that she's her own attorney now. In essence, she's the defense. I don't know how that works, but that's what I was thinking. Why else would they lock it? And it's because it sounds like all it was a letter of her stating that, you know, you sent something to the wrong address. She is going to just continue to refuse to answer the court's questions when they ask her to pinpoint dates and times, because she's doing all she can just to drag this out. She's hoping to get this trial pushed back once again. So the state has till the September 3rd to get their witness list together, or I think they already have it. And then she has until September 17th to present her witness list. Her big complaint today is she wants better phone access because
Jay, if you want to approach sir to review the hand-delivered motions, it is the motions for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom. Second motion is the motion for defendant to lawfully receive, review, utilize the original hard copy discovery, parentheses, 2 boxes, -A, B, parentheses, submitted to the court by former attorney, parentheses, S, and parentheses, on June 28, 2024, for preparation of trial in her criminal case. Just review those, counselor, and just let me know when you're ready to address them.
I guess that's common for her to want.
In regards to the first motion, we need to notice the sheriff's office, who is in charge of courtroom security. So we're not able to address that today unless they're allowed. I don't know if you're able to contact person that's in charge of that today. Otherwise, we would need a separate day for that motion.
Okay.
As far as the second motion, it's completely up to the defendant. We have no standing to say anything about it. If she wants to have her documentary discovery in hard copy form, that's between whoever and whoever, but not the state of Florida.
Okay, all right, I appreciate that, sir. Ma'am, with regard to your request for discovery, or the hard copy discovery, you've advised me multiple times seeking to use a laptop. I've written correspondence from you asking for a laptop. That laptop is being provided. At the last hearing, you advised that you wanted hard copies. You've also advised me that you live in the female dormitory, you have limited to no privacy, and you have nowhere to store anything. You have a small drawer to keep personal effects, and that's it. There's nowhere, is my understanding, in communications with the captain to place this information. There's nowhere to house it. There's nowhere to store it. You do not have, by your own admission, any place to place it.
Is that your understanding now? Are you asking me?
No, those are just statements that I know that are in the court file that you've made. You've written letters requesting a laptop that's been provided to you.
I've never.
You have written letters, ma'am, specifically asking for a laptop.
Do you know what the date of that is?
Without me going through all the correspondence. But when we have our hearing on the issue of the your motion for freedom and movement, where I'll notice the sheriff, and we'll try to set that up for this week.
Yes, let's go back through all her letters and see where she pinpointed a laptop. See, she's written so many letters. She's pen written so many letters and just spewed all of her hate on paper for so long that she can't remember what she was complaining about.
So that can be done expeditiously.
Okay.
We can address that at that time. But the jail has advised me they have no place to store this information, these hard copies. You've advised me you have no privacy and nowhere to place them. So I'm not saying no, but I don't know how I can facilitate this for you. When you do not have a place to store it, the jail does not have a place to store it.
We have an entire property department for all of the inmates on the entire compound. I've been given permission also by Sergeant.
Who?
Corporal Ward, Sergeant Dunn, Sergeant DeJesus, have the understanding that I have been forced to represent myself as pro se and have temporarily given me a property bag where I can store additional case documents at my bunk. Help me understand, please, for future reference, so I know how to approach. By my statements that I have made to you, questions were not asked in order for you to come to the conclusion that you are coming to that I did not want my hard copy. I was never formally asked by you to see if I wanted my hard copy discovery. I would believe it was the court's understanding, the judge's understanding that it should automatically be allowed to give to me. My understanding and trying to explain to you also, so you have an understanding, is my limited restricted access to the laptop is from 8 to 4. I, with 62 days left in order to defend myself in preparation for trial, would like to close that laptop at 4 p.m. and then pick up the discovery hard copy in the 2 boxes that I have. I haven't spoken to the captain yet. I just now received the protocol for the laptop. I know that you had mentioned it to me the last time that we met with one another. So I'm confused how everyone is confused by me coming to the court with solutions and ideas and suggestions, but are being misinterpreted and misconstrued like my letters from my attorneys, and you're coming to the wrong conclusion.
I'm not coming to any conclusion. The process was created, and I'm just reciting what you've said to me at prior hearings, ma'am. That's all I'm doing. You've told me you have limited space. You've told me that you have no privacy, and that you have a small drawer for personal effects. This is the first time I've heard anything about you having a locker or some kind of bag or property bag that you now have access to.
And let's not forget, she also just stated a few minutes ago, this is where she keeps contradicting herself, that she doesn't trust the jail.
That wasn't addressed at our last hearing. This is the first time I'm hearing about it. So I'm not drawing any improper conclusions, as I identified for you with the process. The jail created this process. It was something that they put together. And as I told you, we worked diligently to move forward to get with the jail to have this done. There's no nefariousness here. There's no undermining. There's nothing along those lines. I want you to have this information. And as I addressed at the last hearing, I could not copy it. I can't look at it. I can't look at what's in those 2 bankers boxes. Ms. Berrios cannot. No one associated with my office can look at it. We had to use your investigator to do that. And what the jail has advised me is that they were not in a position to take both those bankers boxes because of space and potential hazards. Now, if something has changed and the captain advises me that you can have those documents, I don't have a problem with you having them. But what I've been advised, as identified in that protocol, is to how and when you can have access to the information. And unfortunately, it wasn't in physical form, it was in digital form. And that was the process that the jail created. They are aware it's 2 bankers boxes. They're aware of what the information is. Everything has been out in the open to address your concerns and how to facilitate getting this information to you. No one's withholding anything. No one's trying to hide the ball.
She don't know how to respond to that.
I was never asked anything, just like my letters to you prior to you forfeiting my right to counsel. I was never asked anything in order for you to have a better understanding.
Ma'am, I'm not going to revisit that.
I am not, you never asked me in regards to the hard copy.
Hang on. Yes.
How quickly can we have an evidentiary hearing with the captain or whomever we need?
My understanding is she's on vacation this week.
Oh.
So, which is why Sergeant Casey was here, because Captain DiGiovanni is on vacation.
See, and Sarah's going to say, oh, see, the whole world's against me. She took vacation. She took vacation on the week that I'm supposed to get discovery handed to me. Everybody's against me.
And I cannot recall off the top of my head when she's set to return. She's set to return on the 12th.
So if the document, what would be the process? Because it's marked, tagged, and in evidence. So there would need to be a motion to get it released from evidence.
I mean, I would entertain an or tennis motion to have it released from evidence. The concern, as in Mr. J, this is the first time I had the opportunity to discuss this case with you. I know I've been dealing with Mr. Capt. We had a hearing, and I'm sure you're versed on this, but let me just kind of bring you up to speed. We had a hearing in June, and at that point in time, I forfeited Ms. Boone's right to an attorney based on her conduct and alternatively a waiver. And I'm sure you've read it. Thereafter, the court endeavored to figure out how to get those 2 bankers boxes that Ms. Cashman had provided to the court at that hearing in Ms. Boone's possession. It took time for the jail to come up with a policy and a procedure for that to happen. I was advised by the captain that they could not take custody or possession of those 2 bankers boxes because of A, storage, and B, because of the hazard. Now, if the jail is in a position to revise that by virtue of Ms. Boone identifying a property bag or something that may be available for her use, I am 100% on board. If the jail says, yeah, we can facilitate and make that happen, her getting that information. I'm just traveling with what I've been provided and the protocol that was provided to me that's been filed in the court file was not inclusive of providing her hard copies.
I understand. I'm just trying to find a solution. So
Same.
If she moves Ori Tennis to release those 2 exhibits to her investigator, then perhaps he can try and get them released to her. And if he cannot, then it sounds like on the 12th, we can revisit this when the captain's back.
I think I don't know if she returns on the 12th or that's when her vacation ends. It's a Monday, so I'm assuming she'll be back, but I don't want to make any affirmative statements on that. I don't have a problem. Mr. Lane's had this discovery. I don't have a problem with him taking custody of it again. And if he's able to deliver it to the jail and they allow it to be released to Ms. Boone, I don't have a problem with that. I have no problem with it. I'm just traveling on what the jail has advised the court in the creation of this process.
So if she wants to Ori Tennis, which means oral motion, move to release those 2 exhibits, the state has no objection. And sounds like if Mr. Lane can't get them to her, we'll be able to revisit this in the near time future.
Yes.
Just so that she's advised. So I don't want to ask her, but perhaps the court can ask her that question.
Ma'am, the state has recommended a position for, in an attempt to get you these hard copies. Is that something that you would like the court to, would you like to follow with the state's suggestion and ask of that of the court orally this morning?
I'm not understanding what it is that he's trying to do. May I please propose that the hard copies go to Mr. Lane, and then once I have permission by the captain and whomever, you can release them to me?
Granted.
No objection to her motion.
Okay. Mr. Lane, thank you for staying, sir. I appreciate you. If you could come back up here, sir, and take custody of both of those banker's boxes. I will have Ms. Barrios coordinate a hearing for the 13th at 8:45. Why not? We cannot do it the 13th because it's pre-trial. You're correct. We will have a hearing on August 14th, if necessary, on Wednesday, August 14th at 1:30, if we need to address the jail's position in taking hard copies if Mr. Lane's unable to have it delivered. And Mr. Lane advised earlier when Ms. Boone had inquired of you as to when you might be able to go visit her. You said the end of this week or by next week. If when you go to visit her by the end of this week or next week, bring that with you and see if the jail would be in a position to take it. If they are, I'm going to ask you to file a similar notice, sir, that that information was provided to the jail on what date and to whom. Okay. All right. Thank you.
Your Honor?
Yes, ma'am.
What would the hearing be for on the 14th then, for the jail taking?
The hearing on the 14th, ma'am, would be if Mr. Lane is unable to have the jail take physical custody of those two boxes for your review outside of the laptop, we would have a hearing to address what, if any, protocols the jail may be able to utilize in you having those documents. It may not be necessary. We're going to go ahead and set it if we need it. If we don't need it, we will not have a hearing.
Thank you. And then so there would not be needing to be made an updated evidence control sheet right now. It has been passed to Mr. Lane.
As of right now, the court minutes are going to reflect that what was pre-marked as A and B from the June 28th hearing is being provided to Mr. Lane.
Thank you.
Okay. With regard to your reasonable freedom motion, I'm going to set that for this Friday. Is the state available at 8:45 on Friday?
No, what's that date, please?
That is the 9th, ma'am.
We're available, Your Honor.
Okay, Ms. Barrios will coordinate with a representative from the Orange County Jail to address the reasonable freedom motion. Ma'am, I'm going to hand file both of these motions with Madam Clerk, okay?
Thank you.
All right. Is there anything else we need to address this morning, State?
Not from the state.
Anything else we need to address, Boone?
Please bear with me, just please, one moment.
Uh-huh.
What was the conclusion for the sensitive issues of having the media incorporated in the courtroom?
I need to research that matter a little bit further before I can make an order that would prohibit media access.
Do you know what your deadline may be or estimated?
It'll be well before the 3rd. That deadline is set for September 3rd at 9 a.m. when we'll have that viewing. I will endeavor to get that done as quickly as possible. Ma'am, you also had asked for a list of the persons that Captain DiGiovanni had provided. The names of the persons at the jail regarding the laptop protocol is Captain Giovanni, Donald Casey, who was here this morning, Stephanie DeJesus, Sonia Robinson, Courtney Battle, and Malik Muhammad.
Thank you for that. Would you be able to provide me with a hard copy?
I will put that in the order that'll be mailed to you, ma'am.
Wonderful, thank you.
Okay.
If I may, I don't know if I'm allowed to address the state directly.
Yeah, you're representing yourself, absolutely.
How do I go about getting a copy of my phone or utilizing my phone? Is that something that can be brought to the courtroom and during the evidentiary, the physical evidence, that I might be able to utilize that?
So my understanding is there was an imaging done on your phone with software called CellRight, and that is part of the digital discovery that has been provided to you. If you are talking about the physical device being re-examined by your own expert, then you would need to find and retain your own expert to do that without giving you legal advice or suggesting that he is the person to hire. I know that defense attorneys in this area hire somebody named Richard Connor, C-O-N-N-O-R, and then that will be between you and the JAC and him, whether or not he wishes to work for you and at what rate, so on and so forth. And then that examination would be done by him, with us being present if we want to be present.
Yes, I have reviewed, I believe, 2 or 3 different thumb drives were given to me at one point, where I researched all of them extensively, also included with Mr. Lane, and it is nothing of use. It's primarily cookies and history and so forth. So that's why I don't understand who it is, the legal expert that can give me a near download of my entire phone in regards to videos and pictures and contacts. I could probably supply a witness list sooner than later if I were to have accessibility to my phone in regards to my contacts. That's why I didn't know if it would be allowed to have my phone physically here in the presence of everyone, including law enforcement, to be able to physically look at my phone and go through it and to see what I can extract myself while here in the courtroom before trying to figure out how to locate and contact an expert to download all of that to receive.
So all of that information should have been downloaded, and I'm not sure what has been provided to you, but we will be double checking that.
It has not been provided.
Yeah, your contact information, all the videos and photographs, everything on your phone should have been downloaded. And what you may have reviewed is just a PDF file called the timeline. There is additional data there, and we will make sure you have that. And then when it comes time to our digital evidence deadline, which I hope to exceed well before 9/3, we will be identifying which portions of it is of your phone, if any, that we seek to introduce at trial. So it may be texts from December 2nd, 2019, whatever it is. We will identify those pages, we will identify those files, because obviously your entire phone, however many gigabytes it is not going to just come into evidence. Because like you said, there's so much of it would be not relevant.
Yes, thank you. So you all have already had access to my phone and have researched it fully?
We're not going to talk about our work product. I'm telling you what, based on my experience from other phone examinations is, all that information should be there. And it's typically presented in 2 different fashions. One is a large PDF, typically hundreds or thousands of pages, depending on how much you use your phone every day. And then there's a separate big digital image file that is read with what's called a UFED reader. And then that is where you can go in and look at everything.
Yes, sir, thank you. I've not seen any of that.
We were going to make sure that that is taken care of.
And that, just as clarification from the court perspective, is that something that would have been provided in discovery to prior counsels?
Yes.
Okay, then ma'am, as Ms. Cashman identified, she had everything. It's already been digitized for you. And to the extent you're able to have the hard copies, it'll be provided to you. So you'll have access to all that information today when you return to the jail.
Quit arguing, Sarah.
None of it was gone over in any way, shape, or form with Ms. Cashman or any product. So this would be a milestone, an epic milestone for me to be able to finally do that. So now, if I don't have what I need or I'm looking for, how do I go about? I know you all can't come because of legal matters, but do I need to write a motion? I don't know what I need to do in order to finally get a copy near download of my phone. If it could be brought to you for physical, with the other physical.
So again, that is going to be something that requires an expert. And then if you get a defense expert, and the JAC pays for it, then we make arrangements to meet with that expert. That expert will have the opportunity to image your entire phone just as we did, and you all can work with that image. And you're going to be, if you don't already, on those thumb drives that Mr. Lane has, if you don't already have the full extraction and not just the PDF timeline of your phone, you're going to make sure that that is provided.
Okay, so that is not able to be included in the other physical
What I'm saying is there's two different ways that I see phone instructions. One is the PDF, which is what I think you're referring to as the timeline of this communication, so on and so forth. And then there is the actual ginormous file that is read with a UFED program, and all that should be provided to you. Hopefully your laptop can use it. It does take some specifications on the computer to open it. In fact, we're addressing those issues at our office with our own computers. And if it doesn't work, we will cross those bridges as we get there. And I've worked with Mr. Lane before. Just let him know. Mr. Lane knows how to find me. We will work this all out and get what you need.
Absolutely, yes. I am grateful for your information. Just to clarify, please, during the physical evidence and me viewing that here in the courtroom, am I not able to physically open my phone and search through it?
No, because it needs to be in a Faraday box where radio signals don't come and go, because anytime you turn on your phone, it changes the contents of its phone.
Thank you
You're
very
welcome.
much.
Ma'am, do you have any other questions?
Okay, so everyone is aware that I'm in the process of trying to talk to the captain. And handcuffs, okay. Your Honor?
Yes, ma'am.
I believe I am okay right now. You and I do not have a direct way of communication, and I didn't know. Another big hurdle is if the laptop has internet access, where I don't know if emailing or messaging or whatever, however it is that you and I can communicate. Other than snail mail, I mean writing you a letter. I don't know when I write a letter, how soon you receive it, because sometimes it's days or weeks that it is uploaded to the clerk's website. Do you have a general time frame of when you actually know of something? Because you already had my address correction, but I don't believe updated.
It's been updated now.
No, I mean on the clerk's website.
I can't speak to what's on the clerk's website. I know for the purposes of my records and getting information to you, that clerical error has been remedied.
Do you have any other suggestions? If I do not have internet, would my only possibility to correspond with you be via mail?
That's my understanding. And you asked when I receive things. I get it as soon as I get it from in the mailbox. So we check the mailbox every day. As soon as I get it, it doesn't go to the clerk, it goes directly to me. And I review it. As you saw with the motions that you made reference to at our last hearing, that you had 5 of them, we set those for hearing immediately. And I intend on continuing to try to do that to facilitate prompt resolution to any concerns or issues or motions that you may have.
Thank you. And if I do have internet access or I'm able to put on, if it's not already, am I able to correspond with you via email?
You cannot correspond with me directly, but you can have conversations with my judicial assistant to the extent that you do have access to internet. I'll make sure to include her email address and telephone number in the order setting the deadlines that we addressed this morning.
Oh, that poor clerk.
And for any, I'm not sure specifically which JA, but as soon as something is scheduled, could you all please make sure that I'm included in the certificate of service or portal or whatever it is I might be attached to in order to receive notices to be properly in here?
Notices have been sent, ma'am. To the extent that there was a clerical issue, that's been remedied, but you have been copied on everything that's been filed with the court, including the JAC's response, the notice of the hearing that was set for today, and the notice of the filing of the protocol. With that, I will see you all this coming Friday at 8:45 to address the motion regarding reasonable freedom in movement. State, anything else?
No, Your Honor.
All right, we'll see you all Friday. Thank you very much.
Thank you very much.
We'll return Ms. Boone to the custody of the Orange County Jail.
Oh my God.
Yes, ma'am. Thank you.
They just turned a freaking, she just turned, let's watch the hooker walk out. Smile at the cameras. She just turned a 30-minute hearing into almost 2 hours. Swear to God, she did. Swear to God. You guys, this woman is just, oh, this is going to be a long, I'm going to regret live streaming this trial. This is going to be a freaking nightmare. Y'all think it's going to be funny. Y'all think it's going to be hilarious. I don't think it is. I think she's going to get on our very last nerve. Okay, let's revisit what was all just discussed because it was a good bit. Okay, first of all, who was in the courtroom today? We had Christian Lake of the JAC. We had Sergeant Casey from the jail. We had Mr. J from the state. I guess he's the state's investigator, the DA's office investigator. And of course, Mr. Lane, who is Sarah's defense investigator, all there. They're giving her $10,000. JAC has said, well, we're going to bump it up. We're going to, instead of $5,000, we're going to give you $10,000 for your investigator. Plus, we're going to give him $1,000 towards travel expenses. Now, this is this is what they're not going to just give it to him. They're going to say, show proof that, you use this amount, obviously, but they're just saying this is what we're going to allot. And then, of course, $500 in discovery. The judge is making her refile her motions about her witnesses because even the JAC said she needs to be more specific on those motions because she said she wanted some money. Remember how I went over that in the last video? She was wanting funds towards having witnesses called. Now, a question I have here is she asking for money because she has that cell phone or because she has that jail phone where when she calls out, she has to do a collect call or she has to have a calling card or whatever, and it costs money to call out. I'm wondering if she's trying to get money for that calling card, to have a calling card to call out for witnesses. That could be it. And I guess that would make sense. She's complaining again about her discovery items. She still hasn't received everything. We knew this was going to come out today. We knew she was going to be complaining, but we also knew that she wasn't going to get her discovery until today. We figured that out pretty quickly. She wasn't going to be handed everything until this court hearing today. But of course, she's going to vent. She's like, I don't know how y'all want me to file all these motions or refile these motions if I don't have the discovery information. Now, they did go over, JAC went over and said, standby counsel is not co-counsel. However, if the defendant decided that they no longer wanted to represent themselves pro se, then the co-counsel or the standby counsel would step in to do that. However, the judge jumped on that quick and said, she's ruined enough attorneys' lives at this point. She's not going to even have standby counsel. I can't believe that. I was really thinking they were going to let her have co-counsel because obviously she's going to need it. But that's what's going to make this. Oh, this is going to be a nightmare. Okay. She made it very clear that she was not forfeiting her rights. And two things that she said that jumped out to me when she was speaking to the court. She said she feels she should have an opportunity prior to being made to go pro se. She feels like the court's doing her wrong. And she did make several comments that he's forcing her to go pro se. She kind of, it's like she keeps giving those nudges to the judge. It's like, you said this. I'm going to put this in there, because you're making me do this. I am not happy about this. Another thing she said is she is uncomfortable with meetings at the jail and having evidence there. And again, we're going to swing back around to that topic because she just contradicts herself on that. But one thing I would say, and I'm not an attorney, but one thing I would say is, Sarah, you need to take out the word uncomfortable and feelings in your vocabulary when dealing with the court. They don't care about how you feel, and they don't care about you being uncomfortable. I guess being uncomfortable is how you feel as well. So, she's going to be screaming, this is not fair on day 2 of the freaking, oh, shoot, she's going to be doing that in jury selection. Honestly, guys, I don't see, to sit here and say she's not going to be screaming that she can't get a fair trial because it's tainted, it's been all over the internet. It is pretty bad these days when you think about, people used to go into court, us in the public, we didn't know anything. We couldn't even watch the trial back then. Nowadays, even the witnesses that the investigators talked to, that's all been out there. There's been some phone calls that have been leaked. And there's a lot of stuff that's out there. It's going to be hard to find a jury pool that's not tainted. I do agree with her there. Maybe she's banking on the fact that any jury, jury selection is going to be interesting, and we're not going to be able to watch it. That's what sucks, because they're not going to show the potential jurors to us. So I just don't see how they would put it up there. But of course, if anything crazy happens, we'll see it. Court TV will be there to play it, I'm sure. Because she's already screaming, you know, how can we find anyone who's not familiar with my trial after, and this is what I'm thinking this is basically what she did say, is after I've turned this into a chit show and with all my videos and my letters. Because really, she's the one that's done that more than anybody. If she hadn't been so vocal in the letters and everything, this probably would not have gotten as much attention. But I think we saw in a previous report, it might have been something I was looking at. I think I put it up on one of my past videos. It's part of her. She's got that same kind of personality that, what's his name's got? Brooks. It's that need for attention, that need to be in the spotlight. Now, she still gets her digital items now, today, plus they're going to have that special hearing for her to have the evidence. And she tried to blame the jail staff for making it seem like the jail, you know, she wasn't comfortable viewing the physical evidence at the jail because, and then when he said, well, who is, she kind of mentioned some jail staff or something, and he was like, well, can you be more specific? Can you give me names? And she was like, well, I don't want to get him in trouble. In other words, she was lying. She was lying. Okay. She also told the judge today she doesn't know how to file an objection. Well, you might want to get on the library real quickly and get that one figured out, because you're going to need it for sure before court. What else? Oh, another thing we found out today, which I'm pretty sure she's going to be putting in writing and pretty furious about, is the fact that Captain Giovanni, who is very key in her getting a lot of this stuff and overseeing the fact that she's going to be having all of this evidence, is on vacation until August the 12th, which is next Monday. Now, Sergeant Casey's there in her place, and he's doing what he can, but I'm sure that Sarah's going to be frustrated over that, you know, the whole world's against her because they took vacation. How dare her? She made several times she stated in this hearing that she doesn't know what she's doing. Well, I don't think any of us were shocked there. They kept asking her, the judge kept asking her to give a detailed list of her witness deadline. And instead of answering, she says she doesn't have access to a regular phone. And she went over the whole process about how she only has 15 minutes on there. And then she has to use a card to pay for it, or she has to call collect. And she thinks that she should be able to also have access to the internet because it helps her find people. And she wants the judge to take into consideration all these hurdles that she has to jump over in order to get all this stuff. And he's like, ma'am, let me ask you one more time. I need you to give me a date. And she said, well, can we just put a TBD on it? And he said, no. She wants to meet with the jail captain, who, again, is out on vacation until August the 12th. So she's going to try to pin her down and tell her how she thinks it should be. That should be interesting. And then the state came in and said, look, why don't we do this? 14 days after she receives all the digital evidence, then that's when we can put the deadline for her to provide a witness list, which they came to the conclusion that let's shoot for September 3rd, that she needs to provide a witness list to the court. And, September 17th for her to provide a witness list. The state said they pretty much have theirs. It's all going to be on September the 3rd. Again, she stated when, asked again about setting a date, she says, I don't feel comfortable with any of this. She refuses to answer the questions. She just wants to drag it out. She wants them to push the trial back. She's contradicting herself, though, because she's saying that she wants the hard copies of her discovery items that they just spent all that time putting on a freaking USB drive. And she wants to argue the semantics and throw a bunch of word salad in there about not being given permission to look at all this stuff. And the judge said, look, this is not, I don't care if you get it. You should have it. If you want to have it, you can have it. But the problem is the jail doesn't have room for it. You just said yourself a few minutes ago that you weren't comfortable having items in the jail because you didn't feel like it was everything was private. But then she goes on to tell the judge that she has they have a entire property department there at the jail, and she's been given permission to store items at her bunk. Okay, Sarah. But again, we're dealing with the fact that the jail says they do not have the physical space to put all this stuff, but they are revisit this on August the 14th, if necessary, to see if they can't actually get her the physical evidence. She also gave the judge 2 motions today. She wants her handcuffs removed while in court. I think that's normal, and I'm sure they probably won't have any problem with that. The only thing is they've got to run all that through. Obviously, the jail staff, those security reasons. So that's makes sense. They're going to get them involved in that. So they'll be able to give her an answer, hopefully by August the 14th. And if there's a problem with it, they'll have a hearing to discuss what to do next, I guess. And I guess the big bomb she dropped today was that she wants a copy. She wants to be able to hold her phone and look through it and pick out all the items in there that she knows that she's done that's going to help her case. And I think what it is she's got past recordings, because she did say that in her interview. She's got past recordings. She's probably got photos of where he hit her. She's got all this stuff, I'm sure, that she wants to provide. But what this guy had to tell her over and over freaking again is, look, right now all you have is a PDF copy of the list of items. We're going to give you all these physical copies that have been printed out by digital discovery experts who went in, Cellbrite went in, and they're going to have it all pinned out for you. It's going to be all there, black and white, might even be in color, who knows. And you're going to be able to look at it and go through and see all the pictures and everything. And she still comes back and goes, well, if I can get that, I really need that. And if I needed my own expert witness to examine it, I really think that I should just be able to look at my phone. That would save everybody money. But if I could get all that information, this would be an epic milestone to receive this information in my phone. So now remember, she had no memory of recording the night that he died. So there's no telling what else she could be opening up a can of worms. They've already seen it. It's going to be in evidence. I mean, whatever else has happened in the past, I'm going to bet money that we're going to see some more recordings of how they fought back and forth, how they were with each other, that the state's going to use against her, that she recorded. And, they haven't talked about it. Did George have a cell phone? They might have some of his stuff too on there. And then lastly, the biggest joke of it all was she wants to be able to communicate with the judge directly. I don't know if she thinks she's going to get like direct chat with him, an email. She did say email. And he's like, no, ma'am, you can't communicate with me. You're now considered to be the defense attorney in the case. I can't directly, but you can talk to my clerk of courts. And we need to add the clerk of courts to our prayer list, y'all, because this is, bless her heart. She's going to need our love, and she's going to need God to look over her during this whole process. This is just beginning. We've got a month of craziness and getting prepared for this trial, all the steps they got to take. And then you're going to be looking at in next month. Wait, no, I'm sorry. We're early August. 2 months from now, we're looking at this trial going in. And it's let's hope by then she's learned some legal phrases and what she's doing better, because this is just going to be a jit joke. It's going to be horrible. Hey, Boonies.
So when I try to open one of the files, all these different icons come up. So if I try to click on one, it says unavailable. So I keep trying to go to the next one, the next one, and the next one, but they're all the same format, so I can't open any of those.
Oh, Sarah, you pain in the ass.
And how many times has that happened?
The one time that
file, 10 files, 20 files, 50 files, or was just the one time and then you moved on to something else?
I don't know how many files were in it because I didn't bother to waste my time on trying to open. I believe I tried to open a file.
Oh, this is going to be good. Okay. So she's finally got all of her stuff on the USB drive, and she's going to complain now that she's having a hard time opening them staying open. Are we going to find out that she's technology challenged like I am? And now this is going to be an issue with the court? The docket said that today, or one of the documents in the docket said today was all about her being unhandcuffed. But then there was also talk of the discovery. So I don't know which one they're talking about today. Knowing Sarah, we're going to talk about a little bit of everything. So why even put it out there about what the plans are for the court hearing today? Because Sarah's going to touch on each and every issue and complaint that she has. Sarah gets caught in another lie, and I love it because they've got it documented, and they're going to call her out right here in front of the judge. I don't understand why they keep objecting to me. Today, we're getting a true preview of what her trial is going to look like. So, let's get to this hearing.
Madam Clerk.
Dave Capt on behalf of the state.
William J. for the state. Ma'am, good morning. Can you raise your right hand? Madam Clerk will swear you in.
Do you swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes.
All right, ma'am, good morning, rather. Can you state your full name and date of birth for the record for me?
Sarah Boone, 10/10/77.
Okay, we
had a hearing this Monday on August the 5th. The court had entered a scheduling order and notice of hearings. Ma'am, that was sent to you by way of mail. Did you receive that?
I did yesterday.
Okay, all right. I know that you had brought up concerns regarding mailing, and I just wanted to go through the historics with regard to the mailing. As you may recall, back on June 28th, we had a hearing where I granted Ms. Cushman's motion to withdraw and addressed your forfeiture, alternatively a waiver to counsel. You were hand-delivered a copy of that order. On May 25, we had a hearing and an order was entered and a notice of hearing was set. That order was hand-delivered to you. Thereafter, there was an order setting hearing that was entered on July 29. That letter, or that order rather, was sent to you at P.O. Box 9109, Seminole, Florida 33775, which is the Orange County Corrections Department mail address for general inmate mail. That was remedied the next day. On July 30th, a certificate of service was entered to the appropriate address, identifying you, your inmate number, FDC-B4, P.O. Box 4970, Orlando, Florida 32802, which is the address that you had placed in your motion and your notice. That certificate of service included the notice of filing of the memorandum from the Orange County Corrections Department, Security Operations, and there was also a certificate of service providing you the Justice Administrative Commission's response to motions seeking due process costs. The next mailings was a notice of mailing of documents by your former attorney, Patricia Cashman, which was the transcripts of depositions of detectives Chelsea Capt and Scott Lowen, which were taken on May 7th, 2024. That was e-filed on August the 1st, 2024, and mailed to you with address to you, your inmate number, FDC Dorm B, P.O. Box 4970, I apologize, P.O. Box 4970, Orlando, Florida. Did you receive those deposition transcripts?
I did.
Okay. Then the notice of delivery, would you recall when you received those transcripts?
Everything that you are stating was received on Monday.
The 5th?
Correct.
Okay. The next was a notice of delivery of digital copies of documents that was e-filed by your former attorney, Patricia Cashman, on August 1, 2024, which provided the transcripts of depositions of detectives Chelsea Capt and Scott Lowen taken May 7, 2024 to Billy Lane on August 1st. And that was mailed to you at the same address we've been addressing, P.O. Box 4970 on August 1. Did you receive that notice?
I'm sorry, what was that for?
Notice of delivery of digital copies of documents, which reflected the deposition transcripts of the detectives I just identified to Mr. Lane.
To be honest with you, I don't know. It was a lump sum of a giant amount of paperwork, and I haven't gone through it yet.
Okay.
They had me sign about 4 or 5 different documents, so.
Okay.
Were received.
And the last was a certificate of service that was just e-filed on May the 5th, which was provided to you as well on August the 5th. It was provided to you on August the 5th at the P.O. Box we've identified by way of U.S. mail, which was a copy of the order authorizing the defense to incur costs for private investigator and the scheduling order and notice of hearings entered August 5, 2024. Have you received both of those?
I did, and I had questions on that, please, whenever.
In just a moment, ma'am. So I know that there was a concern with regard to mailing and things purportedly not being timely provided to you. There was only one order, the order of July 29th, which was sent to the general mail delivery, and that was remedied the exact next day on July 30th. So that clerical error as to the wrong address was remedied one day after the original order was sent out on July the 29th. I just wanted to put that on the record and again, identify for you, ma'am, that nothing's being withheld from you and everything is being timely served to you as required. Now, you had questions about the JAC order. I will revisit those in just a moment. I've got a sticky with regard to that.
And I was going to say, please, if I may, about the address. There were 2 or 3 different documents that were uploaded to the tablet. So those 3 documents, without knowing specifically which ones they are, those were also sent to PO Box 9101.
I don't know what you're talking about.
You were talking about supposedly just one document that was mailed to the incorrect address. It was more than one.
That's not correct. Court scoured the court file this morning, ma'am. The court has not filed anything other than what I've identified since that June 28th order where you were representing yourself pro se. So that is incorrect.
Is it something that I need to record and bring back, or is it that big of a deal?
I can't answer that question. That may call for me providing you legal advice.
Okay.
But I can tell you that other than the July 29th order, which was remedied the next day, everything has been sent to the appropriate legal mail address as provided by the Orange County Jail. We've had this hearing today to address a couple of things based on the scheduling order and notice of hearing that was entered August 5. The first was the digital evidence issue. I've been advised, I think through Mr. Lane, who I do see in the courtroom. Mr. Lane, if you could come on up, sir, so Madam Clerk can swear you in.
Okay, I like how the judge is addressing her complaints up front. Just one by one. You had an issue about the mailing address. I'm going to go through this now with you, and we're going to just get all this out in the open so that if you bring it up again, I'm going to shut you down. Because you know she's going to try to bring it up in the future. I mean, this is not his first rodeo. So, mailing address correction, check, done. And I like the way that he has this calm way of just shutting her down and not sounding too hard about it. You could tell it pisses her off, which is great. We like to see that. But he's not being rude. He's not acting like he's trying to throw his power around. He's just like, no. And then when she's trying to lie to him, and then he's like, he is on top of the details in this case. And he I don't know if this is because he's dealt with somebody like her before. He is just on top of the details, and he is not going to let her play him dumb. Ain't happening, honey. Ain't happening. All right, let's see what's going on with Mr. Lane.
All right, Mr. Lane, good morning, sir. Can you state your full name and your affiliation with Prison Break Investigations, please?
Billy Lane, Chief Investigator, owner of Prison Break Investigations.
Okay. I understand part of the order from Monday was regarding the state's digital evidence. I understand that may have been provided on a USB drive to you, Mr. Lane. I want to hear from the state with regard to that first. So either Mr. J or Mr. Cacciatore.
Yes, Your Honor. We have tendered to Mr. Lane a copy of our the exhibit list with our expected items of evidence that will be received, along with expected witnesses that, to be called at the trial. A copy of that was provided on the USB with the exhibits, the witness lists, also proposed jury instructions and a stipulation as to victim ID for her review as well.
Okay. And when was that provided to Mr. Lane?
Just now.
Okay. All right. The witness and exhibit list that is included on that USB, do you have hard copies?
I do, Your Honor. I would like to file them in open court.
That was going to be my next question. Okay.
And I have a copy for defense.
Okay, very good. Debbie Bruce, if we can get the copy of the witness list and the exhibits and take that from Mr. Lane and provide it to Ms. Boone.
In Your Honor, the state's position is that given that our exhibit list contains within it a witness list as well, we would ask that that document be sealed the way the witness lists are routinely sealed. A copy of that request to seal is there with the notice of the witness list on the initial page before our notice of the exhibit list.
What I have in front of me is the notice of provision of witness list and then the notice of expected evidence and witnesses in trial. I don't have an order or.
It wouldn't be an order, it would just be that first document you read, reference, the notice of provisional witness list.
Got it. Okay, thank you. All right. Anything else with regard to the expected evidence and digital evidence?
No.
Okay, so just for my own understanding, there are 9 files on the USB drive that are digital in nature. Is that correct?
Yes.
Okay, all right. And those are all on the USB drive that is going to be provided to Ms. Boone?
Yes, they're broken down by folders.
And the folders, or the names of the folders, do they match the names in the digital evidence list?
They roughly match. I believe that on there may be some slight change of terminology from, I believe, files found on iPhone as opposed to suitcase, videos, and still shot.
Okay, all right. State, anything else to add with regard to the digital evidence?
No, I also have a copy of the thumb drive as well that Mr. Lane has had an opportunity to copy for his client that I can tender I can either send it to Mr. Lane to tender to his client.
Is that different that we've already given him?
He had an opportunity to copy it, but this would be their copy to retain.
Okay, all right. So you can go ahead and provide that. Do you want to mark that as an exhibit for the purposes of the hearing? I guess not, since it's going to be transferred directly to Mr. Lane.
Correct.
Okay, all right. You can go ahead and give that to Mr. Lane. All right. Ma'am, or Mr. Capt, any other questions? Anything else you want to bring to my attention with regard to the digital evidence?
No, yeah.
Okay. Ma'am, have you had the opportunity to review the notice of expected evidence and witnesses at trial document that was just provided to the court and yourself this morning?
I did.
Okay. Do you have any questions with regard to the digital evidence, which are paragraphs 1 through 9 on the first and second pages of the notice?
I don't know what the majority of them are. Is this part of the evidence that was supplied to me on all of the USB drives that was supplied also?
Yes, this is a pared down. All of the items referenced in our notice and provided on the USB have already been previously disclosed and given to defense.
Okay. Any other questions? Yes.
Yes, on the USB drives for the laptop, it's not compatible with the USB drives for some of the files. So I cannot open a majority of what are on both of the USB drives.
What do you mean you cannot open a majority? What can you not open?
I don't know specifically which files. I know that some of them come up as videos, some of them come up as JPEG, some of them come up as different formats. But there's an entire page of multiple icons that come up, and every time I try to open one, it won't let me review it.
Okay.
So I don't know.
What does it say?
I don't know. I moved on from that to try to go to other programs. So I don't know. I figured it would be something that I might be able to speak to Billy about when he came to see me early next week. So, but I'm just stating to the court now, that's one of the problems that I'm having with the laptop.
But you said it's a majority, but you can't identify specifics for me. And that's what I'm trying to figure out. What is it that you're not able to look at?
It doesn't identify what they are because of the amount. When I click on a particular file, there's a file inside of a file inside of a file. So when I try to open one of the files, all these different icons come up. So if I try to click on one, it says unavailable. So I keep trying to go to the next one, the next one, and the next one, but they're all the same format, so I can't open any of those.
Okay. And how many times has that happened?
The one time
One file, 10 files, 20 files, 50 files, or was it just a one time and then you moved on to something else?
I don't know how many files were in it because I didn't bother to waste my time on trying to open. I believe I tried to open about 8 or 9 of them, and then I just moved on from that folder into another folder.
And the other items in the other folder, were those accessible? Were those viewable?
For the most part, yes. I have not had a
I don't know
moment
what
to.
for the most part means.
I haven't had time yet to explore everything due to the dorm environment. So as soon as in the amount of information, the vast amount of information that he has on there, I'm trying to figure out a way where I can sit in it. I have a letter to you that I wrote to the captain, a copy for you. So you know what I'm trying to work on in order for privacy to be had. So I haven't explored both USB drives to the fullest potential that I possibly can yet. Just from the moment that I have attempted to do so, the one problem I have had was with the one folder with many icons in it. I attempted to open about 8 or 9 of them, could not, so I moved on to whatever was next.
All right. Hey.
I could add to that everything that we have provided on this USB file, we have checked. It's all on standard formats. For instance, the public surveillance video that's referenced in our notice, we included both the original Publix files from there, and then we also had those files converted to VLC because they are easier to play in VLC. So if she clicks on that folder, she can click again on a subfolder, and she will find VLC files for where the Publix video has been converted. So everything in there should be standard JPEG, VLC, and also believe an MP4 for some audio-only files.
All right. Ma'am, do you have any other questions with regard to the digital information or digital evidence identified in the notice that the state's provided to court and yourself this morning?
That was what was just handed to Mr. Lane. So, Mr. Lane, you and I would go over that when you and I meet.
I will be meeting with you tomorrow. There is a concern that I will not be able to transfer this to Ms. Boone through the jail protocol.
I have a remedy for that. With regard to, well, let me finish with the digital. Any other concerns, ma'am, as to the items identified in this notice?
Until I'm able to open them and see them, no, I do not.
Sure. Okay. State, anything else we need to talk about with regard to that issue?
Not in regards to that issue.
Okay. All right. So, Mr. Lane, I'm going to ask that you take possession of that jump drive that was tendered to you in court this morning, and you advise the court that you're going to be meeting with Ms. Boone tomorrow. Is that correct? About approximately what time are you going to be meeting with her?
9 a.m.
Okay. All right. I have had the opportunity to have further conversations with Major Muhammad at the jail, including conversations regarding the physical documents. Ma'am, are you still requesting hard copies of the documents?
I am.
Okay. The jail has advised me that they've had conversations with you related to any other property or legal documents that you may need. Have you ever advised the jail that you have everything that you need and don't need anything else?
No, one of the sergeants came and spoke to me yesterday, miscommunication of some sort, where I explained to her what I'm trying to do with purging my property and the property department so I can anticipate those discovery hard copies.
Was that Tracy Hall?
No, that was Hall. Her last name is Hall.
So it was Hall, H-A-L-L, correct?
Yes.
Okay.
But someone sent her to me to see me, so I just don't know who that was.
Who was it you communicated with yesterday regarding your personal effects that may have been in a property locker?
Miss Hall.
Okay. All right. Thank you. Do you know Miss Hall's first name?
I don't know any of the officers.
Okay. All right. So in conversations with Major Muhammad, they are going to be able to accommodate you having your paper copies. So Mr. Lane, I know that you took custody of those and have had them. So tomorrow, when you meet Ms. Boone at approximately 9 a.m., you will meet Mr. Muhammad as well. Well, let me ask this. Are you able to go to the jail today?
I can.
Okay, so I know for a fact that Major Muhammad is available today, and he may be expecting you to arrive today. If you are able to provide to him the banker's boxes that were identified as A and B and that jump drive, and then provide the court with a notice as to when and what time and that to whom you gave it should be Major Muhammad, those items, so we can file it in the court file. And those will then be, the digital evidence will then be provided with the laptop in accordance with the protocol that we've gone over previously. And Major Muhammad will make sure that Ms. Boone has access to the hard copies. So after conferring, well, let me ask this. State, do you have any other position with regard to the motion that was set to be heard today, the defendant's motion regarding seeking her hard copies?
No.
Okay, so for the record then, that motion will be granted. The motion for defendant to lawfully receive, review, utilize the original hard copy discovery, 2 boxes A and B, submitted to the court by former attorneys on June 28, 2024 for preparation of trial in her criminal case. As ordered, Mr. Lane will deliver those to the jail today and seek to have them delivered to Major Malik Muhammad, along with the digital, the USB drive with the digital evidence. Mr. Lane, the deposition transcripts of detectives Chelsea Counsel and Scott Lowen were purportedly sent to you on August 1st. Did you receive those from Ms. Cashman?
Yes.
Okay, were they a part of the 2 USB drives that we addressed on August 5? You had the smaller one, which was everything you digitized from the 2 boxes, and then you had the larger one of other materials that you had been given previously.
No, but I do have a drive that I can put them on and make sure they get to the jail today.
Okay, if you could make sure, sir, that when you drop off the other 2 things, digital copies, I know Ms. Boone has identified that she has physical copies, but I'd like to give her digital copies just in case. State, do you have any questions with regard to the court's directive to Mr. Lane regarding the hard copies, depositions of the detectives, or the digital evidence the state may seek to admit in trial?
No, Your Honor.
All right. Ma'am, do you have any questions for Mr. Lane regarding those 3 items?
No.
Okay. Give Mr.
Okay, so let's talk about Mr. Lane. He's going to be meeting with Sarah tomorrow morning, y'all, at 9 a.m. So please keep him in your thoughts and prayers, okay? Good gracious. That poor man. So he's got the USB drive that the state gave him right there in court of the exhibit list, the witness list, and the proposed jury instructions. Just happened in court. He's taken that plus the boxes A and B of the hard copies of the discovery to the jail today. Check. The state does want the witness list sealed, which I guess right now is normal. I don't know how long they keep that sealed. Sarah wants to say that the USB drive is not compatible with her laptop. I've never heard of such a thing. She obviously just doesn't know how to go in and open and open and open. I've seen the way that I know in the Waukesha files, it was like you would open one file and then there's like multiple files inside of a file. And it does take a minute to get in there and open them and see all of them. But I don't understand why she's having such a hard time. So maybe we need to get her an IT tech. Is that going to be something that's going to come up down the line? Probably is. But maybe Mr. Lane is really good with digital stuff and he can help her. And then that'll squash that. And maybe he can even, I have a question. They can call Mr. Lane up as a witness, can't they? Is that going to play against her? Anyway, she's brought up the fact that she's complaining about her dorm environment now. This has been an ongoing thing. But she did give the judge warning that she's working on another letter to him about these issues. So we will see. We will see. Let's keep going.
Mr. Lane be released?
Yes.
Okay. If you want to head up, can he be released, ma'am?
I guess I'll see you at 9.
Okay. Sir, if you could endeavor to do that today, I would greatly appreciate it.
Absolutely.
All right. Thank you very much, sir.
Thank you.
All right. The next matter this morning is the defendant's motion for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom that was hand filed with the court on August 5, 2024. Court has had the opportunity to review that motion and the law regarding restraints. State, do you have any positions at this time with regard to the defense's motion?
Your Honor, in speaking with courtroom security, we would oppose the motion, and we have Corporal Gavin Lowton available to supplement this court's knowledge on the issue.
Okay. So, ma'am, we're going to have a hearing on your motion. The state will call the corporal. He will be inquired by the state as to some concerns that they may have, and you'll be given the opportunity to ask him questions or cross-examine him after the state's concluded asking any questions. Do you have any questions about that process?
Is that today?
That will be happening right now. Yes, ma'am.
Okay,
Do you have any questions about that process?
I don't.
Okay. All right. Let's go ahead and call your witness. State.
State would call Gavin Lowton.
Please swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Sir, good morning. Can you state and spell your name for the record for me?
Gavin Alton, Gavin, LWTAN.
All right. Thank you. State, you may proceed.
Good morning, sir.
Good morning.
And what is it that you do for a living?
I work for the Orange County Sheriff's Office as a deputy sheriff.
And to what area of the sheriff's office are you assigned?
Court security.
And how long have you worked that assignment?
4 or 5 years now.
And tell us, what are some of your duties within that assignment?
I supervise the deputies in 2 felony courtrooms and 1 civil courtroom.
And are you familiar with the defendant in this particular case?
Just through research that I've done on her, I don't have any personal knowledge.
And what, in regards to that research into the defendant, what is your position as the head of security regarding her request to be free from shackles?
I do not believe she should be free of shackles.
And why is it that you have come to that conclusion?
Based on her current charge of second degree murder, she also has previous domestic arrest for battery by strangulation. She has 3 separate incidents at the jail for non-compliance, where she was told to attend her court hearings or scheduled court hearings, and she refused to do so. And then even when the corrections officers told her she could be charged with contempt of court, she still refused to attend those hearings. Those kind of, when you combine all that, to me it shows propensity for violence and not wanting to follow lawful commands and orders of law enforcement personnel.
What accommodations can be made in order to keep concealed the fact that she is shackled or restrained during trial?
So when the defendant is here, she would just be in leg restraints. She wouldn't have the belly chains. She wouldn't have handcuffs on. We've modified the leg restraints by wrapping tape around the chains. So even if she's to make motion or movement, it wouldn't make noise to alert the jury as to that she's got restraints on. She would be brought in and sat at the defense table prior to the jury coming in and being seated, so they wouldn't see her walk in with restraints on. And there's a panel in front of the defense table that prevents the jury from seeing that she's got leg restraints on.
Your Honor, I don't believe I have any further questions at this time.
Thank you. Ma'am, do you have any questions for Officer Lowton?
I do.
Go ahead.
First off, in your inputs research that you've done on me, the domestic violence case that I was charged with, the felony with strangulation, was dropped. I don't know if you were aware of that in your research. Yes, so I was never charged with that. Also, what 3 hearings is it that I supposedly missed on what dates?
I'll have to
those here.
I've never missed a court date. In the almost 5 years that I've been here, I've never argued, I've never hesitated.
Objects to the form of the question, Your Honor?
I'm going to sustain the objection. Ma'am, you have to ask one fact per question.
I am prepared to give her the date. Okay. On September 15, 2023, that was one of the times you refused to attend. October 16, 2023, and January 28, 2021.
And do you know what those were specifically for?
For court attendance, wherever you were scheduled for that day.
For a hearing or pretrial or withdrawal?
I don't know. This is just information from the jail where the corrections officer said you refused to attend your hearings.
So is that on record that I have supposedly refused these 3 dates to appear in court?
At the jail, yes.
Who is your contact, please? I've never missed a date.
This is the database that I got this information from.
Do you know when it was last updated?
I don't know.
Okay, so do you know how I have never missed a court date to the present date? I don't know specifically what these 3 dates are for. In order for me to have supposedly denied going. Do you know the name of the officers for each one? You do?
Yes.
Please.
For the September 15, 2023, it is Corrections Officer Portia Hines.
Could you spell her last name, please?
Hines.
And you said the date was 9/15/23?
Correct.
Okay.
And if you would like, I can read her comments in her report.
Sure.
At approximately midnight, I informed inmate Boone, Sarah, that she was scheduled to appear in court today. Inmate Boone stated she did not want to attend court. I advised her that her absence could result in being held in contempt of court. Inmate Boone stated she understood and continued in her decision to refuse. Corporal L. Cameron was notified. This report is being generated for informational purposes.
But it doesn't say what it was that I supposedly refused.
To attend court. It doesn't say specifically what your hearing is for.
Okay.
Second one, it'll be Officer Christy Green.
And what is this date for?
I'm sorry, what's that?
Which date is it that you're referencing?
That's going to be October 16, 2023.
Okay, and I'm sorry, the name?
Green, Greene.
And what was the first initial, please?
K.
Greene.
Yes.
10/16/23.
Yes.
Okay.
And the third one is January 28, 2021. And the officer is Jasmine Scribner. Scribner.
What are the comments, please, for Green?
At approximately 0300 hours, I advised inmate Boone, Sarah, that she was on schedule to attend downtown court. Inmate Boone stated she did not want to attend court. I informed inmate Boone that if she fails to attend, she could be held in contempt of court. Inmate Boone acknowledged she understood and continued with the decision to refuse to attend court. Corporal Ward in the Booking and Release Center, transport officer, was notified. All proper notations were made in the IMS.
Okay. And January 28?
Approximately 0334 hours, inmate Boone, Sarah, was advised she has downtown court and to start getting ready. Inmate Boone stated she did not want to attend court. I informed inmate Boone that she could be charged with contempt of court. Inmate Boone still refused to attend court. Corporal Hall and the Booking and Release Center transportation officer were notified of this incident. This report is being generated for informational purposes only.
And all of those comments were made on the day of that I supposedly refused.
I don't know when they entered that.
It doesn't state in their IMS, in their program?
It might, but I didn't take that information down.
Okay. So I'm trying to figure out how I know all 3 corporals and the sergeant. So I've never refused court. There is no reason for me to want to refuse court.
I'm going to object this to asked and answered.
I'm going to sustain the objection.
So the domestic violence, the original was dropped. I was never charged with that.
Object as to relevance, Your Honor.
Overruled. You can answer the question, Phil.
It was dropped. You were charged and arrested. I don't know why the state dropped it. It could be because both parties, based on the report that I read, did not want to cooperate. So they probably didn't have information to go forward with the charges. That does not mean that you didn't commit the act. It just meant the state felt that they didn't have a case that they could win.
What is your definition of probably did not cooperate? Was it a fact or you're just guessing?
Your Honor, I'm going to object to the question.
Objection sustained.
I'm having Daryl flashbacks.
Both of the charges were dropped for Mr. Torrez and for myself was because we did cooperate and there was not enough information. And we received documentation in the mail, both of us, for the reasons why it was dropped.
Your Honor, I'm going to object this to the form of the question. It's not a question, it's a statement.
Sustained.
Forgive me because I don't know what I'm doing. I'm trying to provide my information for what it is that I'm being accused of. I don't know if I'm doing it the wrong way, apparently. So I don't know I don't know the protocol for this. I'm just trying to answer my accusations.
I understand your position. I cannot tell you what to do. I cannot provide you any legal advice.
Okay, I'm just stating to the court that I'm doing my best with being uneducated in this situation. That is for the non-compliance, I need to speak to the corporals and the sergeant in order for that to be remedied. And then what about, do you need the documentation for the domestic charge that I was not charged with and it was dropped cooperatively?
I do know that the charges were dropped. I'm just saying that is in your history.
I understand, but I was never charged with it, correct?
You were charged with it. It was dropped. The charges were dropped.
But it is not on my record.
The rest is on your record.
But the charge for the domestic violence is not on my record.
No, you were never
Object
convicted.
to asked and answered, Your Honor.
Overruled.
You were never convicted of the domestic battery charge, but you were charged with it.
And the case was dropped.
Yes.
For the three supposed non-compliance that I have, I know that 2 of the officers are no longer with the Department of Corrections, Orange County Corrections Department. So I will need to speak to their supervisors in order for me to have, I guess, this remedied. Is it a...
Your Honor, I'm going to object to the form of the question. This is a statement question.
Objection is sustained.
I guess I will provide information to you for the non-compliance occurrences that I'm being charged with.
Your Honor, again, I'm going to object as to that's not a question, it's a statement.
The objection is sustained.
I know this is a lame question, but what does sustained mean?
That means the state's legal basis for you asking that question is correct, and the court will not permit you to ask that question
Thank you.
in the way that it may be asked.
What do I need to provide to you in order to have that remedied, in order for me to be unhandcuffed?
Your Honor, again, I'm going to object as to the form of the question.
Overruled.
Whatever documentation, but I believe that the decision as to whether or not you'll be in restraints will be made today.
I understand, but it can be made.
What's that?
The decision in order to be unhandcuffed.
Correct. I suppose if you have documentation to say that this was all fabricated, then I wouldn't be able to use this.
Correct, as you telling me about the domestic violence. That cannot be used against me either.
It is still part of your history. I can bring it up.
Right. But just to clarify and conclude, I was not ever charged with that.
Again, I'm going to object. This has to be answered.
Sustained.
Okay. I will, do I provide this information to you?
You can provide it to the state.
Okay. Am I, in your opinion, a flight risk or detrimental to the courtroom and am a threat of any type of harm?
Based on what I've researched, I don't know you personally, but based on my research, I don't think it would be appropriate for you not to be in restraint.
And then what was the year, please, for the charge that was dropped with the domestic violence?
It was 2018.
2018?
Correct.
And it is now 2024. Okay. And you're going solely off of what, the arrest affidavit? What is it that you're using to conclude due to this occurrence that was dropped that I would not be able to be unrestrained?
Correct. Your arrest history, the information I read, all the research that I've done, that's where I'm basing my conclusion on.
But what specifically from that 2018 charge?
The fact that you were charged with battery by strangulation, which is a violent act, is one of the reasons why I've said that I do not believe it's appropriate for you not to be in restraints.
But it was never proven, correct, because it was dropped?
It was dropped, doesn't mean it didn't happen.
Okay. I'll be working on the others with the corporals and the sergeant for the supposed non-compliance. Thank you for the dates and the information.
You're welcome.
Ma'am, do you have any other questions?
Do I need to supply anything for the 2018 domestic violence occurrence that you are referencing and applying?
It's already been dropped. I'm just telling you what the history is. So,
and you can still apply it even though it's not been.
Correct. It's in your history.
Okay. Thank you for the information.
You're welcome.
Any follow-ups, Dave?
No, Your Honor, it's fine.
Thank you, sir. Anything else, Dave?
Not from the state.
Okay. See Deputy Barnett here.
Okay, so she thinks that the jail just made this stuff up. She said supposed non-compliance. So the jail staff that wrote down these 3 hearings, which he had the date for, and he had the name of the jail staff who witnessed this and talked to her, and she says that it's incorrect, and she's going to have this she's going to find something. Like, it doesn't even matter. They're making the decision right now, but it doesn't even matter because she wants it on record that they're lying somehow or another. And the fact that George never, I guess, went through with the claim against her that she strangled him, even though she was arrested for it. They're going to say that she's going to say, well, I wasn't arrested for it, so it doesn't, it's not there. It didn't happen. And the guy's like, no, it did happen. So this is this guy's job. This is what he does. He is the court security. He's the sheriff's officer, deputy sheriff, who is in charge of courtroom security. So he knows when and what to look for in someone as to whether or not they're going to be a problem in the courtroom. It did surprise me that at first that the defense opposed the motion, but they didn't completely oppose the motion. What they said was she won't have handcuffs, but she will have leg restraints, which is the same thing they did to Brooks, which, I mean, honestly, that's not that big of a deal. But of course, she has to just nitpick about every little bitty thing. And the other thing too is with this thing about her not going to the jail. Her first play on it was she talked as if she should be able to choose which hearings she's required to attend. Like it's her choice, not the judge's choice. And then she kind of leans towards, or maybe that's the way he was saying it. But then she's like, it didn't happen. This record, it didn't happen. Like, what the heck, Sarah?
Did you come off, sir? Sir, good afternoon, or good morning, rather. Can you state your full name and date of birth for the record for me?
My name is Capt.
And not your date of birth. Sorry. Could you spell your date for the record?
CHADBARNETT.
And what are your duties and responsibilities here at the Orange County Courthouse?
I'm a deputy sheriff at the Orange County Courthouse. I work in courtrooms, I supervise squads, and I'm also in charge of training inside the courthouse.
Okay. Is there any training that's addressed with regard to other security measures other than shackles that may be provided for defendants?
Yes, we have an item called the stun cuff that is also used in the courtroom.
Okay, could you step us through what a stun cuff is?
A stun cuff is an electronic device that's wireless. It's a box secured to the leg. It has 50,000 volts, and it's able to be remotely sparked from a distance.
How is it fixed or placed on a person?
It's dual strapped along the calf of either leg. It can be hidden in the pants, and gives the ability to people to walk around.
And who is in charge of operating that device?
It'll be an assigned officer that's been trained in the device.
And step us through the operation of how that device is utilized or operated by that officer.
The officer will show the device to the subject or the inmate or the defendant. It will be secured with 2 straps on the leg. There is a waiver to be signed prior to being used, explaining when it would be used, if it was needed to be used during court, violence, attempt to escape, any actions that lead to that level of to use the device. It's a 2-step process, so there is no way for it to accidentally be set off. It has to be hit 2 separate buttons, so there's no accidents. If it had to be used, it would cause a shock to the location on the calf, causing a great amount of pain, causing the defendant most likely to fall to the ground, and we could securely take care of the situation after that.
Are there any other protocols or standard operating procedures regarding the use of the stun belt, other than what you've already identified?
Just to follow the response to resistance policy.
Okay, and can you explain the response to resistance policy?
We have a level of response to resistance depending on what an individual does to what we would do. So if she was attempt to escape or fight, we would use it to match that level of resistance.
What is the level of resistance whereby which the stun belt would be deployed or utilized?
At this moment, it is at a level 3.
And what is a level 3?
Level 3 would be failing to follow directions and stuff like that. If we asked her to get up and move or not, or follow the lawful order, we could use it. Most likely in the courtroom, we would use it probably at a level 4 level. That is pretty much fighting, escaping, attacking another person.
Okay, all right. State, do you have any questions to Deputy Barnett?
No, sure.
Ma'am, do you have any questions for Deputy Barnett?
I do, please.
Go ahead.
Tell me, what is the title of this?
Stun
Cuff.
cuff.
And you said this was applied on the calf or the ankle?
Yeah, the Achilles tendon area.
And is this something that does it need extensive preparation, or is it something that can just be put on coming and going from the courtroom?
We would place it on you before the court starts, and you can take it off as court every time you exit the courtroom. It takes a few moments besides signing the waiver and securing it to the leg.
And it's a one-time waiver?
Each day you will have to re-sign the waiver.
Okay, so there's no limit to how many times it can be put on and taken off, put on, taken off?
No.
And it's a very simple process to apply?
Yes.
And remove?
Yes.
Thank you.
Any follow-up?
No, I'm just saying. Why?
Sorry.
Sorry.
Would I have my hands free, correct?
Yes, you would have your hands free either way. If you were in a leg iron, your hands would be completely free. Stun cuff, same thing.
And then I would be able to walk?
You would be able to walk with the stun cuff free, yes.
So hands free and able to walk?
Yes.
Thank you.
Any other follow-up? State.
No, Your Honor.
All right. Can Mr. Barnett or Sergeant Barnett be released?
Yes.
Ma'am, can he be released?
Yes, thank you.
All right. Thank you, sir. State, any argument, any further witnesses, evidence, or testimony with regard to the defendant's shackle motion?
No, Your Honor.
Ma'am, do you have any other things that you would like to tell the court with regard to your motion?
I don't understand what Sergeant Burnett was that you all providing me an option?
There is Florida Supreme Court case law addressing reasonable measures for movement by a defendant in the courtroom.
So that is an option.
Yes.
Okay. Do I need to supply the information in regards to the supposed 3 non-compliance before that can actually be made an actual option?
I cannot answer that question because that would be me providing you legal advice as to what you could, can, or should do, and I cannot do that.
Would I be able to be unrestrained with that information?
I think that would come down to the argument of yourself and from the state as to what the court has to consider with regard to your requests and your motion and what the law is in the state of Florida.
If I may make it clear also, I'm simply just asking to be unhandcuffed so I can write and move properly. I'm not trying to maneuver the courtroom and so on and so forth. I simply just am asking to sit here being unhandcuffed so I can write without taking skin off of my wrist and being extremely uncomfortable.
Okay. Ma'am, thank you for that clarification. Because when I read your motion, you asked to be unshackled, to have freedom of movement. And I interpreted that as you wanted to move as everybody else may be able to move in this courtroom, as Mr. Capt has moved around, how other persons have moved around. And it wasn't only limited to your hands. I thought it meant to your entire person based on what it is that you were seeking in your motion. So just for the purposes of my own clarification, is your motion only seeking to have your hands not bound so that you can move your hands, but otherwise shackles that may be on your legs would continue to stay there?
Right. I don't currently have shackles, but I don't know what is in regards to trial procedure. And in regards for you not having the clarification of me just wanting to be unhandcuffed, is it my responsibility, or I don't know if you can answer this, but you don't ask questions, which is what got me in this predicament from the get-go of having no counsel, because no questions were ever asked to me. Just for the majority of my motions and letters and so on that I have supplied the court for more information to try to intervene and help, it's just gotten me into hotter water and no counsel and still restrained. So is it something that I need to specifically clarify going forward, or is it something that you have the ability to ask me questions so you have a better understanding?
Generally, I don't know that I can answer that question because it may call for me providing you legal advice. If I'm asking questions, it's because I'm trying to clarify things from my understanding. I cannot ask questions on your behalf. I cannot ask questions for you. I cannot assist you in any process, be it this hearing or at trial.
Right. Yes, I understand. I wasn't asking for assistance. I was just trying to understand by you not asking questions in regards to my motion about being unhandcuffed and unshackled simply meant just my handcuffs.
Ma'am, I reviewed your motion to be unshackled, unhandcuffed, and allowed reasonable freedom to movement and functioning accordingly, equally, and comfortably while utilizing the courtroom. All normal movement of the defendant's hands is as a whole freely, properly, successfully accomplish any task that is needed. Asking to be unshackled and unhandcuffed, the defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel by the court, which will greatly enhance the productivity and progress for the defendant and the completion of her defense in her criminal case in preparation for trial. Your wherefore clause specifically asks to be unshackled, unhandcuffed, and allowed reasonably free in movement to function equally, accordingly, and comfortably in the courtroom. I took that as you wanted to move around. You did not want to be shackled, which would be your legs as well, and you did not want to have handcuffs. If you're telling me now that all you're asking is your hands to be free, that's respectfully not what your motion says over and over and over again, as I've just read. So if you would like to clarify for me now at this time, you can as to what it is that you're asking of me.
Yes, handcuffed, I would like to have these handcuffs removed from my wrists.
Okay.
In regards to the unshackled, I know at some point I would have to maneuver, I'm guessing, in the courtroom for trial. So I didn't want to have to wait last moment to have to do another motion to be unshackled if that's what my option is, because I don't know. So I was just trying to be transparent prior so you would know what it was that I was hopefully expecting. But first,
go ahead.
It's just handcuffs means unhandcuffed. And if for trial I have to be shackled, to be unshackled.
Okay, and when you say unshackled, what do you mean by that? Just so that we're all on the same field.
Shackled, as far as my understanding is from being shackled, means that I have this along with my waist, along with my ankles. So unhandcuffed is simply for the hands and the wrists, and then unshackled would be for my ankles and for the feet.
And is that what you were seeking for trial purposes?
I didn't know if I was going to be shackled or not. So that, again, that was why I was trying to be transparent and up forward by doing so now, to make the court aware that that would be a request of mine at the time.
Okay, all right. So you would be seeking to be unshackled, no leg restraints, no arm restraints at trial, right?
Please.
Okay.
Yes.
Would you also be asking of the court to move around the courtroom when trial would take place?
I'm not sure if this is considered legal advice, but I don't know. I know from seeing other trials, the state and the defense, they maneuver the courtroom in front of the jury, so on and so forth, and they hand things back and forth. I would have to have other movement other than me sitting here. So yes, I would have very limited, reasonable movement in the courtroom for trial. Okay. Yes.
Is there anything else, ma'am, that you would like to tell me with regard to what you were seeking in your motion to be hands-free, for lack of a better word, during any hearings that we may have, and then to be hands-free, unshackled with your legs, and to have movement in the courtroom during the course of the trial? Is there anything else that you'd like to tell me about those requests?
I don't know if you've been able to see my difficulty with just simply trying to take notes. Yes, very much. I would like to be unhandcuffed, just to sit here and be in attendance of my hearings, conferences, whatever it is. For the trial, when the time comes for any limited movement that I would have, the stun cuff, I would sign the waiver now. Just whatever it is that I can do in order to enable myself to be able to have the same comfortable atmosphere and movement and equal opportunities just as everyone else.
Thank you. Anything else you'd like to tell me, ma'am?
No, Your Honor.
Okay. State any argument.
Your Honor, you've heard the Sheriff's Office's position. They're in charge of courtroom security. They presented basically their position is she should not be unshackled, but you've also heard from Deputy Barnett, who explained the options that are available to the court. Our position is if you do not allow her freedom of movement with the stun cuff, then today is probably the best day to start talking about the logistics of how we're going to do this trial so it does not create the inference that she is an inmate. Does that mean the state will be sitting at counsel table to question witnesses? How are we going to go about getting back and forth to the clerk and to the witness to present exhibits if she is not going to be able to do the same with shackles? So we just want to bring everything to the court's attention so we can get it all settled today.
I agree, which was the purpose of why we wanted to set it for today, to address all those circumstances and again, think ahead. Ma'am, do you have any closing remarks or arguments that you'd like to make to the court about your desires to be unhandcuffed, unshackled, and or utilize the stun cuff?
I believe that it is unfair that you, number one, want me to represent myself, and then number two, you would like for me to represent myself while being handcuffed, to be able to progressively and actively participate properly in the same as others with just simply being able to write notes. At some point, I'm sure I will be bringing things with me to court that I need to reach for, to open, to pass normal functions in a body as a whole, with the same equal level as anyone in the courtroom would have in order for myself to be able to do the same and function fairly and appropriately. I don't know if this is legal advice or not, but in a trial, are you able to tell me, are defendants shackled? Or is this something that I don't even need to worry about because they're not even shackled?
Typically, ma'am, the defendants have leg shackles that, as Deputy Lowton identified, they're wrapped so that they're muffled, so that they don't jingle jangle or bring any noise attention. And the privacy panels located in front of defense counsel's table would prohibit the jury from seeing those. Their hands are free, but the legs are in restraints.
Thank you. Yes, I very much would like to be unhandcuffed just to simply take notes and function normally and equally, just for hearings and so on and so forth, which we have a lot scheduled futuristically. And then when trial comes about, either way with trial and or hearings, the stun cuff, I am readily awaiting for that an option and to apply as soon as possible. Whatever it is and however it is that I need to, just to at least just have these removed.
Okay, got it. Any closing remarks, Mr. J?
No, Aaron, just address all the concerns which is the court's plan.
Got it. All right, thank you very much. I think the Florida Supreme Court has given us the guidance specifically for a case just like this in Weaver versus State, 894 Southern 2nd, 178 by the Florida Supreme Court in 2004. In that case, there was a pro se defendant who was representing themselves who had been charged with first-degree murder, and there was no prior history of violent courtroom outbursts. The defendant in that case was representing themselves, and there was some concerns as to being allowed to move around the courtroom during trial may present some safety hazards. The court identified as there would be, in our case, potential sidebars, access to witnesses, evidence, jurors, etc. And that in that case, Weaver's pro se status meant that he would be moving about the courtroom in close proximity to the judge, jurors, prosecutors, witnesses, and potential firearm evidence. This closer proximity to various trial participants arguably raises greater safety concerns than a defendant who is represented by counsel and has no legitimate reason to wander beyond the defense table. Given those circumstances in which a defendant is charged with first-degree murder who is representing himself and moving about the courtroom in close proximity to trial exhibits, especially adverse witnesses, the trial court did not abuse its discretion, even though Weaver had no prior history of violent courtroom behavior. In the Weaver case, the Florida Supreme Court found that the trial court's utilization of a stun belt was not so prejudicial when measured against the other alternative forms of restraint, and whether those alternatives are less prejudicial or viable. There was virtually no alternative to a stun gun given the visibility of other restraints and the security concerns posed by Weaver's pro se status in that case. It is clear as a matter of Florida law that a criminal defendant's right to be free of physical restraints is not absolute, and that under the circumstances in the Weaver case, the decision to employ a stun belt constitutes a rational exercise of the trial court's discretion that was reasonably necessary to ensure order and safety in the courtroom, especially in light of the defendant's pro se status. In that case, we had a firearm. It was first-degree murder. Here we have second-degree murder. The incidents identified by Officer Lotan as to non-compliance in jail for purportedly refusing to return to show up in court, and the charge itself. The charge itself has some level of concern because it is a second-degree murder, but I don't see how where we are right now is not on all fours with Weaver, especially coupled with Ms. Boone's acquiescence to utilizing the stun cuff and saying she'd sign the waiver today. She doesn't have to. You'll have to sign the waiver when we get to trial. So unless I hear anything alternatively from the state, the courts would grant the motion that she would be unhandcuffed for any hearing we have moving forward. Instead of her position in the box, we would probably have her seated at counsel's table, unless I hear an objection from the state as to that. We'll address motions first. State, any position with regard to being unshackled and B, being seated at counsel's table for any motions moving forward?
No, we defer to the court and the sheriff's office, who is in charge of security. Our concerns are just making sure that she's given a fair trial and fashioning a remedy that is a fair presentation for the jury to observe.
Okay, perfect, thank you. All right, so ma'am, The court's going to grant your motion, and then you will be unhandcuffed for every hearing moving forward. And instead of being in the jury box, you'll be seated at counsel's table. Okay? You may still have your leg restraints on, but you'll be hands-free. For the purposes of trial, in accordance with Florida Supreme Court decision in Weaver, you will be hands-free and you will not be shackled with legs. But the stun cuff, as identified by Sergeant Barnett, will be affixed to you, and you'll have to sign that waiver. Do you have any questions for me, ma'am?
For sitting here in the counsel's table, you also said that I would be shackled. I'm not shackled now. Will I be shackled then?
My understanding is that you were. If you're not, and the only thing you have is your handcuffs?
Correct.
Is that correct?
Correct.
Okay. If that's the case, then you'll be seated at counsel's table with that, as you are without your hand restraints.
Okay, so I would be unbound.
Correct.
Yes, thank you.
All right.
Okay, so I think we have the chocolate thing done, right? I mean, let's just get, here's the thing. I wanted to say this because I found this really interesting that they talked about how the stun cuffs worked. 50,000 volts. And the inmate has to sign a waiver each day they're put on. So I guess it's like right when they come into the courtroom, they put those on really quick. The inmate signs the waiver each time. And before they leave the courtroom, they take them off. I also didn't know that there was like 2 separate buttons to make them go off. So he says the level of resistance would be if the inmate tried to escape or fight, that's when they would go off. Not, like Brooke said, every time he yelled or whatever. Because, And these chocolates are on their ankles or calf ankle area down there below. And, of course, during trial, the jury would never be able to see that they're wearing anything. At the end of the day, she would be hands-free in front of the jury, and they would have no idea that she has these chocolates on. He asked her what she wanted in her motions because it was so unclear. And after a ton amount of time, she finally tells him that she only wants her handcuffs removed. But then she muddies the water again with her word salad and says to the judge, "You don't ask me any questions, which is why I'm in the predicament that I'm in," and blah, 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 blah. All in all, he finally gets out of her. She wants 0 restraints, but she's willing to sign the waiver for the chocolates in jury trial. Judge said, "Great. You'll have ankle chocolates during trial. Done deal. Check. And then during the hearings, you can be behind the table over there without handcuffs, but you'll have some leg restraints on." Sarah, it took us that long just to get to that little bitty bit.
The other item I have on, yes, sir.
I think the sheriff's office is looking for clarification, and I think I am too.
Okay.
I think the situation is because she has handcuffs on now, she doesn't have leg restraints, but for hearings, when her hands are unrestrained, her legs would be restrained.
Okay, I'm getting a thumbs up from the deputy in the back that that's the case. Is that the standard operating procedures, Deputy Logan? Okay, so ma'am, so I'll clarify my order. For the purposes of any hearings, you'll be hands-free, but you will have leg restraints.
Yes.
That's not going to affect any fairness or impartiality because it's just you and me and the state, and no jurors will see that. Yes,
Also, Judge, when she's being transported from the jail, she is going to be fully handcuffed with the belly chains and all that. We can take those off
in advance.
She gets up here.
Yeah, I agree. I understand that. Okay. I'm just worried about the fairness here in the courtroom, especially when we bring in a jury panel. Okay. And for the purposes of trial, ma'am, you'll have no leg restraints, no hand restraints, your hands free, legs free, but you will have the stun cuff affixed to your leg. As identified by Sergeant Barnett, you're going to have to sign that waiver every day, okay?
Of course. And if I may, if anyone knows, the stun cuff, does it go over clothing or does it have to
It is under your clothing, as Sergeant Barnett identified. I have a representative from the Public Defender's Office who I've asked to be here. She's going to have a conversation with you, ma'am, after our hearing, so she can facilitate clothing for you, including pants that would prohibit the jury from viewing that device on your legs.
Yes.
Okay?
Thank you.
All right. Does that clarify for you, State?
Yes, I just saw them and I thought that, I saw the confusion based on my experience and how it's done.
Okay.
We cleared it up.
Thank you. Now, ma'am, that doesn't mean that you're going to be able to wander wherever you want in the courtroom. There's going to be spots where you're going to be able to go to. You're not going to be able to walk all the way up to witnesses. You're not going to be able to walk everywhere that you want. There's going to be places that you're going to have to go to. When we get closer to trial, we'll address the box, for lack of a better word, for where you'd be able to go and not go. And I'm going to give the same limitations to the state. Okay?
I understand.
All right. Are you okay with addressing that later, Counselor?
Yeah, I mean, what I would envision is if she needs an exhibit brought to witness, I have no problem getting up and doing that for her.
I was going to, either you could do it or I was going to have the deputies do it. So, ma'am, I envision that because you're going to be able to move about freely and our jurors are not going to know that you have any restraints on you and they're not going to be able to see the stun cuff, you can conduct any questions or statements or arguments from where you would like to be in the courtroom, either at counsel's table or at the podium here for you. If you need to approach a witness or you need to provide evidence to someone, I'm going to ask you and the state to both provide that information or that document to one of the deputies, and they'll be able to approach the witness for you, okay?
Thank you.
All right. Do you have any questions about the court's ruling or the procedures for you having movement throughout the courtroom during the course of our trial?
No, I understand. And you said that it would be clarified greater once we get closer to that date. But I would like to ask, please, when the time does come for any exhibits or anything to be handed to jurors, yourself or anyone in the courtroom, is it an option for the state or a deputy, or is it specifically whoever's the closest and can do it faster?
So what I'm going to do, ma'am, is I've spoken with the sheriff's office. I'm going to endeavor to have additional security in the office or in the courtroom so that there will be a deputy for basically your disposal, be seated closer to you, so that if you have a document you want to bring to a witness's attention or ask them questions about it, you can hand it to that dedicated deputy for you, ma'am.
Yes, that is my preference, please. Thank you.
That's what I'm endeavoring to try to do for you.
Yes, thank you.
Okay. Any other questions about the ruling?
No, sir.
Okay, so your motion is granted for the reasons stated on the record.
Thank you.
State anything to clarify?
No, you're not.
Okay. All right, the last issue that I had on my list this morning was the scheduling order and notice of hearings that the court entered on August 5 required the jail to provide the every Monday at 9 a.m. commencing August 12, 2024, a representative from the Orange County Jail shall email to my judicial assistant, email provided in the order, all notebook entries from IMS from the prior week, Monday through Sunday, for every issuance of the laptop and USB device is issued to the defendant. I'm simply changing that to close of business from 9 a.m. to close of business at 5 p.m. And that order will be hand delivered to Ms. Boone and e-filed to the state today. Okay. Is there anything else, state, that we need to address?
No, Your Honor.
Okay. Ma'am, is there anything else that you'd like to bring to my attention?
Yes, please.
Yes, ma'am.
In regards to the status report, you were just speaking about regarding them providing me with a laptop each day. What is your definition of entries?
The protocol, ma'am, that was read to you, that you were given a hard copy of Monday, and was also mailed to you on, I believe, the 30th, at the appropriate P.O. box for legal mail. The protocol identifies entries that are in the information management system at the jail for when the laptop is released to you and then returned.
Okay, so it's simply just an entry by the officer stating that they gave it to me and it was returned.
I'm making that assumption. I'm just relying on what is in the protocol.
Okay, well, my concern was they're not stating what it was that I looked at for how long and
I don't know that they're going to record that information on the protocol, ma'am. It's just simply when it's checked out and returned under the protocol.
Yes, thank you for that clarification. And then also for the notice of the expected evidence and witnesses at the trial, we didn't discuss the physical evidence. And I know that that was something pending in regards to the media being.
The physical evidence, we're set to review that here in court on September 3rd at 9 o'clock in the morning. And that was identified in the order from 5th, ma'am, which you said that you got a copy of through the mail. That's in paragraph 5. The state's physical evidence will be reviewed with the state and the defendant on September 3, 2024 at 9 a.m. at courtroom 12A, Orange County Courthouse, and the address of the courthouse. So the physical evidence will be reviewed at that point in time.
Yes, Your Honor, I understand. My question though was, are you still trying to decide or research having the media?
Yes, ma'am. I've pulled the case law on it. I need to review that case law to see if an evidentiary hearing is required. I know that we have a hearing that we had set for August 14th, which was to address a couple of other issues, specifically your motion to receive the hard copy documents. We no longer need that hearing on August 14th at 1:30 because the jail has confirmed that they have space and Mr. Lane's taking care of that today. But I do want to utilize that hearing for, I still want to utilize that hearing since we've carved it out. So at that hearing, we can address the media issue based on the court's review of the case law and determine if we have to have an evidentiary hearing, we can have an evidentiary hearing at that time. And also we can utilize that as a status as to your review, ma'am, of the digital evidence and to confirm that you've had the opportunity to review it. You don't have to finalize it, but just to see where you are in reviewing that digital evidence that the state may be seeking to introduce at trial.
This is for the 14th?
That's correct, ma'am.
And what is the time, please?
1:30 in the afternoon.
Okay, and for the case law that you are researching and referencing, are we able to have a copy of it prior?
Sure. I don't see any problem. It's the Miami Herald decision. I don't know the citation off the top of my head, but I don't have a problem.
I have no problem. I'm familiar with the case.
Sure. Ma'am, what I'll do is I'm going to prepare another order. I'll be able to hand deliver you the one today, changing the Orange County Jail, providing the notebook entries from 9 a.m. to close of business. I can hand deliver that to you today. But in the order that I mail to you, ma'am, it'll provide the case law with regard to the your privacy and media concerns.
Yes, thank you.
And that will be heard on August 14th at 1:30, in addition to a status on the digital. Now, ma'am, based on the scheduling order that the court entered back on August 5, you have 14 days from today, absent of showing a good cause, to extend any deadlines to provide your objections in writing to that evidence.
Forgive me, it's objections for the evidence
The
from
digital
the state?
evidence, the digital evidence only.
Of the 2 USB drives from Mr. Lane?
Oh, no, ma'am. The USB drive that Mr. Lane's going to be providing to the jail today that has those 9 items
yes.
as identified in this notice of expected evidence that you were provided today.
14 days and I have to write objections?
That is correct. So your objections to the digital discovery will be due no later than August 23rd. And I will put this all in order for you as well, ma'am.
Thank you.
I believe that addresses all of the court's matters that were teed up for today. State, do you have anything else?
No, Your Honor.
Ma'am, is there anything else?
I do have this. I made a copy of it for you. This letter that I supplied to Captain Di Giovanni upon her return, knowing what I am requesting. I don't know if I'm able to tell you, but it is a basic laptop. I have no internet and I have no phone. I'm trying to utilize the classroom that is in our dorm. I'm trying to have access to a phone. The USB drives, how they're being handled, I feel very uncomfortable with, as I referenced to you prior. They're being taken out of the bags and then paperwork is being removed from those bags, like the protocol security paperwork that I needed to reference, and then they're resealing the bags. The other day, one of the officers took the USB drives upon herself to remove from the bags herself, and then just handed me both the USB drives. I don't know where they go. I don't know who controls them. I don't know how they're stored. And one of my requests was to keep it at my bunk in my locked drawer, along with, of course, the internet, if I could be supplied earphones and headphones for listening, and a word program just simply to be able to type motions and letters and anything that needs to be documented or recorded. It is simply a basic laptop in order for me to view my USB drives. And just as I stated earlier to you, some of the parts of the USB drives cannot be viewed, which I will discuss with Mr. Lane tomorrow when I visit with him.
Ma'am, you can give your letter to the deputy. We will file that in the court file. Part of the reason we had set the August 14th hearing on your motion for the hard copy discovery was that Captain DiGiovanni was returning on August the 12th from vacation, and we were endeavoring to have a representative from the jail or herself be here for that hearing. So in addition to a status as to your review of the digital evidence, a hearing on media request or prevent media from being at the September 3rd discovery viewing hearing will address your concerns as identified in this letter and have a representative from the jail, be it Captain DiGiovanni or someone else here to address those concerns.
Thank you. And if I may say one last thing, please, in regards to the media being a part of my discovery hearing, I am highly opposed to it.
What are you highly opposed to?
That is, I know that I have a lot of my case details that are already online. For me to be recorded inspecting and testing and photographing, I believe that is my business only, and one bit of privacy that I should be able to maintain, especially being in the courtroom doing so.
You're talking about the September 3rd evidence view, right?
For the media?
Correct.
Correct.
Okay. Again, ma'am, we're going to have that hearing on the 14th.
Thank you.
Okay. All right. Any other questions, ma'am?
No.
Okay. I will see you all on August 14th at 1:30. Oh, thank you. Ma'am, as the attorney from the Justice Administration Commission had identified, he has provided the court via email the pro se packet. I have a hard copy for you, and I'm going to have Ms. Barrios also send you a copy by way of the mail. It was already mailed. Okay, we're going to mail you a copy as well now. Today, I'm going to give this to the deputy to provide to you. This is the pro se packet that the JAC attorney made reference to on our hearing on August 5.
Yes, thank you. And then also the public defender's office, you said, would be meeting me downstairs?
They're going to be meeting you momentarily. Be that right here or downstairs, I'm not sure. We'll be meeting you to discuss that. Okay, thank you, Ms. Click. All right, any other questions, Dave?
No, Your Honor.
Any other questions, ma'am?
No, Your Honor.
All right, we'll see you on August 14th at 1:30. We'll return Ms. Boone to the Orange County Jail. Thank you.
Hi, Sarah.
Bruce.
Don't let the door kick you on the way out, Mama. Okay. Woo, lots to talk about. And now Bruiser wants to talk about it too. No, Bruiser, not now, honey. All the judge basically talked about in this last part was, you know, he had sent that. We talked about this in the last video. The jail staff has to sign in and sign out every time she's handed the laptop, which I thought was great, because the judge now knows every time she's utilizing the equipment to look at her case file. They can't do that. I guess they could do that with the paper, the physical evidence too. But then at the end, because I'm going to jump around, so bear with me. I'm getting back to this other stuff. But then at the end, she asked a dumb ass question. She's like, so I'll be able to take the items, including the laptop, to my bunk, and I can lock them in my... No, you can't take them inside the jail. Why would they would not let her take her stuff inside the jail and compromise the entire trial, the entire case. I mean, come on. Am I the only one that thinks that is absolutely an idiot question? I mean, after all that they've just been through with this evidence, all these hearings that they've talked about, the whole process, the whole judicial process to keep everything the way it is. Good God. Anyway, the judge is like, yeah, well, we'll let you file that, ma'am. We'll talk about that on later. Okay, so she's sending a letter. She has a letter, another letter. So that's probably 2 letters that we're looking for on her docket now, that she's going to be sending over to Giovanni, which is the chief. Okay, at the jail. All right, so then she says, she's like, oh, so I don't understand. You're doing a report, and are they going to be able to monitor like what I'm looking at and everything? And I wanted to say, you know what, Sarah, read your freaking documents, because it doesn't say that. It doesn't say that. The judge cleared that up really quick. No, they're just when they're handing them to you to work on. They're still on September the 3rd. They're still doing that physical evidence review, and the whole decision as to whether or not they're going to allow media in the courtroom is pending. They're going to talk about that on August the 14th, which is next Wednesday. And she brought that up again at the end, and he's like, we're going to talk about that Wednesday, ma'am. Okay? So shut the frick up. And then so they're giving her the paper documents. No, I'll tell you what. Giving her the digital evidence, the witness list, the what I say? The evidence list, and also the jury, the proposed jury instructions. She has until the 23rd of August to file any objections on this stuff. She's got 14 days. So it'll be interesting to see what she's going to come up with something. Oh, she's going to come up with something. She's going to try to rewrite the whole thing on the jury instructions and everything. It's going to be a freaking nightmare. Oh, and by the way, someone caught me in the comments. They corrected me and said that when it comes to jury selection issues in Florida, they do show that on the streams, which I always thought they didn't show jury selection. So it could be a possibility that we are there in the courtroom. We'll probably have like an angle to view just her and the prosecution and the judge, like, just like normal, but we'll be able to hear the jurors answer questions, I think is how it works. Because the jurors will be off camera and they'll be doing the back and forth with the defense and the prosecution, which will be interesting to see how. It'll be funny to see if Sarah is nasty. Not, how she's nasty in her little, it's like she's so precocious. I don't know the words. Like she just, I keep saying she digs. She gives digs. And I can't think of the proper word for it. I'll find the term eventually before this case is over, before this trial is over. I'll find the term for it. Just the way that she does it with the judge. She's done it with the prosecution. She's done it with the jail staff. She continues to make her little comments within her statements that are basically nasty little things. Sarah, at the end of the day, nobody's going to read through your BS. There's too much evidence against you. We know you're going to jail. At this point, we're just going through the motions, baby. We're just giving you your constitutional rights. All right. Before we get to this, I want to tell you guys, the first portion of the recording or the court TV is the only one that's got it that I can find. It's like 2 minutes. There's no sound. And then when the sound comes on, it's really loud. It hurts your ears. And then that calms down after a few minutes. So just deal with the first part because it gets better after that. I promise. I've kind of watched ahead a little bit. You guys, this is going to be a doozy. I've already watched part of this. And let me tell you, I was laughing so hard because they were all over her. The counsel for the jail was all over her, and it was hilarious. Hang on just a second. They had, she's already in there making excuses. She said she hasn't received the latest documents in the mail, which I kind of figured that was going to happen. And she said she was unprepared. Unprepared? Sarah. And then she said, oh, what did she say? She was just whining, but she was getting on everybody's nerves. So anyway, I think eventually she's going to break down and cry just from what I was picking up. Not today, maybe, but in trial. I really believe she eventually will because the judge is not giving her any leeway. And you guys, after I said that, I thought, oh my God, what if someone in the jury starts to feel sorry for her and she gets a sympathy vote or 2, 1 or 2 votes. That's all she needs. Sympathy votes. Let's hope not. Let's hope George gets all the sympathy votes. But anyway, let's get to this hearing. Like I said, no sound at first, okay? I'm trying to check all your comments. Oh, you waited for us? Thank you, Barbara. I only watched bits and pieces. I didn't want to ruin it.
Burden to address the factors under the case. So my intention for this afternoon is to have Ms. Boone proceed first with anything that she'd like to tell me. I will hear from the state if they have any position on the matter, and then I'll hear from you, and then the court may be in a position to make a ruling at that time. Okay? Yes, ma'am.
Have a seat back there.
Wherever you feel most comfortable.
I can just sit back there while.
Okay, thank you.
Until you're ready here.
Thank you, ma'am. All right, Ms. Boone, you can proceed, ma'am.
First and foremost, I do not know what it is that you're referring to.
When you say you do not know what I'm referring to, what do you mean?
Motions were filed by the WFTV and the Orlando Sentinel.
Yes, ma'am. So there was a motion to intervene for the limited purposes of opposing closure that was filed on August 12th by WFTV. It was sent to you by U.S. mail at the correct inmate legal mail address on August the 12th. And the Orlando Sentinel's motion to intervene and notice of joinder was filed on August 13th. And it reflects, it said the certificate of service was August 13th, and it was sent to you at the same legal mail correspondence address at the Orange County Jail. Have you received either of those motions?
I have not.
Okay, I have copies. Oh, perfect. All right. That's why I was saying it. The certificate of service reflects the 13th, but the filing information is of this morning. All right, Ms. Fugate has, I am pronouncing your name correctly, am I not? Thank you. Ms. Fugate has provided copies of those motions. So Ms. Boone, if you'd like to take a look at those, feel free to take your time to review them. And then after you've reviewed them, I may have the opportunity to answer any questions you have about them if I can, and then we can proceed.
Cases that I know are in a report that might be hard to find. I have extra copies of those if anybody would like them.
If you want to provide those to Ms. Boone as well, you can do so. Thank you. State, do you need a copy of them?
Thank you.
All right, thank you, sir.
I know I did it again, didn't I? I did it. I did it again. I was muted. Did you guys just hear what I said? This lady over here to the left. Her name is Mrs. Fugate. She's the counsel for Orlando Sentinel and the news station that sent that motion in that said they were trying to get the cameras in on the evidence hearing. Thanks for being here with me today, you guys. I appreciate it. I don't care if you watched it earlier. You're still here with me. That's what matters the most. I really wanted to watch it too. I wanted to watch the whole thing, but I made myself do some research on her case. I got in the docket and started doing some stuff, so I might talk about that later. What are we waiting for her to read this stuff that she didn't get in the mail? Come on, Denise. Hey, Deb. Good to see everybody.
We got a bunch of OGs in the chat tonight. When they start talking, I'm going to shut up. I'm reading some of the chat over here. We were having a good day. Naomi, I was having a good day too. I don't know what happened. I was having a good day. And then I had to do this live. We were having a good day. It was a good day. It was a really good day. Grounds. Oh, thank you, Miss Patty. Miss Patty's been a member for 10 months, girl. Thank you so much.
If I may say,
Yes, ma'am.
one of my topics of discussion, as you know, are the requests in regards to the laptop and internet being one of the most important. Would I have had access to that, I would have already had this and not had to sit here unprepared. I believe that is a major violation to my due process of me not having these in advance to prepare properly and to utilize the court's time and everyone else's here by me having to do this now. So I wanted to put that out to you that I am unprepared for this. I did not know that I had a statement to prepare, as everyone else did also prior to being here.
Ma'am, you were provided the case law as you had requested at our last hearing. It was mailed to you. You asked for the case law that the court was making reference to. You specifically asked for it. That was provided to you. It was mailed to you.
Case law?
Yes, ma'am.
What was the date that it was mailed?
August 9. What was provided to you on August 9 was the additional copy of the pro se packet as provided by the Justice Administrative Commission. You were provided a hard copy of that in court, along with the case law that was referenced at the August 9 hearing that the court had said that it had reviewed in anticipation of the hearing that we were having this afternoon.
I don't have that. The thing that I was provided was the notice of provision of witness list from the state, and then the JAC packet.
Those were both provided to you in court. You are correct. The balance of the things that I'm speaking about were mailed to you at the legal mail address on August 9.
Which I have yet to receive.
Okay. Ma'am, with regard to
this is the first time I'm seeing each one of these documents.
I understand that. They were filed August 12th, and unfortunately this morning, due to an issue with the e-portal,
I wouldn't have internet access anyway to receive those.
they were sent to you via U.S. mail as well.
Yesterday?
Yes. So you're not wasting the court's time. You can feel free to review those at this time.
Is this the case law you're referring to? State versus Smith?
I believe that those are the circuit court opinions that are referenced in WFTV's motion, with cite to the Miami Herald versus Lewis decision, which is the controlling law on this matter.
And these are mine to take. Thank you.
Well, he's being nicer than some would have been. They would have been like, yeah, you're going to waste our time. You're not going to waste our time with this. Get it together, Sarah. She was unprepared. Go figure. Patty said. You know what? You might be right, Bama. This moment going forward, there's no such thing as a Karen. They're now a Sarah. Well, in a few minutes, she's going to talk about how she didn't look at half the stuff that's been given to her. I don't understand how she's not looking at half the stuff. I think she said I didn't open it or something like that. And I'm thinking to myself, wait a minute, you've had it this long. I would have already gone through all of it at least at once, one good time, and then gone back and started to do my research. Hey, Barbara's been a member since 8 months. Thank you so much. I don't know how to make my captions larger. Do you guys know how to do that? Are you ready, Sarah? No, no rush or anything. Does your copy have a sticker?
I'm ready whenever the court is. There's only so much that I can do just now receiving these. I don't have any opportunity to look up any case law of my own in the meantime, so.
You can proceed, ma'am. What is it that you'd like to tell me about your concerns regarding the September 3rd evidence viewing that's been previously scheduled?
My concerns is regarding my case and the whatever is left evidence that is not already on the internet or posted anywhere on social media. And I'm wondering what the reasons for the court other than sensationalism and exploitation. The purpose would be for them to watch me look at the remaining bit of my evidence that has not been globalized. Again, my main concern is it is for exploitation purposes, which has already been greatly applied to my case in many ways globally again. And I see on a couple of, on the motion to intervene for WFTVs, my question is, why is this an important criminal proceeding? I don't. And why do they need to have it monitored? I don't understand the reasons why just for this one. I'm not asking for all of my other hearings to be closed. Simply, this is my one and only. It is my right to have some kind of privacy regarding my case. Nonetheless, it is an active case, and it's my understanding that some information is not able to be publicized due to privacy, and it's not their right to pry and exaggerate, which is the whole point of why they want to be included in this one and only most important hearing that I would say that I have on the horizon. The press doesn't have a right to press themselves into everything in regards to my active criminal case, and I feel that from this one meeting should be closed to the press so I can rightfully, lawfully do what I need to do in order to properly, rightfully, and lawfully defend myself. At this point, I feel that there's nothing even suppressible in my case that is not already on the internet and have been spread all on the internet. I'm trying to salvage whatever it is that I can possibly to have a card to play at least one in the end during my trial. I do not feel that it is right lawfully to have them included in this hearing, this one hearing, and I am asking for their admittance to be closed.
is an active, ongoing investigation and case.
Anything else, ma'am?
No, Your Honor.
State, do you have any position on Ms. Boone's closure motion?
No, Your Honor.
All right. Ms. Fugate?
What I was saying was, when I'm going to keep myself off of mute because I just can't. I can't remember to hit the mute button. What I was saying was, she actually used the word whatever, real snarkily when she was talking to the judge, like whatever's not already been shown through the media. And then she uses the word sensationalism. She must have looked that one up. She says she's being exploited. She thinks she has a right to privacy. You're an inmate. And she wants to know why we're so interested. Well, maybe, Sarah, it's because you wrote all those freaking letters for 4.5 years, one every week at least, telling the judge how he should be doing his job and then lawyers how they should be doing their jobs. And also because you have such an insane excuse or story as to what happened to George. That's why we're so interested. Thank you. And I'm done.
Thank you, Your Honor. I think Ms. Boone's argument really flips the question. It's not why the media wants to be there. What transpires in the courtrooms, even pretrial hearings, is public property, and there's a right to be there. I'm not going to go over the Lewis test because I know Your Honor knows it well, but it's a very strict standard, and it's the plaintiff's burden to meet. I haven't seen a case in Florida where a criminal case was closed on a defendant's privacy concerns. We're not talking about third-party privacy concerns or something that's not inherent in the proceeding. This is the evidence. And even with respect to the evidence and it being an active, still an active case, Florida law is clear that once discovery is provided to the defendant and accessible to the defendant, that becomes public record. That too becomes open to the public. So with respect to the first part of the analysis, I don't think the defendant has established that this hearing needs to be closed to protect her fair trial rights. Publicity isn't necessarily synonymous with prejudice. She has to show widespread, adverse, hostile publicity, and then specifically show why that publicity is going to be aggravated by access to the September 3rd hearing. The discovery in this case has been public. I'm not sure what specifically would be aggravated by access to the hearing. So I don't think she's met that first burden under Lewis. And importantly, the admissibility of evidence, Ms. Boone said she didn't think there was anything suppressible, but even if there was, courts often suppress evidence but still allow access to the hearings and the evidence themselves. That's fairly routine. That alone, just the potential admissibility, that alone is not a sufficient reason under Lewis to close a hearing. And as Your Honor is aware, there's plenty of alternatives under the second factor to protect the defendant's fair trial rights. You know, careful questioning and jury selection can protect against publicity. The courts of this circuit have had their fair share and are well familiar with high-profile cases, and they are well equipped to insulate and protect juries from even prejudicial publicity. And finally, any closure would have to be effective and broader than necessary. Again, I'm not sure why the hearing would need to be closed, but I think even Ms. Boone has indicated it would be ineffective with what's already out there. And that was a consideration under Lewis. If the information is out there, the discovery in this case has been public, there's no reason to close a hearing that's simply going to discuss things that have already been made public. I think heightened public attention only increases the need for transparency. Closure of judicial proceedings is a drastic remedy, and I don't believe the plaintiff has met her burden in this case.
Okay.
Unless you have any other questions.
I do not.
Thank you, Your Honor.
All right. Any closing remarks from you, Ms. Boone?
Yes, Your Honor. First, I'm only asking for this one hearing, which is a very important hearing. I believe that the press is simply in it for ratings and publicity.
Yep.
My evidence is active, and I'm trying to salvage the little bit of anything that I have pertaining to my evidence that is not available online, which would be in that hearing. And I also, she was speaking in regards to once discovery has been received, that is therefore public record. I just received my discovery for the first time, and I'm still reviewing most, if not all of it. And I have not had the time to go through all of it, but I literally, on the record, just received my discovery to even have an opportunity to prepare to review that. And in regards to the hostile publicity, I have letters, I have messages, I have tablet information. I have an entire folder dedicated to publicity in more than one way as being hostile, good, bad, ugly. It's publicity. This will incredibly enhance my inopportunity to have a fair trial because of the already millions of viewers that I have in my case, literally in my case. This would just contribute to it even greater. I'm not asking for all hearings to be closed. I've not had an opportunity to review my discovery, which I just received. I have an entire folder and more information and letters and evidence in regards to publicity, hostile, any type of emotion that you can come up with. I have received from Australia being the most recent. So I do not believe just because they would like to, again, in my opinion, for ratings and for publicity. It's one hearing. There also is a solution that I believe, my understanding was that this could be held at the Orange County Sheriff's Department. The question was in regards to transport, which is a possibility. It was a matter of the decision being with the court. I would like to be able to properly prepare for this. Would I have received everything prior as everyone else did? Having the internet would have helped also in regards to receiving the notice via email, as everyone else had. I'm sitting in front of you, yes, unhandcuffed, but I am unprepared for this rebuttal in regards for me to have privacy, expected privacy to a certain degree, and by law, to have this one hearing closed. And we also have an active case that is ongoing, active evidence, and there's a solution for it to be held at the Orange County Sheriff's Department as well.
Okay. Anything else from the state?
I wasn't going to bring it up until after the ruling on the motion, but the parties have reached an agreement to do this on our own. And as soon as that gets accomplished, if it's accomplished to both of our satisfaction, then I'll let the court know so you can create the hearing time.
Okay, we'll address that momentarily. Ms. Fugate, anything else?
If she knew that they were already going to settle on another situation, why did she just sit there and rant like that? She knew they were going to come back and say, we've already settled on something. We've got another plan, another game plan. But she wanted to have her say, this is what we're going to be dealing with for 3 weeks, you guys. I hope y'all are prepared. If y'all have Valium or whatever else, you may want to take it.
All right.
Just saying.
Under the Miami Herald versus Lewis case, ma'am, Ms. Boone, you had the burden of producing evidence and proving by greater weight of the evidence that closure is necessary. What has been presented today has failed to meet that burden. Your motion to close the September 3rd viewing is denied. The court will follow up with a written order that you'll be hand delivered today. Ms. Fugate, if you don't have no longer any business before this court, you are free to go, ma'am. Thank you. Have a pleasant afternoon. Mr. J. Yes, ma'am.
Forgive me. When you stated to the court that my motion was oral, was this during the last hearing that we had?
You requested this both, ma'am, on August 5 and on August 9.
What was it specifically that I requested?
You had requested privacy with regard to the September 3rd hearing. And I advised you that I needed to look at the law on it. And you asked again on September 9th when we were going to address it. I said that we would address it on the 14th. You asked for copies of the law, and those were mailed to you on the 9th.
Which I have yet to receive. And I was not aware of, I was not instructed by anyone in the court, including yourself, that that was an oral motion. If I needed to actually do a proper motion, I would have correctly done so.
That's why we had the hearing, ma'am, because you asked for it orally. So you orally moved or tenaciously moved to have that motion heard. And we set it up for today, since we already had the hearing time carved out, to address you receiving the hard copies, which seemingly has already been remedied. And last week when we had our hearing on the 9th, I said, I don't want to lose that hearing time because we already had it carved out. So we would proceed with the hearing on the privacy issue at that point in time. You then asked for the case law. I said, absolutely, I will get it to you. Mr. J had advised that he was familiar with the case law. But regardless, it was provided to all parties and mailed to you on the 9th.
Yes, Addie,
which
he
I
is
have
on
yet to
top of it.
receive, and I was not instructed by anyone in the court that that was an oral motion for me requesting privacy. I thought it was just a comment that I could have on record.
Ma'am,
I don't need to do anything further.
that's why we set the hearing, because it was something that you had asked for. And that's clear in the order that was provided to you on the 9th as well. It says that we would have a hearing today on the 14th.
And when did I receive this?
Well, that was orally told you on the 9th. The letter itself was mailed to you on the 9th, but the order itself was read to you during the course of that hearing. Specifically on August 14th, 2024 at 1:30 p.m., a hearing will be held in courtroom 12A, Orange County Courthouse, 425 North Orange Avenue, Orlando, Florida 32801, regarding defendant's review of the USB drum drive, which contains the state's digital evidence. The defendant's August 7th letter to the court, delivered to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024. The pertinent case law is attached. That was all addressed with you, ma'am, on August 9 here in open court.
In the order I have yet to receive.
But it was read to you, ma'am. It was read to you as to what we would be doing today, and
Even
that
we
we would
heard
be
it.
addressing the issue regarding the media's participation. And that's when you asked for the case law. And I said, I will give it to you. Absolutely. And it was all mailed to you on the 9th.
I'm not ever sure of what it is that I'm supposed to be doing with, I guess now, oral and also in writing. And again, I'm sitting here waiting empty-handed for everything that was mailed to me day before yesterday and or could have been readily available on the internet, which I do not have access to. So I'm guessing that your verbalization of the order that you read to me, which I have not received, is supposed to suffice.
Ma'am, you were told about the hearing in open court on Friday, August 9th.
If I knew to be prepared, I know that everyone knows that I would be prepared, which I am unprepared because of.
That's certainly your opinion that you're entitled to. Any reason for Ms. Fugate to remain? State? Okay.
I'm trying to, hang on, guys.
Ms. Boone, any reason why counsel
Sorry.
for the Orlando Sentinel and WFTV should remain?
No.
Okay, thank you, ma'am. All right.
I'm gonna see if I can get
In
these
addition
subtitles
to
better.
what was set to be addressed today, which was the Ms. Boone's review of the USB jump drive, which contained the state's digital evidence, Ms. Boone's August 7th letter regarding her requests from the Orange County Jail. Mr. J, you made reference to a potential change in the September 3rd meeting. I want to hear about that, sir.
I believe we have reached an alternative solution to an evidence view with the defendant. And as soon as that is accomplished to both parties' satisfaction, then I will notify the JA so that we can release your hearing time.
Okay.
I know it's valuable.
Can you explain to me what the proposed plan is for the viewing?
There will be a time and place where the evidence will be brought, the defendant will be brought, and she will be given as much opportunity to
I can, Amanda?
viewing like a defense attorney as possible. Her investigator will be there and allowed to take photographs and ask if he wants any particular bag of evidence opened so that it can be photographed.
Is that better?
Inspected, tested, copied as provided by 3220 in the criminal procedure rules. And then the evidence will be brought back to where it's stored, and then the defendant will be brought back to the Orange County.
Okay. Have you had a conversation with Ms. Boone prior to today regarding this proposal?
Well, with Mr. Lane, who has indicated her position, which was that she agreed to that.
Okay. All right. Ma'am, I don't want to go into specifics of what you've had with your investigator, but has he relayed to you what Mr. J just advised the court of?
Yes, to a certain degree. It has not been fully explained because it is in the process of being spoken about between the two of them. So yes, I do know that that is a solution to my request.
Okay. And did you understand what Mr. J advised the court of today regarding how that process for you viewing the physical evidence would be.
If you could please do so again.
Sure. If you could explain it again for Ms. Boone, Mr. J.
When the defense attorney wants to do an evidence view, we typically go to where the evidence is stored, depending on the law enforcement agency. He or she can bring an investigator, and an investigator will take photographs if so requested. We typically don't let the defense attorney manipulate the evidence him or herself. The CSI, who would be present as well, the crime scene investigator from the law enforcement agency, would be the person to manipulate the evidence on the cutting paper. And then we would have the opportunity to review, test, inspect each piece of evidence. So for instance, I'm not saying the evidence, but a piece of clothing, the front, the back, you have the CSI turning inside out, those sorts of things. And then it can be documented by an investigator with photography. Between each piece of evidence, there's a new piece of cutting paper, butcher paper laid down. So examination and DNA testing. And this is basically how the process goes on for physical evidence. If it gets opened, it'll get resealed by the CSI right there in front of all of us. And the CSI will reseal the tape, re-put his or her initials over it with the new date. So everybody will be on the same page about why it was open, when it was open, and so on.
Thank you for that. If I may, is it closed or is it open to?
No. People that are not involved with the case will not be there.
And if I may, if you know, will my phone physically be there?
If it is stored in physical evidence, then it can be brought over. We're not going to be turning it on. It can be photographed or examined. It can be photographed and physically examined, but in order for it to be turned on, it would have to be done at a different location where there's something called a Faraday box, or room where electronic signals cannot come in or out.
Do I need to write a motion for that?
For what? For your phone to be brought over and turned on?
If I can extract any type of information from it.
So, like we discussed in the last hearing, that would be up to you to hire a digital forensic examiner, and then we would make arrangements with that person so that he or she could image the phone in the same manner that it was imaged by law.
Thank you. I'm grateful.
Welcome.
Wait, I can't touch the phone? I can't turn my phone on? Oh, she is pissed. You guys, here's what I don't understand. Bruiser Grace. Here's what I don't understand. There's a motion, or in the docket that I was researching earlier today, Padilla, y'all remember him? He was our attorney back in 2021, 22. He actually did a subpoena to AT&T for all of her phone records. It was her cell phone. I confirmed that. And her all phone records from January of 2016 to March 15th of 2020. Now that could be a little bit different than what's actually inside the cell phone, but you can't, they told her already that everything that's in that cell phone has already been downloaded into that, what do they call it? Cellbrite or some, that, not DataWorks. Maybe it's Cellbrite. So she can already see it if she would just open her flipping digital evidence. Ugh.
Okay. All right. Then, ma'am, after having Mr. J explain that alternative solution to the evidence viewing, is that something that you would like to participate in?
Absolutely.
Okay. So then is it the parties' agreement to no longer have the evidence viewing here in open court on September 3?
That's the state's position, but again, I've been doing this long enough to know that you can never predict every possible hiccup. But I will defer to the court if you want to free up your hearing time now or wait until we're able to tell you that we're satisfied.
Okay. Ms. Boone, are you in agreement with that alternative solution?
At the Orange County Sheriff's Department?
Wherever the viewing is going to take place. I don't know that a specific location was identified, but yes, where it's going to take place.
I am.
Okay. So then here's what we'll do. I will keep the hearing for now. The deadline to have that viewing as set forth in the August 5 scheduling order and notice of hearing will remain of September 3. If that evidence viewing takes place at a law enforcement agency based on the protocol as identified by Mr. J, I'll just need a notice that's provided, signed by Ms. Boone, signed by the state, signed by Investigator Lane, as to when it took place and how long the viewing was. And if that's provided to me, we'll then cancel the September 3rd hearing.
Yes, sir. We'll do that, and we can even list physical items that were brought.
My only question about that is we had sealed at the last hearing the witness list and the exhibit list.
I think all the property receipts and all those sorts of things are already in the public record.
Okay.
I think there's a vast difference between a list of evidence that's already in the public record versus having them look at it with television cameras.
Okay, all right, fine. Ma'am, are you amenable to that additional procedure that after the evidence viewing takes place, you would sign a notice reflecting when and how long that evidence viewing was? Okay, and then once that's provided to the court, it can be filed, and then the court will cancel the September 3rd hearing. Yes, ma'am.
And that is done by the state?
The state will prepare it.
Documents and bring them.
Yes, ma'am. The state will prepare it. All you need to do is just review it and sign it. Okay. All right. Thank you, Mr. J, for providing an alternative solution. Ma'am, I wanted to go back and address your request for the freedom of movement motion that we addressed last week and your desire to use a stun cuff. I understand that a representative from the public defender's office spoke to you about clothing and what they may be able to provide to you. Is there any preference with regard to clothing that you may have?
As opposed to a skirt and pants?
Correct.
Yes, I very much would prefer to wear a skirt.
Okay. So if you wear a skirt, as explained to you by Officer Barnett, the stun cuff is located on your calf Achilles area. It would be something that would be viewable by the jury. So you have, or do you understand that if you choose to wear a skirt for clothing purposes, that's going to be viewable by the jury?
I understand. My belief by you asking me was that maybe it could be moved to a higher place where it cannot be seen, or is it strictly to the one area?
As Mr. Barnett or Officer Barnett explained at the last hearing, how the stun cuff is affixed to a person, it is on the lower leg ankle area.
Okay. I'm not understanding why this is being asked.
Because I want to bring it to your attention that if you have a desire to wear clothing which would reveal the stun cuff, I want you to understand that it's something that the jury can and may be able to see.
I understand. Is it a decision I need to make today?
It's something that you need to consider. If you're wearing pants, they obviously cannot see it. If you're wearing a skirt, they can see it. And you're making a intelligent, knowing decision that they can see that and that you want to proceed with wearing a skirt. Your other option, if you do not like either of those, is the parties will remain, you'll be hands-free, as we discussed, but you'll have the leg restraints like you have today, and everyone will conduct everything from counsel's table. All direct examinations and cross-examinations, any questioning of any witnesses, any argument, any opening remarks or closing arguments or opening statements will be made from counsel's table. You can certainly stand, but we will not have the opportunity to walk around the courtroom. Now, I know that we talked about in our last hearing that we would have another hearing when we have our trial case management in September, addressing the box as to where everybody would go to. And last week on the 9th, I said that we would limit access to from counsel's table to the podium, and we wouldn't be allowed to approach a witness or the jury, and those same restrictions would be placed on the state as well. I'm not telling you what to do. I'm just giving you a series of options. Because if you want to wear a skirt, you have to understand that the jury can and will be able to see that device that's affixed to your leg.
And by my hearings that we have spoken about the stun cuff, they are televised, correct?
To the best of my knowledge, the media has participated in the majority, if not all, of the hearings that this court has had with you.
Does the court broadcast live, or is it uploaded to the clerk of the court's website?
What is broadcasted live?
My hearings in regards to all of them, basically, but recently the stun cuff. Is there anyone that would know that I'm already wearing it if they could see it or not?
I can't speak to what everybody else knows.
So if I may, please, my options are pants hiding the sun cuff, or a skirt with it being visible, or I am able to sit here at the council's table with leg chains on and no one is able to move except for here at the council's tables.
You'll certainly have the opportunity to stand, but we wouldn't be able to move around the courtroom, and those same restrictions would be placed upon the state.
Okay, I just wanted to confirm that those were my options.
Correct.
And when do I need to make that decision?
You don't have to make that decision today. It's something that we can address at the trial case management in September. Ms. Click, I see you raising your hand.
Your Honor, I just wanted to let you, so Ms. Boone is aware fully of what the options are.
If you could, before you get to it, and just announce yourself for the record, please. Yes, ma'am, go ahead.
We have gone through the entire clothing closet as well as our backup for what we have. As it stands right now, unless we have.
Okay, I'm not sure what this lady's technical title is, but I'm pretty sure she works for the court or whatever. And she's basically saying that she has some outfits in Sarah's size for her to wear to trial. I think she says she has about 3 or 4 pieces in her size.
Every, we do have some shirts, but for in terms of skirts versus pants versus the dress, that is everything we have that will fit in this food size range. So I just wanted that to be aware so that Ms. Boone is making any sort of decision, she understands the implications.
And Sarah's like, Brian, go down to Fashion Bug and get me a dress. I'm just kidding. He doesn't take her calls anymore.
Okay. Ma'am, did you have the opportunity to hear what Ms. Click said?
I did.
Do you have any questions for her?
If you could please repeat what it is that you all have available, the numbers.
8 pairs of pants, 3 skirts, 1 dress.
Ma'am, do you have any other questions for Ms. Click regarding the clothing that the public defender is endeavoring to provide for you?
And if I do come to the decision, I can always have someone externally bring something into me.
Absolutely, always have someone provide something in your personal property at the visitation center, which I described across the street from the center. That is not, the public defender's office is in no way involved with that. To put it in your property and the corrections with transport of property.
Yes, ma'am, thank you.
All right. Any other questions for her? All right. Can Ms. Click be excused?
Yes, thank you.
Thank you, ma'am. The next issue that I wanted to address was the review of the digital discovery. Ma'am, Mr. Lane was provided at our last hearing on the 9th, the hard copies of the discovery, the USB jump drive, which contained the state's digital evidence, and digital transcripts of the depositions of Detectives Chelsea Counsel and Scott Lowen. And he was to meet with you on Saturday at 9 o'clock. Did that meeting take place?
It did.
Okay. What was provided to you, if anything, at that meeting?
What he and I did?
What was provided to you? What was given to you by Investigator Lane?
The digital evidence we went over, and we're still reviewing the discovery, but I don't recall anything physically being handed to me.
Okay. All right. And when you say that you went over the digital evidence, are you referring to the USB drive with the 9 items that were identified in the state's exhibit list?
Yes, I do have that. We have not concluded going through that. We have other meetings tentatively scheduled, which we will be concluding that also in order to meet the deadline for the objections of the 23rd of August.
How many of those 9 items were you able to review with Mr. Lane on Saturday?
Not more than 1.
Okay. Were you able to access all of the 9 items on that USB drive?
For the brief moment that he and I were able to attempt to do so, yes, they seem to work.
Okay. You did not have any issues opening up any of those files?
I personally myself did not open all of them.
Okay. All right. Okay.
It's on our to-do list.
Ma'am, Mr. Lane also took possession of the hard copies. Have those been provided to you?
They were waiting at the dorm for me upon my return of the last hearing.
Okay, and where are they currently?
They're located at my bunk area.
Okay, and what are they stored, or how are they stored?
The hard copies you're referring to?
Yes, ma'am.
The 2 boxes are at my bunk on the side in between other bunks.
Okay, all right. Are they in some type of bag, or is it just the 2 boxes that are right there?
Just the 2 boxes.
Okay, all right.
Okay, in case you guys didn't hear, she just said that the physical files that were given to her, those 2 boxes, boxes A and B, they're sitting at her bunk in the jail in between her and another prisoner's bed, bunk, bed, whatever. And here's what's going to happen. She said, yes, the items could disappear. And when they do, I will blame the court. No, she didn't say that. I'm just saying that he's going to tell her, well, you do realize if anything could disappear, that another inmate could have access to your documents, right? And she's like, yes, I do understand. And then in my head, I was thinking she's still going to come back and blame the court because something of hers is missing.
Do you understand that you told me that you live in the female dormitory with limited privacy? You understand by keeping those boxes there, there may be a risk as to other persons looking at them.
I don't have any other choice.
Okay, but do you understand that that risk exists?
Of course.
Okay. Do you understand that there's a risk that those items could disappear?
I understand.
Okay. All right. Do you understand that it's your request and choice to keep those documents in your possession?
I do, and I'm also requesting in my letter to the captain and to the major to also be able to store all of the USB drives and the hard drive in my locked drawer also for an extra security measure.
Okay. All right. I see that we'd have Investigator Lane here. Sir, if you can come out. Madam Clerk's going to go ahead and swear you in.
I do.
Sir, good afternoon. Could you state your name for the record and your affiliation with Prison Break Investigations?
Billy Lane, owner and chief investigator of Prison Break Investigations.
All right. Thank you, sir. I did see that your notice that you provided regarding the distribution or providing the discovery. You provided the hard copies and the USB with the digital and the USB with the depositions of the 2 detectives.
That's correct.
Okay. All right, sir. And when you met with Ms. Boone on Saturday, again, I don't want to go into any specifics, but were there any issues accessing any of those USB drives or any of the files?
Not at the progression in which we made through the files.
Okay. All right, very good. But as of right now, there's been no issues as to access from what you've reviewed. Okay, all right. State, do you have any questions for Mr. Lane?
No, Your Honor.
All right, ma'am, do you have any additional questions for Mr. Lane?
In regards to the drives?
Correct, based on what was teed up for hearing today, which was addressing your review of the USB jump drive, which contains the state's digital evidence.
Mr. Lane, are you able to briefly meet with me downstairs after this concludes?
I'm not sure if that's permissible with the policies and procedures. If not, I'm going to try to schedule a meeting with you.
Okay.
Any other questions for him, ma'am?
No, Your Honor.
All right, can he be released?
Yes.
All right, state.
Yes, Your Honor.
Thank you, sir. Appreciate you. Okay. The next, ma'am, is your letter from August 7th to Captain DiGiovanni, which is the court has had the opportunity to read. I believe that we have a representative from the Orange County Jail who's appearing virtually. If you could please unmute yourself and turn on your camera, whoever it is that may be appearing from the Orange County Jail.
Captain Giovanni's in the house, you guys.
I have a Administrative Sergeant De Jesus on the link.
Good afternoon, Judge. This is Captain Gina DiGiovanni. with Orange County Corrections. I'm the captain of the Female Detention Center. And yes, I have Administrative Sergeant Stephanie DeJesus with me.
All right, very good.
I will also want to make it clear that I have Orange County Corrections Department Legal Counsel Scott Chevenel on the phone with me.
Okay, very good. If all of you can, if the Captain DiGiovanni and Sergeant DeJesus, if you could please, I only see you, Captain. If Sergeant DeJesus can come into frame, we'll have Madam Clerk swear you in. If you both can raise your right hands.
Yes, ma'am, I do.
All right. Could you both state your names for the record for me again?
Administrative Sergeant Stephanie DeJesus. Captain Gina DiGiovanni, Security Operations, Female Detention Center, Phoenix Facility, Genesis Facility.
And can I get appearances for legal counsel for the Department of Corrections, please?
Scott Chevenel, County Attorney's Office, representing the Department of Corrections.
Okay. All right. Very good. Captain, have you had the opportunity to review Ms. Boone's August 7th letter regarding some of the requests that she has in this case?
Yes, and if it's okay with you, Judge, I'd like to address each request one by one. Do you have a copy of the letter?
I do, and we can proceed with the 7 different items that she has requested. So if you
actually, so with number 1, the request to have her review time extended, I can make the extension in the following fashion. We'd still have to collect the laptop at 4 p.m. This gives the staff and supervisors the ability to conduct the afternoon head count, conduct the meal dinner service, conduct the shift change, and then the evening head count. I am willing to allow her Sunday through Thursday to get the laptop and the USB drives from 8 p.m. to 10 p.m. and Friday night and Saturday night from 8 p.m. to 11 p.m. That is more than the requested time that she has asked for additional viewing.
Ma'am, do you understand the extension that's being provided by the Orange County Jail regarding the laptop, that on Sundays through Thursdays, additional time from 8 p.m. to 10 p.m., and Fridays and Saturdays, 8 p.m. to 11 p.m.?
Correct, with them collecting it at the normal 4 p.m. time.
Correct.
Yes.
All right. Do you have any questions regarding that extension?
I do not.
Okay. Is that acceptable?
Very much.
All right. Moving to the next issue, Captain, the USB drive security.
Number 2, USB drives. It's a matter of security. The metal tips, the drive itself can be fashioned into something other than what it's originally intended for. These items are secured in a secure control room and inventoried by our supervisors on every single shift. They're also inventoried and acknowledged being in good working order and repair by my DSTs, the escorting officer, and my supervisors. So at this point, unless directed by legal counsel or consultation with legal counsel, I believe that these drives are secure and managed. This, by the way, is the same way it's managed by other facility captains, that you get a viewing period and then everything gets secured and inventoried.
Ma'am, do you have any questions with regard to the USB drive request in your letter and the position of corrections regarding it being a matter of security, and how the USB drives are secured, controlled, inventoried, and confirmed to be in good working order?
I understand the process. My only concern is if I'm able to have my hard copy of 2 full boxes of my discovery, I'm not sure why, other than the fact that the assumption could be made that it could be made into something other than a USB drive. And I'm trying to avoid any further leaks of information that could possibly be suppressed or utilized in my case. So I didn't know if I could have my hard copies. I'm unclear other than those reasons why I cannot have those as well.
To the extent you're able to answer that question, Captain.
And I would just chip in that, obviously there's safety issues and you can definitely distinguish between, paper copies and anything made out of metal, which is what the captain just testified to. That's the problem, it sounds like to me, is anything that could be a safety hazard is an issue for us.
So, ma'am, do you have any other questions regarding the Corrections Department position with regard to the USB drives?
What was the outcome?
It sounds like unless I've missed something, it sounds like the Orange County Jail is going to continue with their protocol of storing, inventorying, and keeping the USB drives in accordance with the procedure as provided to you and read to you in open court.
And that's due to metal?
That's due to the reasons that were already identified. The matter of security regarding the drive being fashioned in a way that may affect security, and it continues to ensure that those drives are secured, controlled, inventoried, and in good working order. Do you have any questions?
Could you please provide the last name of Scott, the legal counselor, please?
I'll spell that, Judge. Shevenell.
One more time, please.
Shevenell.
Thank you.
With regard to the third request is to a classroom, Captain DiGiovanni.
So that classroom is a multi-purpose classroom. It's used by programs and chaplain services. I cannot allow the use of a classroom. What I can offer is if the defendant is willing, I can move her to a housing unit and place her in a secure cell where no one will disturb her, and she can review and conduct case review. She will still have access to a shower. She will still have access to open day room time. She will still have access to phones, but the review and her location will be in a secured housing location where she would be the only person in the cell.
That sounds reasonable, right? Do you guys think that sounds reasonable? I like that. But do you think Sarah's going to accept that? No. Sarah is on another level of type A. She is the only person I have ever met that needs a forklift to get her panties out of her wad. You know what I'm saying?
Ms. Boone?
Captain, is this Lima dorm?
K dorm.
Kilo. So my only options are being moved to the maximum security dorm or my bunk.
K dorm is no longer maximum security. It's a multi-purpose area with inmates of varying needs being secured and housed there.
So it is not the maximum dorm any longer?
That's correct.
And I'm unable to utilize the classroom for an hour or two per day while it's dark the entire?
That's correct.
And if I may ask, other than it being accessed on a rare occasion of the two classes that do participate in that classroom, why is it that I'm unable to sit and be viewed by the officers at all times in my dorm comfortably to be able to utilize the phones on a regular basis, the day room on a regular basis, to be able to go outside to recreation, to have just for fresh air? Specifically why the reason is it has to be so extreme from going to being locked behind a door 24 hours a day to not being able to just utilize the classroom.
You're
for
in
an
jail.
hour or two per day.
You're in jail.
Ma'am, you will still retain your rights as an inmate and have access to all the services and day room time that you currently have during the same operational hours. And instead of having to move items from a housing area into a classroom where the officer may have line of sight, I cannot guarantee that my officer will have continuous unfettered access to you to ensure the safety and security of that classroom while something may potentially occur in the housing unit. So as a matter of security to the rest of the inmates in the housing unit that you are currently assigned, my staff and the facility, I can make the accommodation where I could put you in a single person cell where you would have unfettered access, uninterrupted access to your case material, and still have my officers in the housing area where if you had a question or you wanted to take your shower during normal day room time, you would be able to do so.
I've been in a situation where I have been behind the closed doors also when I was made PC, when I first got to Orange County Corrections Department. And if it's anything like that, I do not ever want to have that experience again. And to be honest with you, forgive me, Captain, but I do not believe that it would be this simplified. And nonetheless, I'm behind a closed door for 24 hours. Is there anything that I can do, any kind of research or further explanation in order for me to try to still be able to utilize my dorm, which is general population dorm, where I do have friends and I do have some type of comfort there, in order for me to be able to access the classroom? Or simply are my options from working on my bunk or to the extreme of being behind a closed door for 24 hours?
This ain't Burger King, Sarah.
Captain?
Judge, I'm going to object to that question. It calls for her to speculate at this point as to what all the other alternatives may be. She's simply here to, responding as to this particular request, and now she's asking her this kind of this broad general question about alternatives.
The objection is sustained.
In regards to number 4, earphones or headphones, I would need to consult with legal because I don't know what the ramifications of that is. We've not had a pro se inmate ask for earbuds or headphones. I would have to defer to legal counsel and my chain of command for guidance in that request. With regards to number 5, internet access. Again, we've not had a pro se inmate, or at least not one that I've been responsible for, request internet access without limits. So again, I need to refer to legal counsel with legal counsel and my chain of command to get guidance on that. Regarding number 6, a word program, we've not had a pro se inmate, again, myself, that requested access to a word program. I would need to consult counsel, legal counsel, and my chain of command for guidance before we could make a response. Number 7, telephone access. In her statement here, as you are aware, my dorm contains payphones only and are limited to only 15 minutes per call, which are collect. I need to be able to communicate on a regular, normal phone to make all necessary calls. Hold on, I'm turning the page. For my case to use in trial. I have no other way to contact anyone that is not collect, which incredibly, I believe that diminishes
See, y'all, she
I
can't
don't
read
know
it
what the
either.
other word is here. If not all of my opportunities to properly prepare. The phone system that we currently have in the jail for the inmates to access is as is. I don't have the ability to make any modifications. Number 8, discovery hard copies. It seems that Ms. Boone already has access to her hard copies. The concern I have to do now is do some research with legal and my chain of command, because that quantity of paper can potentially become a fire hazard. And we have standards in place. And Judge, I'm not certain if you're familiar with the Florida Model Jail standards, but the quantity of paper is actually the problem. So we may have to come back to the table for a different type of resolution regarding the 2 cases of paper discovery.
All right. Ma'am, do you have any questions regarding Captain Giovanni's and the Orange County Jail's position with regard to the earphones, headphones, internet usage, word processor, telephone, and the concern regarding the hard copies and it being a fire hazard?
I do, and I was also including number 3, the classroom utilization. I just want to make it clear and in open court that I want to have the understanding with everyone that it is an option of mine to decide to remain on my bunk with this discovery in the laptop, and it is or my option to be moved, but I have the ability to make that decision.
Judge, I have no objection to that. I am not looking to impede anybody's ability to access to a general population housing unit. I was simply offering an option that would be amenable to security and potentially Ms. Boone.
Okay. Am I able to proceed?
You can.
She thinks she's at the Hilton.
So for my understanding right now, you need to speak to your legal counselor in regards to the headphones, the internet, the word program, and the discovery hard copies, which I already have. Is that correct?
And telephone access.
Oh.
You want unfettered telephone access, if I read your letter correctly.
Reasonably, I would like to have access to a regular phone. It could be 1, maybe 2 times a week where I save all of my calls for a particular day. I'm always up for solutions, just whatever it is that I can do in order to progress properly and expeditiously. I'm trying to do so by having this where I am confused why this was not all solidified prior to the implementation of the laptop. So I'm waiting for whatever it is that I can do to fully access and become a pro se defendant and inmate. Do you know when, how long the deadline might be for the open-ended items that I would be waiting for?
Judge, this is Scott Chevin. I'll chip in with the legal piece of it. The legal piece of it is simply that she's a pro se inmate. She's not the first pro se inmate that the jail has had. We've had several. And the issue is whether or not there's any constitutional or statutory violation with what we provide pro se inmates. And I would argue that there's not. She has access to the court as required by the law. Everything she wants is over and above what our typical stance is for pro se inmates, and all those policies are in place for a reason. But somehow she wants to go beyond that, and she wants all this extra consideration, more than anybody has ever been given, frankly. And at the end of the day, again, it's a constitutional question. Is it a violation of her constitutional rights, the restrictions we have in place? And I would tell you it's not.
Is that a position, Counselor, that you're taking today because Captain Giovanni had stated she needed to consult with legal counsel as to the issues of the headphones, internet, word processing, telephone issues. Is that the position that you're taking today, or is that something you need to further investigate to have a final position as to that?
No, that's my piece of it from the legal end. Now, of course, she's going to talk to her folks as far as the security end of it, because a lot of those things are in place because of security concerns. But from a legal concern, I can easily answer that today. And the answer again is, she's legally, she's allowed access to the court and all these other things that she wants. And really, and I'll tell you what the case law says. The case law says if she's pro se, she's entitled to get, a paper, a pencil, and some stamps and some envelopes and those types of things. The idea that she wants unfettered access with the phone and she wants to make calls all day and night. At the end of the day, I'll also say there's case law out there that says, she's gone through, I think, 8 attorneys in this case, and she had several attorneys appointed to her case, and she's kind of put herself in this position today. And the case law is not real favorable to folks that put themselves in that position.
Woo!
Ma'am, do you have any other argument with regard to these requests as to the headphones, internet, word processor, or telephone?
So my understanding is that I'm being penalized by Orange County Corrections Department because of their misunderstanding in regards to my, in quotes, 8 attorneys prior. Is that why I'm unable to have anything in order for myself to properly represent myself as a pro se defendant and inmate of the Orange County Corrections Department?
I'm not going to answer that question.
Not being penalized, just the opposite. She's being treated like every other pro se inmate in the institution. She's not being penalized at all. She wants consideration over and above what everybody else has.
If I may please, what is over and above? What other pro se inmates, what is it that they've asked for? I don't see how they could successfully even represent themselves without internet and a regular working phone. And I'm pretty sure that they were not able to complete their case and the successful outcome that they were hoping for by being provided simply papers and pens.
Counselor, if you
I'm not sure she's asking me a question. I don't know if I'm a witness in this case or if she's trying to ask me a question.
I'm not. You're just simply the attorney for one of the participants, sir. If you don't, you're under no obligation to answer that question. You are just providing your legal position with regard to the Ms. Boone's demands and requests.
Right.
They're simply requests. And I'm not sure who it might be that could answer my question, please, in regards to what prior or present other pro se defendants and inmates have requested. So I might have a guideline of something to go with forward. And I, again, do not know what is above and beyond simply asking for more than paper and pens in order to properly and rightfully and lawfully represent myself.
Counselor, to the extent you want to respond to that, you can.
Yeah, I mean, Judge, like I said, we've got tons of pro se inmates that have come through, that are there right now, that have come through the jail, and they get standard treatment. And she wants a lot of things that are over and above that. For instance, again, unfettered phone calls. She wants to keep things in her cell that she can't normally keep, that they wouldn't allow folks to keep. So there's a lot of issues. I mean, that's a wide open question. But, can I speak to everything that everybody's got in the past? How many pro se inmates we've had that have come through the institution? No, but I can tell you that, we could probably find plenty of examples if need be as to what people have received in the past. And it's nothing close to what she's requiring or requesting today.
Okay. Ma'am, with regard to your state, do you have any position with regard to any of these matters we've addressed? Okay, thank you. All right, ma'am. So with regard to your request as to the laptop, this jail will be able to accommodate your request, and those extensions will be provided as placed previously on the record. With regard to your request to hold the USB drives in your own personal lockup, for the reasons identified by Counsel Chevenel, it's a matter of security, and the protocol which secures, controls, inventories, and ensures in good working order the USB drives will be complied with, so that request will not be accommodated. Your request for a classroom similarly cannot be accommodated for the reasons identified by Captain DiGiovanni on the record. However, there is an alternative housing offer that can be provided for you. with regard to your request for headphones, that has been rejected and denied by virtue of legal counsel's argument and what is being provided to you. With regard to the internet, word processor, and telephone, again, for the reasons that counsel for Orange County has identified, those cannot be provided to you. The court does note that you do have the services of an investigator, and JAC provided you $10,000 and $1,000 for travel for your investigator. To the extent, as requested for the purposes of internet, for locating witnesses and experts, you have a personal private investigator that can utilize, who could do that for you. I know you've made requests previously to look at your phone to find contacts and information. You also have a private investigator who would accomplish some of those tasks for you. And those can be communications and conversations between yourself and to your investigator as to who and when and where and what persons you might be able to seek to find. So for those reasons regarding the headphones, internet, word processor, and telephone, based on arguments of counsel for Orange County, I'm unable to accommodate those requests. The jail is unable to accommodate those requests. Those requests will not be provided. With regard to the hard copies, that's going to have to be a matter, if it needs to be addressed, it can be readdressed with regard to the potential fire hazard. Captain DiGiovanni, would that still be an issue with regard to the fire hazard based on the amount of paper if Ms. Boone elected to move to the secured housing in the K dormitory?
Yeah, it's basically the Florida Model Jail Standard 7.12. The officer in charge or designee shall determine what personal items may be kept in the cell or stored with the inmate. However, an inmate shall be allowed to retain a reasonable amount of personal property, including but not limited to his or her legal material, personal hygiene items, writing paper, and writing instrument, and authorized reading materials in reasonable quantities as approved by the officer in charge or designee. Personal items will be kept in an orderly manner. Fire potential is reduced by limiting the amount of personal property in the cells. So it is the sheer volume of paper, and that is what I need to conduct an evaluation from. Now, in Ms. Boone's letter, if you give me one moment.
You know, they really don't have to go over all this stuff with her. They're going above and beyond, and I think they're doing that kind of to help the judge out as well. But you guys, her next motion is going to be to ask the judge if she could use his car. She's that entitled.
In number 8, discovery hard copies, she writes the following: as I am presently, I can keep these in the permitted property bag discreetly located at my bunk. I will purge the documents I have now and keep only new discovery hard copies. The remaining I can send to the property department and will purge anything already being stored for easy convenience and extra space. I'm willing to see what she's going to purge and send to property, but at the end, I have to reduce any fire liability to the building in order to maintain security and safety for the 399 other inmates that I have here, along with the almost 100 or so assigned staff, civilian and certified. I will also say that pro se inmates in the past have been afforded a second fire retardant property bag, and I'm willing to issue a second fire retardant property bag to accommodate the excess, but anything over and above that, we may have to find an accommodation. And based on the willingness of the letter that Ms. Boone has written, she articulates clearly that she's willing to purge and send to property any paper that's over and above.
Do you have any questions?
And
well, no, go ahead.
And I
I'm
can
sorry.
have that second property bag upon her return this evening.
Ma'am, do you understand the second fire retardant bag that could be provided to you regarding the hard copies of the discovery?
I do, and it was already provided to me, but the boxes unfortunately do not fit in the bag, where I did attempt numerous times and even had others try to help me put it in the bag. I also did not know that they were fire retardant bags. I have the one already at my bunk, and I'm in the process of trying to figure out what needs to be purged. I also have my second family law case that I'm trying to be able to obtain those copies at my bunk as well, because of the difficulties of receiving and delivering anything to the property department, which is why I came up with the solution of me trying to purge what I can specifically, to be specifically removed from the jail completely by a friend who can come and pick that up. I was just waiting for this hearing to happen so I can figure out when to tell her to come to do so.
So is that accommodation acceptable?
It is. I returned the second fire retardant bag, property bag, because I didn't want to have anything extra on top of my extra already. And it is not able to be used for anything that I can put in there, where I already have everything in the boxes in the one bag already being occupied.
Are you satisfied then with regard to the treatment, for lack of a better word, of the hard copies?
What do you mean by that?
Sure. Are you, the procedure for having them stored and where they're kept is identified today, is that acceptable to you?
Meaning I can have them where I have them now?
That's my understanding.
Judge, may I say something here?
Sure.
Okay, and thank you for allowing me the interruption. The cardboard boxes are not authorized by the fire marshal. The fire retardant bags are. So the documents are going to have to come out of the cardboard box and into the fire retardant bags.
Ms. Boone?
I would have to figure that out for the voluminous amount of paperwork that are contained in those two boxes. And there is no way to organize or separate. So it would just be a large mass amount of papers. So if I may, in the meantime, try to come up with some type of organizational structure of those two fire retardant bags with my hard copy discovery enclosed in those.
She's going to do a show on that, a DIY show on the home. What's that? What is it? Home and Garden?
If I could please do so.
To organize things.
Mr. Chevenel,
Captain Giovanni, is there any way we can give her an additional bag or so and she can switch it in and out of property or whatever it may be? Can we provide her an additional bag that may help her to separate her documents?
I could provide the third fire retardant bag, but it's the encroachment into another inmate's area. It's a limited space. But the cardboard box can't remain. And Judge, if you recall my request, I had asked for all of this to be placed on a USB drive so that we would not have the paper in the jail for this very reason.
And I understand that. And Ms. Boone has continued to request the paper copies. And that's why everything was digitized, so that she would have that access to it. Everything has been digitized, but she has continued to request for those, and we're trying to make that accommodation for her as well. Yes.
Scott, if everything's digitized, why do we have to get the paper?
That's up to her if she wants paper or not. That's fine.
All right.
It was never my decision to have anything digitized in the first place, and nonetheless, it's being put on a laptop that is not even fully accessible because some of the programs do not work, which I have not had the time yet to continue to go through everything that are on the USB drives. And that being not my decision, and nonetheless, and most important to me, they are limited and restricted to particular time periods. When those laptop times are closed for the day, I can therefore pick up the hard copy discovery, be it in a fire retardant bag or in a cardboard box or whatever else it is that I'm able to keep them there at my bunk. I have that as plan B when plan A is closed.
Judge, if I might be able to offer a resolution here.
Okay, what do we got?
Was the discovery that Miss Boone received, was it just a stack of papers in the box, or was there any type of manila envelope or filing separation system?
I haven't looked at them. I haven't copied them. They were opened in court back in, I think, June 28th, when we had the hearing where the court found that Ms. Boone had forfeited her right to court-appointed counsel and alternatively have waived that right by virtue of her conduct. I believe the box was open at that time, and there may be manila folders for some of the items, but I can't speak to all of it. I haven't reviewed it. I'm not able to review it.
Would Ms. Boone be able to indicate whether the paper is free-flowing paper, or was it bound in some way?
Ms. Cashman had represented that all staples had been removed and all paper clips had been removed. Ms. Boone?
It is a mass amount of paper.
Are there dividers? Are there manila folders?
There, I believe, are 2 manila envelopes that have contents inside.
And everything else is just free paper?
As far as my understanding is, yes. I've not been able to fully dive into the boxes quite yet because of waiting for information for this.
What?
I can further explore once I return back to the dorm.
But I can't. Wait a minute. She's had that stuff. Hasn't she had it since at least, it was either Friday afternoon he was going to bring it over early, or he was going to bring it over Saturday. And she's saying she hasn't gone through. Y'all, I don't understand. I don't understand. This is her freedom on the line. I don't get it. So here's the deal. I found a solution. Because, you know, they were talking about solutions. Okay, I have a solution. Let's ship this hooker off to North Korea or Russia where she has fans. What do you guys think about that? Would you all like to pitch in like $1 or $2 to pay for a plane ticket, airfare? Let me know. We might could start a GoFundMe.
I can provide some manila folders without any type of clasp or string in order to get the cardboard boxes out of the building.
I understand. And that would be appropriate. I don't know if I'm limited to a certain amount on top of the specified pen and papers I am able to have. My question is, I would like to know also, please, for the reasonable quantities that you quoted earlier in regards to the amount of paper, is that the definition that you provided, is that for the enclosed housing area, or is this also for general population?
Ma'am, I'm responsible for, based on the Florida model jail standards, to reduce the amount of paper clutter in all living spaces. It's not specific to just your housing unit.
Thank you.
Captain DiGiovanni, does that now, can she switch out and get things out of the property within reason if there's additional documents in her property?
Through the request form, if she, you know, we're going to authorize the second fire retardant bag. We're going to offer some manila envelopes without a metal clasp or a string, so that she could get everything into the fire retardant bags. And then we're going to remove the cardboard boxes, which are what becomes or is the fire risk, because it is not authorized or recognized as a, fire retardant item based on the fire marshal. The only thing that they consider fire retardant is the bag. And again, I will provide that. And then anything in excess, she could send to the property room. Well, and then upon her need for it, she could write a request to the property room, and the property room will bring it over. But she has to swap it out. I'm amenable.
Delta miles, girl.
I'm amenable to her keeping her documentation. I'm not looking to take anything away from her, but it has to be in accordance with, fire marshal and policy.
I understand. And I would be happy to comply with the extra bag and the manila envelopes for separators in regards to that.
So ma'am, if the jail was to provide you those manila folders for the hard copies and a third fire retardant bag, is that acceptable?
It is. If I do conclude that I need anything additional in order for them to be able to be held together in regards to some type of rubber band or some type elastic, something to be able to bind the paperwork together, is that a possibility?
I didn't hear the question.
You may have to speak more clearly into the microphone in front of you, ma'am.
Would I be able to, please, if I needed, to have a type of rubber band or some kind of elastic in order to bind?
No.
And I know, Captain, that you are aware the courtroom is not in regards to the property bags that you all do supply. There's no rigidity to them whatsoever. It's just a floppy bag. So when you pick that up, everything goes in the middle. So there's no type of, there's no way of actually being able to make sure that one pile stays in the one pile and so on and so forth. Do you have any suggestions other than manila folders that I might be able to utilize in order to keep those together?
The purpose of the manila envelopes is that you would put the paper in the manila envelope, and that manila envelope keep the paper in order.
Okay, so they're envelopes, not folders.
Correct.
Wait, before I make my decision about that other sale, can you tell me what the view is? Is there an ocean view?
Thank you.
Ma'am, is that acceptable to you? And is there anything else we need to address with regard to the hard copies?
Not in regards to the hard copies, no.
Okay, all right. Is there anything else, ma'am, that we need to address today, Ms. Boone?
Yes, please, if I may conclude with the remaining amount of questions that I have in regards to my requests.
Sure.
Is it Mr. Chevamel?
Yes.
Could you please provide me with the protocol or policy that you all have, a guideline for me to follow, please, in regards to what previous pro se inmates may have had access to and be able to utilize? Do you have anything in writing as a hard copy?
We'll have to check on that. You asked for, are you making a public records request?
I'm sorry?
Are you making a public records request?
I'm unclear of your question. I was just asking if Orange County Corrections Department had any type of guideline that you are accusing me of going above and beyond, other than the pen and paper. So I didn't know if you had a policy or process in, if you have a pro se packet, like JAC has a pro se packet. Does Orange County provide something like that?
You'd have to ask the jail that question. I don't know. I advise from a legal standpoint, and I can certainly tell the jail what the legal standard is. I'm not going to advise you as to what the law is, but I'll certainly advise the jail as to what the legal standard is.
Yes, please. Captain, I would be responding to you in regards to that or following up with you, or Sergeant DeJesus.
Ma'am, we don't have any access to that. I don't know anything about what other inmates that are currently pro se get other than that laptop and the information transferred to a USB drive.
Yes, ma'am. Thank you. And Mr. Shabamel, you repeated that I have access to the court. Could you please define to me what your access to the court is for me?
Yeah, I'm going to object. I'm not a witness in this case. I'm really counsel for the jail, so it's really not appropriate to ask me questions. I know I've entertained a few, but I'm really not required to answer any.
Ma'am, he's not in a position to answer those questions.
Could you please answer who might be able to? Because I am in desperate need to view the case docket, which requires internet, and I am still waiting for any documents that you have mailed to me. I am unprepared, it seems, every single time now sitting here at the counselor's table with not the same information and opportunity and advantage as everyone else in the courtroom because I'm waiting for the mail. So I didn't know if anyone had any other suggestion of how I might be able to receive those more expeditiously and in a timely fashion so I can be prepared in order to properly defend myself in apparently more than one way, or every time that I'm here in the courtroom and something new is presented to me as a surprise. So I'm just trying to avoid those.
Addie said, "Help me, Jesus. She has officially requested a rubber band."
Items will continue to be mailed with you, mailed to you at the appropriate address as required by the rules of judicial administration and general practice.
So if I may please clarify, my understanding is the only way that I can receive anything is through United States Postal Service.
I'm not going to answer that question because that would be me potentially providing you legal advice. But what I can tell you is that items will still continue to be mailed to you as required by those rules.
If I may please just make sure that everyone is aware that I cannot be properly prepared, as you can see now and prior. I just want to make sure that everyone is aware and understands that.
Ma'am, for the reasons that we've discussed previously, I understand that. You're entitled to that opinion as to your pro se representation of yourself. Anything else that we need to address today? Ma'am.
Yes, I have a motion that I would like to submit, please.
Okay. Is there anything else that the jail needs to participate in with regard to this hearing?
Captain, would I be following up with you, or who would I be speaking to when I return to the dorm?
In regards to what?
I'm wondering in regards to the guideline and when and how the discovery hard copies, will the property bags be waiting for me when I return?
I will take care of that with my supervisors that are on shift.
Yes.
We will need the cardboard box so that we can dispose of that properly.
Yes, ma'am. And if I may, do you know why it was not approved prior when a supervisor was the one who delivered it to me?
I have no information about even the amount of hard copies. I didn't even know that that came into the jail because my conversation has always been that everything would be digitized and that we would have no hard copies so I could be in compliance with the Florida Model Jail Standards, Orange County Fire Marshal, and our policies and procedures regarding excess amount of paper.
Yes, ma'am, I understand. Thank you very much for your time. And Sergeant DeJesus and Mr. Shabamel.
Okay, are they free to leave?
Yes, thank you.
State. All right. Thank you all very much. Ma'am, you made reference to another motion or something else that you had.
Yes, I have a motion.
Okay, if you can hand it to the deputy behind you.
We have a motion,
Actually,
too, Sarah.
Deputy, can you hand it to the state? State, you can take a look at it, and then I will.
Wouldn't it be funny if they were able to say, yes, there's a motion coming in over the line, Your Honor, from YouTube. They told us to tell you to shut the up, Sarah.
Thank you, sir. All right, ma'am, give me a moment to take a look at this.
Oh yeah, they're having a party in the jail right now after they turn that thing off. Is it turned off? Is it turned off? Good Lord, this woman is crazy. All right, we're changing everything. What do they call it when they go jump into their bunk and they raid their bunks? They're going to go raid her bunk now. She's so stupid if you think about it. She's pissing off the people she's going to spend the next, I don't know, we hope at least 20 years with, right? Well, maybe not this jail. Maybe she'll get moved to another one. There's no way in heck, you guys, that the people around her really like her. There's no way. They probably fake it. And then when she's gone, they're all going through her stuff and stealing things from her. Yeah, do y'all think I'm right? Yeah, she's going to go to prison. You're right. She'll be moved. And that officer right there is like, I can't wait to get back to the jail to tell them about what she's doing right now. She
Court
gives
has been
them
provided
cheese.
a motion for payment of costs and appointing a neuropsychologist to assist the defendant in preparation of the defense. State, I don't think we can have a hearing on this without JICS.
State takes no position. We don't have anything to do with this.
Okay. Ma'am, I can't have a hearing on this today. I will have to coordinate a hearing with JICS to have this heard, because this is something that involves them.
Right.
And they haven't even had the opportunity to review it yet.
And they are copied on that as well.
I do see that, but you're hand filing it with me right now.
Right, thank you.
So the court will file this in the court file, and we'll coordinate a hearing as soon as practical with regard to this motion, and it'll be heard before the end of this week. Anything else, ma'am?
Just to confirm, please, for the next deadline for my responsibility to meet would be the August 23rd for the objections to the state's USB drive that they provided.
As identified in the court's order, that is the deadline. The only other deadline, ma'am, is the September 3rd deadline for the viewing of the state's physical evidence, which sounds like that's something that may take place prior to that deadline. As you may recall, you will have 14 days after that evidence viewing to tender any of your objections in writing to the court, 14 days thereafter, and that will be extended for good cause shown. Anything else, state?
Not from the state.
Ma'am, anything else?
No, Your Honor.
All right. We'll return Ms. Boone back to the custody of the Orange County Jail, and we'll coordinate the hearing appropriately. Thank you all very much.
Forgive me. In order possibly for a solution for me to know about the hearing, especially for the one regarding the JAC, is it possible for you please to relay it to Mr. Lane and he can tell me sooner than the mail?
I can certainly do that.
Going forward, so I would have some opportunity quicker than waiting for the mail.
I can certainly advise him of that, or my office can. Sure. Okay, I understand. All right, just so for recap purposes, with regard to the motions to intervene as first addressed this afternoon, the court orders that the defendant has failed to meet the burden of producing evidence and proving by a greater weight of the evidence that closure is necessary as required by Miami Herald Publishing Co. versus Lewis, 426 Southern 2nd, 1 at pinpoint 8 by the Florida Supreme Court 1982. As such, the defendant's requested closure of the state's physical evidence viewing with the state and defendant set for September 3, 2024 at 9 a.m. is denied. With regard to the other items that were discussed today, defendant and state agreed to an alternative arrangement as placed on the record on August 14, 2024 regarding the viewing of the state's physical evidence as tendered in open court on August 9, 2024. The state shall prepare for all parties to execute a notice reflecting when the evidence viewing took place and the length of time that the evidence viewing took place. The state shall file with the court the executed notice after the viewing of the state's physical evidence takes place. Defendant's request regarding extending the laptop time has been agreed to by Orange County. The times have been extended as follows: Sunday through Thursday, 8 p.m. to 10 p.m., and Friday and Saturday, 8 p.m. to 11 p.m. This is in addition to the times outlined in the memorandum from the Orange County Corrections Department Security Operations, which was previously provided to Ms. Boone and read to Ms. Boone. Defendant's request regarding the discovery that was provided to the court on June 28, 2024, and keeping that discovery in defendant's possession was addressed to defendant's satisfaction on the record on August 14, 2024, and the balance of defendant's requests cannot be accommodated for the reasons placed on the record on August 14, 2024. Ms. Boone, you'll be given a hard copy or hand-delivered a copy of these orders momentarily.
Thank you.
All right. Anything else? Anything else, ma'am?
No, Your Honor.
All right. Thank you very much.
Thank you.
Did y'all see that prosecutor? He had everything packed up. He was ready to go. He was standing there with his satchel all snapped up, ready to walk out. He's like, all right, guys, shots on me. I can't go back to the house like this. I got to stop and get me something. Oh my gosh. You guys, you are killing me in the chat. I swear to you, I've starred like so many. I know I've missed some good ones. So let me just go through. Let me just go through some of this. Oh my gosh. B Blanco, thank you so much for being a 10-month member. And thank you so much for reminding us that today is the birthday that we lost. Well, today is the day we lost Steve, one of our longtime buddies in our chat. Was it a year? Has it been a year? Or is it 2 years? It's been a year. Yeah, it's been a year. Thank you also, Miss Patty, for your 10 months. And telling everybody to don't forget to hit that like button because Carrie never remembers to tell y'all. And Miss Barbara, she's been our Bayou baby has been a member for 8 months. She says, best chat on YouTube. If you ain't here, you're in the wrong place. Oh, she's doing slogans now. And Miss Christine Covey, thank you so much, my dear. She's been a member for 10 months. And she said, you guys are all amazing people. That's so sweet. Miss Amanda Page has been a member for 4 months. Cannot wait for this trial. Girl, we're all in there with you on that one. It's just going to be, since the Brooks trial. You know what I'm saying? It's going to bring us all together. That's the one good thing about it. Soul Souffle says she takes three left turns to make a right. I love that. I have to remember that one. Barbara says, I'm going to call Verizon and put her on my family plan so I can see the phone. Mel said, yep, they've told her everything over and over and she hasn't read anything yet. Why has she not looked at her stuff, you guys? There's something not right there. I think she has, and she just hasn't found what she wants. Because think about her mind and how it works, right? That's exactly what's happened. She has not found what she wants, so she hasn't really looked through it yet, is what she's saying. She wants to get to that phone and erase any videos on it. Yeah, she probably does, Linda. I don't know. I think it's so funny. She thinks they're going to hand her her phone. Just here you go, Sarah. Just take it over to the corner of the courtroom over there. Yeah, you can go back there and have some privacy. Sure, girl. Oh, yeah. Let us take off your shackles while you're back there. Get comfortable. Sit back. Go ahead. And you'll probably take a while. We know you had that phone for a long time. It's got a lot of documents on it, a lot of pictures, lots of videos, lots of text messages. You go right ahead, Mama. You go right ahead. And they're like, nope, you can't touch anything. And so now she's going to call this forensic specialist expert to come in and just so she can touch her phone. But what she didn't realize is she's still not going to be able to touch her dang phone.